Hello there. Hold on a sec. What's going on? My bad there. Hello and welcome to Trial TV Live. I am the Squeegee of Justice, and we just did an unveiling and unboxing of Slim Pickens there. So thank you for joining us for that. That was a members only. That was fun. Thank you again to Therapist You Know, Pammy, and Sinbad. And I was corrected. That is not real bones. They're medical. Those are medical bones. They're not real bones. So, but we will put Slim Pickens there together over the course of this week, and we will do an unveiling again for those that. Well, the unboxing was members only, but the unveiling we'll do later in the week. So, how's everybody doing today? How was your weekend? Who's with us? Ruby, hello to you. Thank you for joining us. Brat and Gerviel, good to see you. Shirley Roth, Therapist You Know, Green-Eyed Cat, Lily Wayne, Widespread Panic. I'm glad no humans were harmed for Slim Pickens to exist, right? Thank you all for joining us today. Julie Schwartz, Lily Wayne, Cleverly Twisted, Terry H. Good to see you guys. Thank you so much, Golden Girl. Only Fan. Appreciate you guys joining us. So we are continuing our coverage of Michigan versus Christopher Schurr. They are 30-minute delayed, and they are in court. They started, let's see, Judge Mims called court into session at 9:07, so that would be 9:37. Jury comes in at 9:11. So we still have about 15 minutes to go over what we have seen so far. Let me just hope everybody had a good weekend. So let's see. So the state has rested, as we know. The defense has been on since day 3, 4, 5, and now 6. So this will be their 4th day of testimony. We heard from Christopher Schurr on Friday, day 5. That was pretty big. We also heard from a David Blake, and then also Louis Van Kleem. He was director at Force Science. And then we heard from David Blake, police practices and human consultant. Hey, Mike, how are you? Good to see you. Let's see. I'm back. I keep getting called away. Told about 2 new lambs being born by 2 kids who are now live farming. Very cool. Awesome. So name it Smelly Bones. We had we had 16 names, Kathy, that we had to go through. Not had to, but we did like a round robin NCAA type tournament type, and we had 16 names, and we whittled them down to 4, and then we had the final, and Slim Pickens was the one. All right. Let me get my, sorry. Let's see. Wait, Shirley Roth. Lily Wayne, we all freaked out. What do you mean, real bones under your bed? What? Hold on. What's Lily saying? I gotta go back and, Super Bowl. Super Bowl was she participated. She supervised. She was my little supervisor. Super Bowl the supervisor. Hey, Krista J, how are you? Thank you for joining us. Curviel, you were sick, so someone else has been manning the cameras. Oh, that stinks. I did. I thought you sent real human bones. I thought those are real human bones. Apparently not. Yeah, I honestly thought those were real human bones. Widespread panic. You still have your dead father under your bed. Siblings and I haven't been able to get together all at once for scattering the ashes. Yeah, we have ashes. We have ashes of our two Jacks, our two boys, Iggy and Sagan. I have my mom's ashes. Erin has her mother, grandfather, and grandmother. I did need to wash my hands. Wait, there was a huge letdown? No. Oh, that they're not real bones? I'm kind of glad they're not. It makes me feel a little bit better. Well, to be fair, Baka, the wrapping like underneath was really, really dirty. I mean, it did come from somewhat far away, so it collected some dust. So, did I give the boxes to the cats? Not yet. It's full of like wrapping paper and stuffing and stuff like that, so I haven't quite given it to them yet. But two come. Yep, two come. There's. Oh, you know what? Here, I can move Slim over here a little bit. We can do that. You can at least get that far. And I know this is the last thing that goes on, but let's see. All right, we can we can at least get that far. He's just kind of hanging, chilling. That's my bud. If you have no idea what's going on and you just pop into this channel, you're going to be like, what the heck? Hey, Shore Life. Good to see you. Yeah, bone dust, right? Slim is replacing guitars. Yeah. He's still, well, you know, I still got guitars over here. Let's see if we can do this. We'll have him. We'll have him playing guitars. I have to get him inflatable guitars, right? Oh, that's funny. Yes, we can get an inflatable guitar. He might have a headache sitting like that all day. Yeah, Slim will be playing guitar soon. That's funny. Hey, Wendy, happy Monday to you. Thank you for joining us. Hope you had a good one. Let's see, live trial will be starting in 10 minutes. When did they go? When did they kick in? 9:07 they kicked in. So, yeah, 10 more minutes. Live trial will be starting in 10 minutes. So let's see. So we left with Mr. Van Kleem. Did he have cross? Oh, yeah. No, he definitely had cross. And we had a couple votes there. What grade would you give D.A. Becker in his cross technique? 49% of you gave him a D. So you guys did not like his crossing. 26% gave him a C. 15% gave him a B. And only 9% out of 53 votes gave Mr. Becker, D.A. Becker, an A for his cross-examined technique. Let's see here. Mr. Kleem. Let's see. He was our last witness on Friday. And I thought he was a pretty good witness. I thought he came across as credible. Hey, Hellcat, good to see you. Jenny, when I heard his name, I thought you said Mr. Clean. Yeah, it was funny, right? Because he did kind of, with his hairstyle. But yeah, Kleem. I think that's how you say it. It's or climb. Maybe it's Kliem. It could be climb. Could be climb. Could be clean. It's probably climb. But hey, Julie, how are you? Good to see you. And Hellcat, thank you for joining us. Wendy, I would like to announce I've now been 50 revolutions around the sun as of 5:30 this morning. There was a time I didn't think I would see 50 years old. Aw, fantastic. Well, happy Sun Revolution to you, Wendy. Thank you for letting us know. Yeah, Mr. Clean. He does kind of look like Mr. Clean, too. Should I say Climb instead, Mr. Climb? I could say Mr. Climb. Mr. Clean, Mr. Climb. Yes, happy birthday to you. Everybody's saying happy birthday to you. As of 5:30. Awesome. Let me just check here. Let's see if they've got... no. Just checking the other feeds. I like that other feed. They're not live yet, but I did like that other feed that I found, Channel 3. They were pretty... they didn't have the talking heads. This other one that I'm following, Channel 13, is... they tend to talk over the judge. I don't know. Hey, you Hellcat. How are you? Good to see you. Aw, thank you. Thank you all for the birthday wishes. I love you guys. We love you too, Wendy. Thank you for letting us know and celebrating your day with us. Hey, Drunky, how are you? Thank you for joining us. Good to see you. Hope you had a good weekend. I know it's early for you. Therapist, you know, saying happy birthday. Green-eyed cat, Baka. Oh, Jeff is with us. Jeff Taylor, good morning to you. Appreciate you guys spending your day with us as we hit day 6 of Michigan versus Christopher Schurr, or Chris Schurr, I guess he goes by. But yeah, so we've got about another 5 minutes before they kick in. Hey, Ohio Jen, how are you? Thank you for joining us. Alice saying happy birthday to Wendy. And yes, this is an intense trial, as we found out, as we have been finding out. So we appreciate you guys being respectful and courteous to each other. We have difference of opinions, and I'm sure it will get more heated as we get closer to the verdict. So I just ask that we just maintain our, what we've been doing for the last 5 days. You guys have been really good. So thank you for that. Aw, Wendy, spending the day with you guys is a great birthday. Shucks, y'all are the best. Aw, thank you, Wendy. Appreciate that. And Ruby, also great to see you. Thank you for joining us today. Let's see. Bach, I'm not even sure what what all that means. Golden Girl, good morning to you. Thank you for joining us. Good afternoon, good evening, wherever you may be. So we're about 5 minutes away from live court kicking in. And it looks like, not giving any spoilers, but this isn't really a spoiler, but it does look like Mr. Klein will be on the stand again. He was on stand. He was on the stand Friday, so they have him back on. Let's see. Oh, that's you trying to be good? Nice. Let's see. Junkie, you missed the unboxing? Yeah, well, we are going to put it together. We're going to put Slim there old Slim Boy. We're going to put him together, and I'll record that, and then we'll do an unveiling again, later in the week. I don't know how long I'm not sure when I'll get to that. Some point this week, certainly the weekend for sure. But I'll take a stab at it tonight. See how easy it is to put together. All right, Tammy, thank you for joining us, and enjoy your stream over there. Oh, it'll take less than an hour? Okay, that's cool. That's good to know. Thank you, therapist. How's Mama Cat? She's okay. She's outside. She slept with us last night. She's been spending a lot more time inside, which is nice. Yeah, she's doing good, Jenny. Thank you for asking. She's, I think, 5 weeks in now. She's got like 3 or 4 more weeks. I think it's like a 9-week term. So, yeah, she's just halfway, if not over halfway. So, yep. Oh, yeah. Therapist, seriously, 6 screws, I think, maybe 5. All right. Is it a 2-person job? Or can I do it by myself and Aaron can record? Might be a 2-person job. Let me know if it's a 2-person job. Yay. Yay to Polly. Yeah, Shirley, Polly's going to be a mom. Yes, she is. You can do it by yourself. Okay, cool. Thank you. All right, so then I'll have maybe Aaron will record, or I'll just put my phone, and record it, and then I can do like a speed. We can speed it up, and then we'll post that. Just don't expect him to stand on his own. Okay, yeah, we'll have to get a stand, or I'll just have him sit. Right? Yes, Julie, that is a skeleton. That is Slim Pickens. We had an unboxing this morning, and that's from the dog park shooting trial we streamed in April, or is it March? I think in March. And we had, there's a whole backstory to that, and live court's going to kick in, so I'm going to pop over here now. Let's see. We'll pop in here. All right. So we had during that trial, Julie, there was a skeleton that they have, but it wasn't like real looking. It looked like more like Jack Skeleton, and so we're like, it's not real. I thought it was real. But I was, yes. Don't ask, don't tell. I thought it was real, but no, it is not real. Anyway, the prosecutor had this live skeleton, and he was showing how the bullet was shot. So we were like, name that skeleton. And therapist, just happened to have a skeleton in her closet. No, she had a skeleton kicking around the house there. And she, along with Pammy and Sinbad, helped pay for shipping, got it over to us. We had a whole round robin. We had 16 names. We whittled it down to 4, and Slim Pickens was the one that won out. So, all right. I'm gonna go here. All right, I'll see you guys on the other side.
Your Honor, we did file motions. I don't think this is now the time to argue them, but we want to make sure the court has received them. And if the court wants any additional argument on the motions, they'd like to put the question. Thank you. We'd like to look at the rest on our motions themselves, and we have a personal argument on those.
Okay. And I know there was a question that I did not place on the record that we discussed briefly that I should or could be question on the record, and those were jury questions that were not asked. And I believe specifically when the defendant was testifying. And I'm just trying to find that particular question. But aside from that, once I locate that, then I'll read it place it on the record. Because I do believe that questions that were not asked should be placed on the record. So what I'll do is just have it. Is the witness ready to retake the stand?
Yes, Your Honor.
And would either side like him sworn in again?
No, Your Honor.
Reminder's fine, Your Honor.
So you can retake the stand, and I'll remind you, sir, that you are still under oath.
Thank you, ma'am.
Writing.
Yes, ma'am.
And then we'll have the jurors come in. Welcome back. You may be seated. And once again, I'm glad to see all of you made it back. Mr. Becker, you may continue with your cross-examination.
Thank you, Your Honor. Like I said, not a whole lot of additional questions, but I do want to get at a few things. One of the things you talked about, though, on your direct exam is that you have kind of a network of experts you rely on, because I think one of the questions was Mr. Stoughton or Professor Stoughton and Mr. Bloomfield were not part of your network. Is that a fair statement?
Yes, sir.
Now, when terms of, obviously you get hired as an expert, you're retained to provide testimony, correct?
Yes, sir.
When you give a defendant access to the expert, do you get compensated for that as well?
No,
Is it
sir.
on top of, you get paid for this, do you get paid for
No.
giving them access to these other experts?
No, we don't charge a referral fee in our process, no.
But Mr. Bartel would be part of your network, if you will.
Yes, we would reach out to Mr. Bartel if his CV supported the need, yes.
And Mr. Blake would be part of your network as well.
I don't know that we've ever used Mr. Blake, but I would certainly consider his CV if we needed it, yes.
What about Dr. Kroll? Is Dr. Kroll part of your network?
Dr. Kroll is, yes.
Okay. So in terms of, in this case, did you facilitate, did you reach out to them to say, hey, I got a case for you, kind of?
No.
Okay. But that you provided that information to the defense so they could reach out for this case?
I don't know, I think they had already found them in this case. I don't know that I actually referred them in this particular case.
We talked a little bit about the International Chiefs of Police and the foot pursuit policy.
Yes, sir.
And then, like you said, it's not mandatory, it's adopted, correct?
Right, just to be clear, the foot pursuit considerations paper, I couldn't find an IACP foot pursuit model policy. What I saw was the second resource, which is a considerations paper, but I think that's what you referred to.
But in that considerations paper, they talk about foot pursuits are inherently dangerous, right?
They are, yes.
Do you disagree with that?
No.
One of the things they said, decision to pursue a fleeing suspect should not be regarded as required or even prudent in all circumstances. Do you disagree with that?
I do not disagree with that.
It all depends on the seriousness of the offense, the totality of the circumstances. That's what they talk about, correct?
Yes, sir.
And in terms of, people flee the police for all kinds of reasons, right?
They do.
Some people flee because they curfew violation to a serious felony offense, right?
Yes, sir.
And one of the things, I think it was Eric Heim, the podcast you talked about. Do you recall talking about sometimes innocent people are the most difficult people to deal with because they know you're innocent, you're still trying to figure that out, right?
Yes.
So when you're looking at a chase, it's based on the totality of the circumstances. You would never recommend a single officer chasing 4 armed suspects down a dark alley, would you?
Well, if you're talking about the 2 different types of chases, I think we may have discussed chase to pursue or chase to contain or chase to capture. It wouldn't be unusual to chase 4 people. It might be unusual to try to capture them all simultaneously.
So chase to contain is part of the thing. You chase and you're keeping an eye on subjects and calling for backup and trying to get, establish a perimeter, right?
Yes.
All right. We've talked about it, I don't know if you were here, but just the CLIA, just for the record, Commission on Accreditation for Law Enforcement Agencies. You're familiar with that?
I am, yes, sir.
And that's kind of we've heard it, that's the gold standard, if you will.
That's their marketing slogan. I don't know that they're considered the gold standard universally. There's many organizations that do what they do, but I think their marketing slogan is they're the gold standard, yes.
Okay. And it's all, I think we heard that only like 5% of law enforcement agencies ballpark are CLIA accredited.
Yeah, I don't know the percentage.
Okay. But Grand Rapids is CLIA accredited.
They are, yes.
And you're not faulting. I mean, it's a good thing to have accreditation, right?
Yes.
And one of the things that CLIA does is they take a look at comprehensive and uniform written directives that clearly define authority, performance, and responsibilities. That's one of the criteria CLIA uses when they look at a department, right?
Okay, I'm sorry, I did miss that. We say that again.
They look at, is there a comprehensive and uniform written directives that clearly define authority, performance, and responsibilities? That's one of the criteria.
I don't know the CLIAs in front of me. I would take your word for it if that's one of their written criteria, yes.
And part of how they do that, though, is they bring in people from departments from all across the country, right? To look at the policies of the specific department.
I don't know that that's their policy, no.
You don't know
or
how
process.
it's done? You don't know the process of CLIA?
I know the process of CLIA, the evaluation model, sometimes just a couple of people that have been hired by CLIA, and they would be regional representatives, so I don't know how many or where they get. Typically, I know of one regional representative that will work with the agency. You've listed I think your broader question is, do they pull in people from across the country? I don't know that they do that.
Okay. But part of the policy that you cite, though, the policy that's taken a look at, is Grand Rapids policy bases the reasonable of any use of force is ordinarily judged on the totality of the circumstances, i.e. based on all of the circumstances. That's clearly Grand Rapids policy.
Correct, yes.
Thank you. I have nothing further, Your Honor.
Thank you.
Good morning, Mr. Clean.
Good morning.
On Friday, you were asked some questions about who Force Science has consulted with in this case. And you previously testified you've consulted with defendants, students, community members, and prosecutors. Has the prosecutor's office in this case ever consulted with Force Science?
Yes.
And are you aware of whether the Michigan State Police investigators that are involved in this case has ever attended a Force Science course?
Yes.
Do you recall when approximately we retained Force Science?
I believe ultimately it was September of 2022.
Have you ever met with or talked with Officer Schurr about this case?
No.
Did you have any part in preparing Officer Schurr for his statement?
No.
Thank you.
Just one question. We never consulted with you on this case.
Not on this case, no.
There's been years in the past.
Yes, I think there was maybe just 2 in the past, 2017 timeframe.
Thank you.
Nothing further, Your Honor.
We see a couple of questions on the agenda, so I'll have my clerk wrap those for you.
So they're at a sidebar, I'm assuming. Yeah, how many more witnesses? Oh, a Hawaiian shirt and sunglasses. Parrot on his shoulder. Lily Wayne, we don't know yet about any more witnesses. We don't know. We gotta wait and see. We're in a wait and see pattern.
To clarify, your opinion is based from you looking at everything, videos, audio, reports, autopsy, testimonial, and then human factors, or the other way around?
So we would start with the first. So we would look at the facts of the case, the evidence in the case that was available at the time. So that would be the videos, that would be the audio. And then when we're taking that and we're trying to evaluate the officer's decision-making and performance, that's when we consider the human performance aspects.
All right, and next, when you got drives done in your head, how long approximately did it take to recuperate?
Well, once I realized that I was okay, it was probably less than 30 seconds. I think the initial shock of it probably took more time than the recovery did.
And then next, if the subject didn't have full control of the taser during the time deadly force was used, would you still consider it a reasonable action? Or is this what makes it reasonable?
Yeah, it's again, the standard I'm using is, could a person in the officer's position, knowing what they knew, reasonably believe? And so we don't look at actual threat, we look at apparent threat based on the available information to the officer. So if we later learned that if the officer reasonably believed he had full control, and later learned that he didn't because we could watch a video or do a still shot, we analyze the case based on the apparent threat from the perception of the officer at the time, not what we would later learn. I'll just stop there. I think that answered it.
Any follow-up from that, Ms. Hamilton?
No, Your Honor.
No, Your Honor.
And I don't see any other hands raised from the jury. May this witness be excused? Ms. Hamilton?
Yes, Your Honor.
Any interjection, Mr. Becker?
And no question, Your Honor.
Thank you very much, sir. You are excused.
Thank you, ma'am.
And defense, you may call your next witness.
The defense rests, Your Honor.
And Mr. Becker, are you prepared to put on any rebuttal evidence?
We do have one brief rebuttal witness, Your Honor.
Okay, you may call that witness.
I'll detect that you agree with.
And since you were sworn previously, I'm not going to have you re-sworn, but I am going to remind you that you are still under oath.
Yes, Your Honor.
Thank you. Whenever you're ready.
Detective, going through, I want to get into one of the things you do is obviously you try and get a statement from the defendant in any cases like this, correct?
Yes, I do.
Let the record reflect that I'm showing opposing counsel exhibits 37, 38, people's exhibits. Detective, I'm going to show you what has been marked as Exhibit 37 for identification purposes. Can you tell the jury what that is?
I'm sorry to interrupt, but 37's already been admitted.
I'm sorry, I thought we had 36.
37 was already admitted.
Okay. Then I got to go 38 and 39.
And 37 was training record / outline. What it was.
Okay. So let's try Exhibit 38. Can you tell the jury what this is?
Yep, this is a typed written statement. It's 3 pages long. It's signed by Chris Schurr on April 15, 2022.
And how did you get this statement?
I requested through his defense. I believe Mr. Dodge facilitated getting this to my office.
Okay, and what you did is after you get this, you turn it over to our office as make it part of the case file, correct?
Yep, this becomes a part of my report.
And I'm going to show you Exhibit 39. Could you tell the jury what this is?
Yep. After that original statement, I, along with my colleagues, had a couple of follow-up questions. I numbered those out. I believe it was 13 specific follow-up questions. Purely voluntary, but I reached back out to Mr. Dodge and I asked if Officer Schurr would be willing to answer these follow-up questions, which he did. So this is, again, typed answers to those questions, signed by Chris Schurr on May 13 of 2022. It's 3 pages.
And once again, you made those part of the file as well?
Yes, I did.
I move the Admission Appeals Exhibits 38 and 39.
No, Your Honor.
Right, 38 and 39 are now admitted.
And just to be clear, there was not during an interview, this was just typed
Correct.
at some point in time away from you?
Yes.
There's one follow-up thing. Why is the state police investigating this? Happened in the city of Grand Rapids. Why is the state police on this?
Yeah, we have a formal agreement with the Grand Rapids Police Department. Again, I work for the Michigan State Police. And before my time and above my rank, a formal agreement was made with the PD that if they had an officer-involved shooting, that our department goes and investigates those. So really, I was there on invitation based on a formal agreement that was in place ahead of time.
Thank you. I have nothing further.
Morning, Detective.
Good morning, sir.
I just want to ask you some questions about the statement that was just admitted and the circumstances under which they were admitted, under which you obtained them. You touched briefly on this. Now, this was obviously a case that drew a lot of attention from the public. Is that fair?
Yes, it is.
And you were among several detectives that were working on this case?
Yes.
Okay. And you recognize that Christopher Schurr was under no obligation to give a statement, right?
No, this is purely voluntary.
Okay. And if you, in a normal case, went out to talk to somebody and said, we would like to talk to you, if they said, we don't want to talk to you, then you can't force them to talk to you, right?
No, and that carries no weight with me, the response.
Okay, but you were doing this investigation, there's a lot going on, and you wanted to hear from him, and you reached out to his attorneys, right?
Yes, I did.
Okay. And by that point, he had Mr. Dodge as counsel, right?
Yes.
And I think you said that the first statement was in April 15th of 2022?
Yes.
And that's something that was signed by the defendant?
Yes.
But came through his attorneys?
Yes, it was.
Okay. That's not an interview you had with him shortly after the incident or anything like that?
No, there was no interview.
And in a case like this where there's a shooting, you actually give the officer some time to reflect anyway, right? Before you would try to interview them, right?
That's standard. That's typical.
Okay. So you don't pounce on them like right after the shooting and start asking them questions, right?
If they wanted to, I would not say no, but I've not had that experience with an officer before.
Okay. And then you got the statement, you asked some follow-up questions, and you actually wrote questions on the second statement that's dated May 13th. Is that fair?
Yes.
And again, it came through counsel, and to the best of their ability, you believe that you got some answers to the questions you had?
Yes.
Okay. But that's not everything that you might have wanted to ask Officer Schurr, right?
No, sometimes when I'm interviewing somebody, those interviews can go on for hours and hours and hours. This was, if I had to ask some pointing questions, it was a short list.
Okay. And so I think it's 13 questions. That's pales in comparison to the number of questions that he could be asked on, say, like cross-examination, right?
Yes.
Okay, thank you.
No, Your Honor.
I don't see any hands raised on the jury. If you step down again.
You may, Your Honor.
Any objection?
No, Your Honor.
Thank you very much. You may step down. Any additional?
No additional rebuttal, Your Honor.
All right, so I would like to take a break because it looks like the evidence is complete, but we need to go over some things outside of your presence prior to closing arguments. And so I'm going to ask you to go into the back and we'll take a 15-minute break right now. And meanwhile, even though all the evidence is finished, you're not deliberating yet, so I'm going to ask you to still leave your notes and not discuss the case amongst yourselves or with anyone else, and also continue to refrain from any news reports in the media and social media, and then we'll see you back in about 15 minutes. You may be seated. Did my law clerk provide you with a set of the final instructions?
Yes, sir. I
Yes, sir.
One on Friday. And we sent over some proposed additions, changes.
I would like to take a break and go in the back to discuss anything that we can discuss as far as hashing out the instructions. I also noted that on the expert witness instruction 5.10, there's several experts that are missing and some that their expertise is misstated. So I'm correcting that particular instruction. But if you want to come in the back and make sure that they're complete, and if there's any objections, we can do that when we come back on the record.
Okay, so are you saying that we don't have the final instructions yet?
I'm saying, my law clerk provided you with the final instructions. I noted that there's some things that need to be inserted. I don't have the, Ms. Hamilton mentioned that they sent over, that you sent something over, I don't know if there were corrections or objections. Either way, I haven't seen those. If they were sent over the weekend or this morning, I have not seen those. So I would like the opportunity to review those before saying these are the absolute final set of instructions.
Okay, Your Honor.
Okay? And then I did know that there were a couple that were missing, so, but I would like the opportunity to address any additions and that sort of thing without having it a long, dragged out discussion on record about them. But if you don't want to, that's fine. I just thought it would.
Whatever you work first.
I just thought it would be easier.
Just one thing here, you didn't ask at least one question, you want to put that on the record before we forget?
Thank you for reminding me about that. So I did want to put the questions that were presented by the jury but not asked of the defendant, and then this particular witness that just stepped down, there were two questions that were not asked of him. As far as the defendant, there was a question by one of the jurors that we did not ask him, which is, and that's after discussing at a sidebar, and that is, has your wife ever asked you to get something from a different area of your house? When you don't find it, does she take your word for it, or does she go check herself? That was not asked. Also, did you speak to anyone about the incident between April 2nd and when the statement was submitted? That was not asked. Also not asked is, did anyone offer their suggestions or advice on how to write the statement? So those were questions that were not asked of the defendant because they were found not to be appropriate to do so. And then of this particular witness, there were two questions that were not asked. The first is, can you explain your thought on bodycam from Becker's reference? That was not asked. And then, have you ever testified in a case for the prosecution where the police officer was found guilty? If so, how many? That was also not asked. And I believe those are all the questions that needed to be placed on the record that were from the jury, not asked, but needed to still be placed on the record. I do have all of the jury questions, and I've noted with an X the ones that were not asked, and a check mark the ones that were. So that will be part of the file. And is there anything else before we recess briefly to go over these instructions?
Nothing, Your Honor. No, Your Honor.
So we'll recess briefly while that happens.
Rise, please.
Yeah, that was really weird, right? Has your wife ever asked you to get something from another part of the house, and do you believe her or go get it? Something along those lines. I missed the second question, and then there was, can you explain your thoughts on body cam from Becker's perspective? Oh. And then, have you ever been on a case where law enforcement was found guilty? No. I don't know. Odd questions. All right, so defense has rested. State did a rebuttal. Let's get to it. So the defense at the very top of the hour, or top of the broadcast, defense filed motion. This is not the time to argue them. Then she talks about jury questions not asked. She gets that on the record. Then Louis von Kleim comes back up, and basically foot pursuits are inherently dangerous. He agrees to that. He talks about pursue, contain, and capture, the difference between those. Then redirect was GRPD has attended his classes, which we found, we knew that on Friday. Hey, Missy, yeah, defense rested, state had a rebuttal, and then that's it. So, yeah, that's what you missed. A lot happened in half an hour, basically. Let's see, the rebuttal was, he had a couple jury questions. Your opinion is looked at everything or the other way around. I messed that one up. The one I did get was when you got dry stunned on your head, how long did it take you to recuperate? And he said once he figured out that he was okay, it only took a few minutes to be okay. And then if the subject didn't have full control of the taser, would you still consider a reasonable action? He's like, well, a person reasonably could believe, he says, we look at the apparent threat, not the actual threat. Thought that was kind of odd, but I don't know. All right, and then Detective Aaron Terbergen got up again, and they basically just, there was a statement that Officer Schurr had put in the day after, and then a month later he did 13 follow-up questions, and these were typed questions coming back in. And because he's Michigan State Police, they investigate anytime there's an officer-involved shooting. They come in and they investigate. All right, so that concludes all of that. So I guess jury instructions and then closing arguments. So it's all happening right now. It's all happening. Let me see if I can get another feed. Why do they not have this feed? Yeah, it's weird. Some channels are not playing this. You would think that they would, but yeah, just that one. All right. All right, so should we do a poll? Should we do some polls here? Let's see. We can do a series of polls. We'll do the first one. Let's see. Start a poll. Did the state meet their burden of proof? And is Schurr guilty, not guilty? Met burden. Oh, not border. Met their burden. Met their burden. Burden of proof. Okay, so did the state meet their burden of proof and is Schurr guilty or not guilty? So guilty, met their burden, not guilty. Did not meet the burden. All right. All right, we'll start with this one. All right. Poll-a-thon, yes, exactly. So new poll. So did the state, first one is, did the state meet their burden of proof? And is Schurr guilty or is he not guilty? So if they met their burden of proof, you feel he's guilty. If you feel they did not meet their burden of proof, then he's not guilty. So did they meet their burden of proof? And their burden of proof was that Patrick is no longer with us. So that one's the easy one. The second one was an intended, and then was it justified? So did they meet it? Did they meet it? So that he caused the passing of Patrick, it was intended, and that it was not justified. Those are the three that they have to meet. There may be another one. Oh, so okay, so A, that Patrick is no longer with us. B, it was caused by Schurr. Those two they can meet. Then it was the intent. And was it justified? So 24 votes, 51 watching. So if you guys want to, the first two, yes, Patrick's no longer with us, and yes, it was caused by Schurr. Those two, obviously, nobody's denying that or arguing that. It's the intent and then justified. So was it justified? That's yep. Pull-a-thon, yes. All right. Yeah, it's going to be a tough one. This is going to be a tough verdict. I'm not going to be like happy, I think, with either one. I don't think this is going to be it's going to be one of those verdicts where I'm just like, ugh. Either way it goes, it's not going to feel good about it, you know. Terry H., surprised at the poll results. Yeah, right now we're just asking if the state met their burden. We're not asking for personal opinions. We're not asking for, well, I guess we kind of are. Well, no, just go by the facts. That's truly what the point of that for me. I was trying to just go by the facts, go by the evidence. Did they actually prove, did the state prove that Christopher Schurr intended, deliberately, justifiably, did he do it? Or did he not do it? That's the big one. Was it justified? Did they prove that it was justified? Right? If I'm reading this correctly. First of all, it's you know, someone's no longer with us. That one we know for sure. The second one was, yes, it was caused by Schurr. That one we know. Third part of it is the intent to do it, and then fourth is justified or excused. So widespread, I think it'll come down to the question of whether the jury feels that his training justifies his actions. That's what it is for me. That's exactly where it lands for me. Did his training nice. So Aaron's putting together slim pickings. Oh, and Rafa is helping.
Sorry.
Nice. So we'll post these for you guys. Aaron's putting together slim pickings right now, and our QA team has joined the project, so we'll post those for you guys of Rafa helping. He's so cute. There's one where he's like looking up. Is he trying to eat it? Is he trying to eat the bones? Is he gnawing on the bones? Here, you know what? Let me see. I can show you real quick here's one. All right, I'll show you guys this one. This one's cute. We'll post more of these, but this is cute. Let's check this one out, you guys. Let's see, desktop. Let's see. All right, hold on. Oh my goodness, hold on. Let me find this. Okay, hold on. So here's here's Rafa helping Aaron put together. Sorry, let me get this. All right. Oh, nope, not that, Chris. This. There. There's Rafa helping. Hi. So that's Rafa helping Aaron put it together. And here's Super Ball being all cute. Hi. Yeah, it's a good girl. So that's Rafa trying to help. We'll post more pictures, but that's pretty funny. Let's see. Is Rafa baby daddy? No, we don't think so. 13th juror, a little behind. Who's the rebuttal witness? It was Detective Aaron Turbigan. He testified already. He was in day... when was he? When was he? Oh, he was day 1. He was the 7th. Overall, he was on day 1. He was the 7th witness. He was the lead detective, 13th juror. Definitely needs a Speedo for that pelvis. Nice. Super Ball is. Yep, she's being super cute right now. She's flopping around over here. Oh, it's a good girl. She's being very, very cute as she bites me. Yeah, it's a good girl. Sweet little girl. So no, Rafa is not the baby daddy. That would be really cool, right? That would be really cool, but he tried, we think, but he didn't quite know what to do. He's like 3 or 4, maybe 3 weeks younger than Paulie, so he tried. Are you going to have the pregnant one fixed after kittens? Yeah, we wanted to beforehand, but she caught us before. She went into heat before we could get her fixed. But yes, we are definitely going to get her fixed. And OnlyFan is correct. 13th juror, it was just to submit the defendant's statement. So he had 2 statements. Schurr had 2 statements. One, I think, was already admitted. It was the second, I think, OnlyFan, if I heard it correctly. So there was one statement that was the day after. It was April 5th. And then there was one that was May 13th, so a month and 6 weeks later or so, that there was 13 follow-up questions. So that's what they got in. So, no Speedos. See, Father, fun fact, cats can have multiple baby daddies, yep, depending on how close they get hit. That is true. How old are kittens? Rafa and Paulie. Paulie we saw first, and that would have been in June. Middle to end of June we saw her, and then Rafa was like a week or 2 later. They were very close to each other. So, but Paulie, I think, is a little bit older. She seems to be a little bit older. We need a due date squares board, right? There are still 3, but all male and belong to the neighbors. Nice. I have cleared whole blocks of strays, getting them fixed till I ran out of money. Yeah. When we were down south, closer to West Palm, there was feral cats all over the place, and that's where Super Ball came from, and that's where we took care of a couple of ferals, and one of them got fixed by somebody else, and we were able to capture Super Ball. We got her fixed. But yeah, it's a problem. It's an issue, I suppose. It could be a problem. But they were all over the place. There was a lot, and I'd say maybe half of them were fixed. Hey, Nanar, how are you? But where we are now, we do not have to deal with them all over the place. But Paulie found somebody and she got pregnant, so it's clear there's another cat floating around close enough that she was able to get herself pregnant. So Oh, Ruby, you're Pinky Lemonade? Oh, I didn't know that. Oh, how cool. I had no idea. So they're about, let's see, what are we into May? They're probably very close to being born in the next, like, 2 weeks or so. It's really funny because probably Polly's birthing of her kittens are going to be very close to when she was born, but a year later. It's really interesting, right? Jenny, I have a dog with 2 baby daddies about 30 years ago. Oh, you had a dog. Wow, she was a chow lab mix. There were 2 dogs in our area of the woods. One was a Rottie and one was a Shepherd, so they came out half and half. Nice. Hey, Run with Scissors, good to see you. She fell pregnant. Kathy, a mother stray dropped her babies on my porch and took off. They cost a lot to feed, but I love animals. Yeah. Well, we're definitely getting everybody fixed after this round. We can't afford, we can't afford 20 kittens. Plus, they're just going to run. There's a relatively busy street. I can't even. It's enough for me to panic with Polly because who knows what she does. Rafa, pretty sure he never goes over there. Polly, we've seen. I think I saw her go over once, so I can't imagine. So we're going to get them fixed. We'll get Polly and Rafa fixed. Hopefully next month we can get Rafa fixed. We got to really sort that out soon. All right, guys. So there is a poll for those that haven't voted yet. 34 votes. Did the state meet their burden of proof and is Schurr guilty or not guilty? So this is just based on the evidence. This isn't what you feel in your heart or what you would do. This is just based on the evidence. Did the state meet their burden? And the burden was prove that Patrick is no longer with us, that they can prove that Officer Schurr did it, that they can prove the intent, and then prove was it justified. Those are the things. Are we concerned about Super Bowl going into heat? We shouldn't, right? We've been with her now since 2019, and she was fixed in 2019, so she's never have done that. Jenny, that's the issue. Do you have a spay neuter clinic? Yeah, we have one here that does it like $40. No. Down south we had one. They did it for free. All you had to do it was Peggy Adams. All you had to do was just take them over there, and they would do it. They would accept donations, but no, here it's like 150 or something like that. The one that's closest to us in town, it's like I think it's 150. Then there's one that is more of like a donations thing, but that's like a half hour away, and I don't know. We probably just won't. Oh, yeah, widespread. Yeah, no. We got her fixed. She was pretty young. She just barely was just hit the weight because I took her in and they called us and said that she just barely made it, like ounces, like an ounce. Otherwise, they wouldn't have done it. So we would have had to taken her back. So. Green Eye Cat, to me, it was intentional for sure. It wasn't an accident. I would agree with that. He admitted it was lethal force, but I guess you can debate the justified issue. Yeah, that's what the jury's going to have to decide ultimately. Was it justified and did it fit his training? I think it's going to boil back down to his training. He was trained to do this, just like a soldier. Just like they said, one witness said, I forget who it was, but it's like a football player. You don't tell a football player to tackle gently. They're trained to do that. Unfortunately, that's where maybe that's where we need to rethink some of our policies. But then if he didn't and Patrick rolled around and shot him, then we'd be having that conversation of like, now an officer decided not to do what they were trained to do, and then they end up, no longer being with us. So it stinks. I mean, it just stinks all the way around. Lily Wayne, are you going to live stream the birth? We're going to try, as best as we can. We've been taking videos. We've been posting. We posted one video, and as that's what they did. And then our pizza guy, he said that they had kittens, and the raccoon ate those kittens too. I mean, it's just, ugh. That's just disgusting, right? Kathy says Schurr should be found not guilty since he had no partner or backup. Interesting. I don't know if that would... I don't know. He didn't say that. He didn't put that in his defense. So I don't know if we can say that or not. Let's see. Jenny, did she do the funny meows and rolling around? Oh, yeah. She was... Oh, yeah. And Rafa would get on top of her and bite her, but that's about it. He didn't know what else to do. But oh yeah, no, yep, butt up in the air and yeah. Normally she just kind of squeaks. She's more like just like meow, meow. But she was giving out some serious meows for sure. Nanar, my Katie's birthday is May 7th. She was born in 2019. I got her a couple weeks later. Nice, yeah. That's when Super Ball was born. But she was born, we think, in April. We think April 15th was her birthday of 2019. And then we think Rafa and Polly's are like May, because we saw them at the end of June, mid to end of June, and they were probably about 6 weeks, 5-6 weeks old. So we're thinking they were probably born like now, like pretty much now, yeah.
He's approved the assembly.
Oh, I see. Okay. Nice. All right. All right. Let's see. Father, they say to keep them inside 2 to 3 weeks before due date, so she makes nest inside. We have a box and a towel. She's been sleeping in our bed a lot. So yeah, maybe she'll give birth on our bed. I don't know. Nowhere here will any longer take cats. They are packed full. Yeah, Father, we're trying to make a nest for her inside. We hope that she does it inside, obviously, because there are dogs and coyotes and bobcat. I saw a bobcat once in our backyard. That's why we thought Polly was a bobcat, because she looked just like a bobcat. Nanar, I was late. Are they done, and did they do closing arguments? Not yet. Not yet. They haven't done jury instructions or closing arguments yet. Everybody's rested, but they're hashing things out. Terry H., your cat gave birth on you in bed. Wow. Yeah, it wouldn't surprise me if she gives birth on the bed. That's where she tends to go. Jenny, I had one sneak into our bathroom closet to have her kittens. Father, I wish you luck. I know how hard it can be. All right. All right, I think at lunch. Okay, at lunchtime. I'll do it at lunch. All right, at lunchtime, Aaron has put together Slim Pickens. So at lunchtime, I will bring him over and we'll do an unveiling at lunchtime. So Slim Pickens unveiling at lunchtime. So announcement, Slim Pickens unveiling at lunchtime. Hear ye, hear ye. Slim Pickens unveiling at lunchtime. It's her first time. She's gonna be just confused and scared as you guys are. Follow will be out at lunchtime. Yes, Jenny. Way to go, Erin. She did do it fast. Kathy says, I had a bottle-fed dog give birth between my legs in bed. I told hubby, I know I have slept with dogs, but this is ridiculous. When I was a kid growing up, we had a collie that my brother found in our backwoods, and she ended up getting pregnant 3 times. She had three sets of litters. So as a kid, like, right, I'm 7, 8, 9, 10, 11, 12. It was pretty cool to see her give birth, and, you know. Yeah, 13th juror. This jury is so wild with their questions. I know, right? OnlyFan, 13th juror outright troll questions. That was pretty weird, that one. Has your wife ever asked you to get something from another part of the house, and do you believe her or go get it? That's what I was able to find. Oh, you have an appointment at 1:30? Oh. All right. Do it at the end. We'll do it at the end. How about that? Follow, we'll do it at the end then. We'll do it at the end of the thing. Unveiling of Slim Pickens at the end of this stream. There. We'll do it at the end. How about that? And that way people that are watching the other trial will come in, because that they end at like 4 or something, right? So I'll do it afterwards. We'll do it afterwards because I want people like Pammy, she and Sinbad, they helped Therapist with the shipping. So let's see. No, Father, I think it's better. It's better because we'll have more people that were involved with it, you know? So, and I want you to be a part of it. Yes, we'll use that excuse. Jenny, I had one give birth on her couch unexpectedly, and the blood stain blended in with the pattern. Nice. Therapist, they don't play with shipping. My goodness. Baka says, your daughter is starting an egg factory, incubating eggs. Will be great fun for our oldest little girl. Cool. Jenny, one of my mice just had babies. I came down to clean them, and they're new babies. Wow. Now let me just check with the live updates to see. Let's see. Recess is called at 9:23. 9. Okay. So they still haven't come back yet. Oh, wait a minute. I'm sorry. Okay, they have called back at 10:26. They came back in. So that's we have to wait a half hour after that. So we got about another 20 minutes or so to go. Let's see. So court is back in session, but they came back at 10:26. Wow, they took a long break. Oh, 9:29 to 10:26. That was almost an hour. Wow, they took almost an hour break. Let's see. Lily Wayne, how many kittens do people's cats usually have? Our last one had 5. I think from what I understand, the first 1 or 2, they only give like 1 or 2, right? The more they get pregnant, the more they give, I guess the more fertile they become. So I'm hoping that it's only 1 or 2. If it's 5, 1 or 2 is going to be an issue. 5 is going to be, yeah. So from what I hear, it's only 1 or 2. And then based on experience with Super Balls, her litter, there was 2 of them, and then Junior, who was born before her, there were 2. So the Super Ball's mother gave birth twice that we saw, and there was 2 and 2, and then I think she gave birth again, and I think there were 3 then, I think. So the first pregnancy, it seems like it's just like 1, I'm sorry, like 2. They just give birth to 2. Jenny, your cat had 8 on the first birth. Can vary 3 up to 9, but over 6 isn't as common. Oh, good Lord, you guys are scaring me. First litters are small. Thank you, Kathy. Thank you for that. Polly is tiny too. Polly and Rafa both are they're tiny. Or Super Ball's big. Or maybe both. But the Super Ball, I'm sorry, Polly and Rafa just seem like they're small. So whatever Polly does give birth to, I'm going to imagine they're going to be small as well, because she's pretty tiny. Like, I still keep thinking they're kittens, like they're still, compared to Super Ball, she's like a beast. Yeah, I agree. They shouldn't have the 30-minute delay. Yeah. Well, I think through closings they'll probably have the delay only fan, and then once we get into verdict watch, they'll take that away. Because closings, they could still say something that could be personal, show something, that kind of thing. Black and white cats tend to be larger breeds. Interesting. I had a ginger cat. He was pretty big. He was a big boy. And then Super Ball's mother gave birth to 2 gingers, and one was pretty big, one we called Tiny. And then she gave birth again to another ginger, and then to Super Ball, and he was about as big as her. He was a little bit smaller. She definitely tended to be bigger. She was like the biggest one. Cheryl, if you have an orange and white cat that is huge, I know, right? Like, think of Morris. It's cute that they're tiny. I love the fact that they're like little kittens still. Widespread. Yeah, one of the ferals I took in had only 1 kitten in her first litter, or just 1 who survived. Yeah, her second litter was the 3 we took in. First kitten lives in our backyard. Cheryl, your tuxedo cat is much bigger than your other cat. Yeah, Super Ball is like a marshmallow. We call her Big Marshmallow. She just she bullies the other 2, but it's still her house. She's still not quite willing to to reside with them. Now we're going to have another kitten that she's going to have to deal with. Oh my. Nanar, that explains my tuxedo cat. She's bigger cat, not very, but still big. Oh, are you kidding? Closing arguments. Hate when they do this. All right. Looks like we have closing arguments, guys.
Oh, we are getting calloused. And callousing is the fact that how many times do we watch a video of another person, Patrick, dying over and over and over again? It wasn't TV. It's not movies. This is a real man, a human being, who was shot in the back of the head back in April of 2022. We watch it over and over. He's got a family. He's got loved ones. So I hope we're not callous. It's just something we see because we somewhat get immune to somebody dying over and over and over again. And we try and take a rational kind of look at it. And I think the other thing, when you look at it, it's a serious crime, but it's got one of the more simple elements, if you will. Because it boils down to just a few elements. There's a lot of the crimes you're not aware of, but elements are what we have to prove beyond a reasonable doubt. And so when it starts off, we talked about over and over again, this is the first element. Patrick died because of a gunshot wound to the head that the defendant did to him. And so the other part is, yes, this is also about him, about what he did. Because Patrick is no saint. I'm not going to sit here and argue Patrick was a saint. He was drunk driving. He was resisting. He was driving without a driver's license. None of those are executable offenses. There are ways ways to deal with it. It's just because he committed a felony, he could commit 20 felonies, he could have had other felonies. It doesn't mean he deserved to die, or he has to die. That's for juries, that's for other things down the road. The other thing is, yeah, I'm not gonna sit here and say he's a horrible person. Yeah, he's got a great family. We heard about how he's an All-American, grew up in Grand Rapids. Yeah, that's wonderful. That's great. It's also fairly irrelevant. Because you don't compare, okay, one's good, one's bad, they'll just throw it up there. You have to base the case based on the facts. You'll hear from the judge that sympathy or prejudice shouldn't play any role in your decision. So you've got to base your decision on the facts that were here, the facts that were what the witnesses said, the videos, all the policies and procedures. That's what you have to base it on. Not, well, he's a hometown boy and want to do good, and we've got this bad guy who's drunk driving. It's not that simple. It is simple in terms of the elements, though. Clearly, the defendant killed Patrick back in April. And he had an intent to do so. Because part of the instruction you hear, there's maybe 3 different states of mind. But I'm going to stop at the first one. There was an intent to kill. And the intent to kill, please don't get wrapped up. Nobody's saying that when we left that morning that he intended to kill somebody. When he fired the shot, he intended to kill. That is clear when you put a bullet in the back of somebody's head. So in terms of the elements they have to prove, the first 2 are proven, no question in your mind. Those are the 2. Those are the easy ones. So what does it come down to? Why are we here? It's number 3. Number 3, was the killing justified or excused or reduced to a lesser crime? That is your decision. That is why you're here. And justified, I talked a little bit of cross the line clean. Words matter. And words matter in terms of, it matter, we're going to hear a lot of instructions, and sometimes jurors get wrapped up in terms of instructions that, this is the law, and we're in a courtroom, and somehow things change because you're in a courtroom. You don't lose your collective common sense. You'll hear that instruction from the judge. You have your own common sense, you have your experiences. The words that you use out there have the same meaning here. Justified, done for a good and a legitimate reason. Excused, removing something you had to do. You're excused from school. You have a duty to go to school. You're excused from school. You're removed. So what is the duty here? You have a duty not to kill somebody unless it's a really darn good reason. That's the duty you have here. That's the duty any of us have here. There's no difference between a police officer or a civilian. You can't take a life without a darn good reason. So when you start looking at that, when you start getting into the evidence, I think there's maybe also a little bit of confusion in terms of the law. What is the law? Okay? What is the law, and the law impacting the policy? Because you've heard that. There's, the policy of GRPD. You have to follow the law. Okay? The judge will tell you, your job is to follow the law policy, and what the policy is, in fact, may impact how you interpret the law and what happened here. But you have to follow the law. So the law on the left, the defendant must have honestly and reasonably, once again, words have meanings, honestly and reasonably. It can be 2 different things. You kind of think of the same thing, but you can have an honest belief, but it's not reasonable, right? There's a lot of people that believe that have an honest belief. We never landed on the moon. It was a big hoax. Nobody landed on the moon. We made it up. There's a sound stage somewhere in California that we made up a moon landing. It's an honest belief. Is it reasonable? So a lot of what depends on is what is reasonable. And what is reasonable is also defined. And there's 2, you'll see the same thing. You have the policy of GRPD is not vastly different from what the law is. You kind of take a look at the reasonable person under same or similar circumstances, looking at the totality of the circumstances, looking at everything that happened. What led up to that decision to fire that shot? You have to take in everything from the start to the finish. And it's got to be reasonable through the entire time. We've heard that testified to on a number of different occasions. So you have to, what is the reasonableness when you break it down? And once again, dealing with the facts. Dealing with the facts of what was presented here today, or here this week, that the time you're paying attention to. Well, maybe putting it another way, it was reasonable to shoot Patrick because he had the taser, he was outnumbered and exhausted. That's really the justification. That's the excuse. Okay? And that's an important thing because it's not that he pointed the taser. Nobody said that. The defendant took the stand, can't say that in a statement, never said he pointed the taser at me. He simply had the taser. That's it. The best we could get at was, well, maybe he was starting to turn and he thought he may be pointing at him. No evidence, no evidence, never said he threatened it, said he was going to use it, that I was going to kill you, said anything like that. He simply had the taser as one of the justifications of why I had to shoot. And the other one is, he was exhausted and alone, outnumbered. So, kind of taking that second one, let's take a look at that second one going from that perspective. Okay, why? Why were we in that situation? Well, that goes back to the chase. There's no dispute that, the defendant had the absolute right to try and place him under arrest. Okay? He was driving without a license. And that's the thing you have to look at it. At the time, he knew driving without a license and had a bad plate. Those are the only two reasons. Okay? There's nothing else. Nothing else that the defendant knew at that point in time. So you have to take it at that point in time, that's what he knew. Didn't know about the drinking, that came up later. So at the time, he makes the decision to chase, and I'm not going to play the videos, we've seen it ad nauseum, and that's a great thing now. You can go back in the jury room and play those. You can look at whatever you want, you have the ability to replay it, take different looks at it, pick whatever thing you want. Please, take a look at it, go over it. You paid attention, but now you get to really talk about it. So the decision to chase happens, and he makes the tackle. Okay? He makes the tackle on that, within a minute, that's testimony, he's tired. He's exhausted and outnumbered. That's one of the first things he says in the statement. He's exhausted and outnumbered within a minute. Now, mind you, at 1 minute, this is one of the best in-fit officers in the Grand Rapids Police Department. And he's exhausted and tired within a minute? Well, apparently they should never chase anybody then, if that's the circumstances. And we're not saying, though, that police can never chase anybody. It's based on the totality of the facts and circumstances. And in this case, look at what's going on here. We talked about the use of force 9-1.5, relative size and stature, multiple subjects, relative strength, access to weapons. All those point against that decision. Because from the get-go, he knew he gets higher, he knew he was bigger. We heard from the testimony of Captain Sidebar, we saw how he got jumped off, kind of moved when he spun. Got lifted off the ground. He was we didn't know if he had access to weapons. That's a scary thing, because how many times over and over again did we hear about Grand Rapids Police talking about traffic stops, unknown traffic stops? You have to anticipate there are guns in the car. You have to anticipate that the people with the car in the car may have a weapon. But we have a person flying off chasing, not knowing about the guns, not knowing about there's another person, knowing this person's bigger and stronger, and yet doing that, but then using it to turn around and saying, well, I'm outnumbered and I'm exhausted because I chased somebody. That's troubling. That's troubling to use that as a justification from the get-go. There's plenty of policy, and that's what we talk over and over again, Exhibit 36. That's the one policy we see, a set-out policy. If you're looking at policy, how does that impact the law? That policy says, hey, if somebody's armed and dangerous, you're perfectly fine in following behind, having a plan. Not tackling. It's bad tactics to tackle. And I thought it was ironic that, in terms we brought that up, that the defense then brings up, well, they're trying to chase. And they have to go over chases, but the chase that they talk about in Exhibit 31, they bring it up, you're responding to a system of foot pursuit. Solo officer gave his last location and no further updates. Your first time was seen to assist. And what does that talk about? The officer's in trouble. The solo officer's in trouble, and so you've got to assist this officer in, he got himself bit off more than he could chew, which is essentially what happened here. So yeah, they train and you can chase, but it's basically you don't go running off. Von Queen says, I'm not going to advocate somebody go running off and chasing people down a dark alley. You're outnumbered, there's no business. When you don't know the situation, call for backup and do that. But now they try and use that as justification of why this all happened. The next part, the next major part, is the taser. You grab the taser. Okay? And these are screenshots. These are some frozen screenshots from the frame-by-frame video that you have an opportunity to take a look at. When you look at the frame-by-frame, this right here, the one on the left is, you can see the taser, that's when the moment the taser comes out. This is a little bit further behind because it's just about to be deployed, because you see the two dots on here from Nick Bloomfield in terms of that's where the shots are going to go at that point in time. So when the grabbing of it during this period of time, what's going on? why would you make it? And Nick Bloomfield's the one that says, well, yeah, you can use the taser, but you got a whole big issue with weapons retention right here. And you see why. You see why is because that's exactly what happened. He grabbed onto it. He grabbed onto it right then because he's face to face. But once again, you get back up. You know, it's not like you're just looking at the silos. What did we talk about before? What did we talk about the criteria, if you will? Patrick's still stronger. Patrick still don't know if he's got weapons. You're still outnumbered at this point in time. You're actually sticking, you know, you're trying to stick a gun where this guy who you just tackled, had two hands on, were on top of, gets up and walks away, and now you're trying to hold on to him with one hand, and then deploying the taser at the same time, and that's gonna be a good idea. And so this is, you know, we had experts, and, you know, this is Mr. Bloomfield saying, yeah, that's not a good idea. And you kind of see why that happened, but it also, once again, talks about policy going against, what does Taser say? This is from the PowerPoint. We go over the PowerPoint. Here's what Taser says about it, is that, you know, employ other force options or disengage. Okay? So, you know, Patrick did a bunch of dumb, bad things, but that, you know, the defendant did some things that led to this firing shot, and he's using those as justifications. Well, this all happened, ergo, I get to use deadly force. And that's where you get into Professor Stoughton and Nick Bloomfield. They're the ones, you know, they don't disagree with everything that happened here. Yeah, you can get pulled over. Yeah, he had a right to arrest. But in these certain critical areas, there are critical mistakes that occurred here that a reasonable officer, not using 2020, a reasonable officer wouldn't have made those same decisions. You don't try and chase him as bigger than stronger. You don't try and bring a taser out holding on to with one hand and in a position where he can grab the weapon, especially when Taser says, yeah, you can disengage, and the ideal footage that somebody has to use for a taser is 4 feet, even with the closed cartridges. Because we went over that. A closed cartridge, yeah, this Taser 7 had the ability to use closed cartridge, but closed is 4 feet, not an arm's length, which led to all this. So looking at the totality of the circumstances, you justify, well, I used a taser, I chased somebody, so I had to use, and I shouldn't have, but I had to kill him then. That's essentially what they're arguing. So one of the things you also have to look at is the imminent threat analysis. And this is kind of interesting because, you know, one of the things they talk, you hear in terms of all the witnesses, the experts on both sides, Von Clean and Professor Stoughton on both sides, they kind of use the same analysis, right? They talked about this. The imminent threat means intent, opportunity. Okay? I think there's a motive. I think Von Clean had motive. There's a similar thing. So if you think about that, when does Patrick Lyoya into a threat? When does it happen? Well, once again, you just don't. Use the defendant's statement because okay, you can testify to this, but take a look at the statements. Those are exhibits 39, 38, 39. The last two things I just admitted. Because when you go back and I cross-examine on him in terms of what did he think was going on, what was going on at the time, Patrick's trying to get away. Because these are his statements. He began to walk away, he proceeded to turn away, he ran away from the stop, he would not comply with commands and continue. I think the last two are the key. Continue to move his arms and legs in an attempt to get away. From the get-go, all this time before the taser grab, he's got the idea, yeah, Patrick's trying to get away. That's the defendant's perspective. That's what he says in his statement back in April of 2022. Okay, Patrick's not threatening me, Patrick's not taking a swing at me, Patrick's trying to get away. That's the whole basis. Even when it comes to the taser. And that's the thing, that's the key moment, okay? That's where something more is happening here. He puts his hand on the taser. What is the defendant's impression? The defendant's impression is he moved it so he'd not be struck. And that also compares, when you think about, you start comparing, you compare the witnesses. What do the other witnesses say? What does Wayne Butler, the neighbor? Wayne says from the get-go, yeah, Patrick's trying to get away. Wayne says, yeah, he's trying not to get tased. That's the whole thing. That's not an expert. That's just a normal civilian, a neighbor sitting there watching everything. He's not trying to get tased. You can tell that. That's a lot of what Seth, Professor Stoughton and Nick talk about. There's an intent to flee. There's no intent to harm. There's no assault going on here. He's trying to get away. You don't get to shoot somebody because they're trying to get away. That's not a justification. That's not an excuse. That's what the law is. And that's what the impression of everybody here, including the defendant, because that's a statement. So when you start looking at it, has the ability to have an intent to do great bodily harm, that's the imminent threat analysis. When does that start? Was it here? Because once again, you get to look at the pictures now, because right here, clearly, that one on the far side, he's moving away from him. That's obvious to everybody, so why now, just because he's got his hand on the taser, is he going to use it against him? He never threatened him, he's never tried to swing at him. And you go back to these, look at the first two, he's got plenty of opportunity, right? He's arm's length away, both hands are open, take a swing, punch, do something. It's, no, grab the taser, get away from him. So once again, how does a reasonable officer in this situation think I'm going to die? When a guy who's done nothing more than keep trying to get away from you, to keep trying to walk away from this. How does a reasonable officer get that out of this? And then you go to, and these are exhibits from the body cam, or excuse me, the cell phone video. You hear about, Professor Stone and Nick talk about, their opinion, based on generally accepted police practices, was that a reasonable officer in this situation would not make the decision to fire. And what do they say? One of the reasons is, well, he was never in a good Patrick was never in a good tactical situation. And look at this. This is a good tactical situation when you're on the ground. He's on his back. Take a look at that. He's flat on his back with the taser at his side. Okay? He's not. And once again, what does Wayne say? Wayne kind of says the same thing. Wayne's not, once again, not an expert saying he's winning. The defendant's winning, I think he said. There's nothing coming from Patrick. Okay? Right here, this is the one thing they point to right here, just before the shot was fired, his legs get lifted off. His legs get lifted off the ground, but within a little over 10 seconds, he's back on the ground. So you break it up. So until the taser's grabbed, we have the defendant saying, yep, he's trying to get away. What happened in the next minute, 10 seconds approximately, that would make a reasonable officer think he was going to die? What did Patrick do? What did he do? He grabbed on the taser. That's the sole justification. He grabbed on the taser. Didn't point, didn't threaten, didn't say anything else. Once again, didn't throw any punches, didn't do anything like that. So why is a reasonable officer going to think, and that's exactly what Professor Stone and Nick said, a reasonable officer wouldn't have come to that conclusion. Generally accepted police practices, and generally accepted police practices are Grand Rapids policy. Because we heard that from who? Captain Sidebar and Captain Pierce, who basically said, we're CALEA certified. We're certified by CALEA. They give us, that's generally accepted police practices. That's, you have other agencies come in and take a look at things, and generally police practices, and that's what Professor Stone and Nick based their decision on, based their opinion on, when you take a look at all these facts and circumstances. Why would a reasonable officer think he's going to die when somebody's simply trying to get away, never in a tactical situation by their opinion, and as well as the civilian witness who saw it at the same time? So it also comes into this part. I'm trying to play it, hopefully it works as long as it never...
No, that ain't good, I can't talk to him.
Because that was one of the bases. That was the basis of Nick. Nick Bloomfield said, well, the other thing on top of it, the taser there was no neuromuscular incapacitation. That was not possible because right there, because that's the second. And Brian Child says, there's the second appointment. So it's been deployed twice. There was no probes that were going to fire out at that point in time. So he couldn't been incapacitated. Well, they call it, David Blake saying, what the heck's going on? We need to, he doesn't hear anything, there's tunnel vision, he's going to skip things and miss things. And his explanation at this point in time is, well, he could have, been out of breath. Listen to it and watch. Drop the tape, and then he moves it away as well. There's plenty of knowledge that he knew exactly what would happen, but you also take a look at everything else. And you look at everything else, what happened there, what else? All these other things that he heard through this entire incident. Take a look once again at his statement. He heard everything. He heard the neighbor coming out of the house at the beginning. That's when the fight's still on. He heard that he didn't hear him, but that's still hearing, other units were on the way. He could not hear sirens later on. After the taser struggle, he knew that there were no sirens coming, that other Cars were approaching. So he heard everything, and suddenly there's just one thing he misses, and that's on top of all the other perceptions he was making at that point in time. He saw, this is, he testified, here, he saw the red on the taser on what was happening. So when you look at all that, he was aware of anything, so suddenly this one thing he missed, that he wasn't aware that that taser had been deployed twice, so there was no chance of neuromuscular incapacitation. You have to ask yourself that. How is that possible? One thing, you just missed one thing out of everything he perceived. He perceived at the moment he fired the shot, in his statement, he says, yep, I checked the background, there's nothing there. So it's not like he says, I don't remember what happened. He says, yep, I was checking everything, I saw everything, I heard everything through this entire incident, so there's knowledge there that the taser was not able to be fired that would cause NMI. And the fact that it suddenly maybe the NMI, that it could have caused pain, we heard over and over again. How many times did we hear from the various defense witnesses? Were you tased? Yeah, it was painful. It was painful as heck. It was burning, it was everything. Pain is not a reason to use deadly force. You can't use deadly force because you're going to be in pain. There's no instruction. You can use deadly force when you think you're going to be killed or you're going to be seriously injured. Pain is not part of that. Just because it's going to cause you a lot of pain. Burning the pain of 1,000 burning suns doesn't justify it. But they try and work that in now. And they try and add that in. And quite frankly, look at his statement. That was never the concern back when he wrote his statement back in April. The statement was he was afraid that he was going to get tased, there's going to be neuromuscular incapacitation, and then Patrick was going to grab his gun. It wasn't the taser that was causing the issue, it was the fact that he may get shot. So NMI set in, and so Patrick's going to grab his gun. Why would you think Patrick's going to grab his gun? Patrick never went for his gun. They testified, never touched his gun, never tried to go after his gun, never grabbed his gun. But that was the feeling at the time. Which also going into policy, if you're trying to determine what policies should have an impact, you heard over and over again, what was the policy in 2020? Exhaust all alternatives before firing. Now I thought that's kind of interesting in terms of, what they talk about. They keep on saying, well, in terms of, if you make the decision to use deadly force, does that mean you have to go back down? That's not nobody's arguing that. Like I said, during one of the witnesses, if somebody comes out with a gun and points it at you, you don't have to try and use pressure points, right? Nobody's saying that. But when you're in terms of a struggle over that lasts a couple, 2-3 minutes, yeah, you got to try something else. And what do we have here? We have arm strike, one arm strike, a bunch of knee strikes, taser gun. What does GRPD teach on this? Why are we going over that? 4 hours, they're recertified. That's where you take a look at the exhibits, all the training records. They are taught for every year, going over all the pressure points, all the different stuns, all the different strikes, all the different things that are used to try and get control over a person who's not willing to be arrested. You don't need to use all this stuff. You don't need to do stuns and takedowns and pressure points. You don't need to grab somebody by the side of the jaw if they're compliant, right? You only do that is when they're not compliant. None of them are used. Zero. Not one. So what is the purpose of this policy that says exhaust reasonable alternatives when nothing happens? They don't use it. It's ignored. It doesn't even try. Arm strike, kick, taser gun. That's all we have here. And then that's part of the policy we talk about, require a warning shot. Now they say, well, it doesn't make a whole lot of sense that maybe stop is enough. Maybe stop is, we don't say stop or shoot, but there's some sort of warning, so we kept on saying you drop the taser, that's enough. That seems that once again applies in the face of the policy that says is a warning shot must be given, or a warning shot, warning must be given before firing the shot after you exhaust all reasonable alternatives. None of them were exhausted. There was no early warning. It was just a shot in the back of the head from a guy who was trying nothing more than to get away. There was no threat there. He wanted to get away. Whatever reason, he wanted to get away. We don't know why. We don't know why he made that decision. He was drunk. That could have played a role. But that didn't mean he should die on that day. So when you look at it, a lot of what we are basing on Yeah, it's two experts. Our two experts, Professor Stott and Nick Bloomfield. And they based it on generally accepted police practices. What would reasonable officers do under this situation? And when you look at it, they take a look at the whole thing, is you look at it, there's, I think Professor Stott said, yeah, there's an imminent threat. A reasonable officer would think there's an imminent threat of somebody trying to get away, but that's very different than an imminent threat of somebody trying to kill or hurt or injure somebody. Those are two different things. And once again, that's also backed up when the one civilian who really saw everything here, Wayne Butler, he kind of said the same thing. There was no evidence that Patrick was trying to hurt or do anything. He was trying to get away. The primary act was resistance, an attempt to harm, and he didn't do harm. I think that's an important thing. There's a fight to the death, and that's why I showed those pictures. There's a fight to the death, and the most injured, you got maybe some redness on his wrist. You're gonna fight to the death, and they keep on talking about a fight. How is a fight? Once again, a fight is defined as throwing punches, doing something else. This was a wrestling match. The most I could say, all the witnesses said this was active aggression. Okay? He was pulling away, he was wrestling. The only thing we could say is, well, potentially, maybe, he could be, the defendant thought maybe he was going to turn and fire the taser. There was never a tactical advantage, that's what they said, never a tactical advantage, so why would you think that you need to do it at the moment and fire that shot? Because what happened over and over again? You saw Patrick try to get up once, but then it shoved it down. Patrick got up again, what did he do? He walked away. So this time when Patrick's trying to get up again, he gets shoved down. Watch the video, take a look at that video. He gets shoved down again. He never got up, fully walked around the second time after they went to the ground with the taser. They were wrestling, Patrick went to get up, he was shoved on the ground, and that's when the fatal shot was fired. The defendant had tactical control. The defendant was on top of him the entire time. Why would you think you need to use deadly force under these circumstances? So what happens? If it's not reasonable, it's not lawful self-defense. That's the only thing that justifies it. That's the only way we get out of here without a verdict of guilty under these situations. There's not a reasonable officer that think that Patrick was trying to kill him based on what was here. So what does that mean? The defendant's guilty. This is a traffic stop. At the time the defendant knew what was going on, it was for a bad plate and no driver's license. What out of all this he didn't think he was going to die? He had his taser? That's not enough. He was tired? Yeah, he was tired. Okay, great. You don't need to beat over the head that he was tired. He was tired because he put himself in that situation. There was no reasonable officer that would think he was going to die based on the facts and circumstances here. So the verdict that you must come at the end is guilty of second-degree murder, and that's why I asked you to return the verdict of such. Thank you.
All right, Mr. Borgola.
Thank you, Your Honor.
Good morning, everyone. And thank you for your patience. The prosecutor is trying to make this case something it's not. You're here because you're going to judge my client, Christopher Schurr, on the decision of whether or not to use deadly force in a situation, on his decision and his belief that he was in fear of either great bodily harm or death. You are not here to judge the GRPD policy. You are not here to judge whether it was reasonable for him to chase Patrick Lyoya. You have to decide whether the prosecutor has proven beyond a reasonable doubt, whether Grand Rapids Police Department Officer Christopher Schurr had a reasonable fear of great bodily harm or death. That is the issue. And you must look at it at the moment of the threat. When Patrick Lyoya had the taser in his right hand, whether or not Christopher Schurr was reasonably in fear. And the prosecutor has failed miserably. I want you to look at just the case that the prosecutor put on. And I would submit to you, the prosecutor didn't even meet his burden in their case. You heard from a couple of Patrick Lyoya's friends about what occurred the night before leading up to the events. There was a night of drinking. Mr. Lyoya wakes up at 8 a.m., according to the witnesses who were there. He's with Aime Tuyasheme and David Bakuru. And the prosecutor put on evidence of how much everybody was drinking. That was the prosecutor's case. And that they got into a car. No one is suggesting that anybody should be executed because they're drinking and driving. That's absurd. And that's nothing to do with what happened here. Yes, he was drinking and driving. Is that a bad thing? Yes, but nobody's saying they deserve to be executed, and nothing like that happened. The issue is whether or not he was in fear after Patrick Lyoya later on took his taser. So what happened is they get into a car, and it has a license plate from a different car. That means that the license plate belonged to a totally different car. Mr. Lyoya and Mr. Tuyasheme and another person was dropped off so that person could take his kid to school, and then they drive around. They visit Mr. Lyoya's new apartment. They stop to reload on Budweiser, and they're driving around again. When, according to Mr. Tuyasheme, they hear a noise in the car, and they were driving around. They take a couple right turns. They stopped on Griggs Street in Grand Rapids, and then Mr. Lyoya quickly exits the car to see what's going on. According to Mr. Tuyasheme, he really wanted to hear what the noise was to try to figure out how maybe there was something wrong with the car. But at precisely that moment, in an incredible coincidence, that's when Officer Schurr had pulled him over. You can decide whether or not that was the case, or whether or not that's even relevant. But Officer Schurr, it's irrefutable and undisputable, he had a valid reason to pull him over. The plates didn't match the car. He's a police officer, and that's his job. He's at work. It's 8 a.m. on Monday. That's his job. That's why he's pulling him over. And the prosecutor agrees it's a lawful stop. After getting out of the car, Officer Schurr gets alarmed. You can hear it in his voice. He orders him back in the car. 4 times, get back in the car, get back in the car. Why is he doing that? Because he's trained that if somebody jumps out of their car, that could be a problem. So he orders him back in the car, and Mr. Lyoya refuses. Officer Schurr doesn't know why. He doesn't know why he won't go back in the car, but he just approaches him. But he doesn't know anything about a broken down car, because did you hear Mr. Lyoya say anything about, hey, my car's not working? There's a funny noise. No. So we're talking about the knowledge and in the situation of the officer here. So what does he know? He just knows somebody jumped out of the car. Instead of answering lawful questions, which the officer is allowed to do, Mr. Lyoya decides to start questioning the officer. What did I do wrong? And then Officer Schurr is asking questions at the same time. Neither are getting answers. Officer Schurr, he says, you have a license. What for? Do you have a license? For what? Do you have a license? What did I do? Do you have a driver's license? Do you speak English? Because now he's wondering, maybe he doesn't understand what I'm saying. Mr. Lyoya answers that question, yes. Can I see your license? What did I do wrong? And then Officer Schurr just starts answering his questions. He tells him, well, the plate doesn't belong in the car. That's why I pulled you over. He's hoping to get an answer from Mr. Lyoya. Do you have a license or no? Do you have a driver's license? Yes. Where is it? It's in the car. Get it for me. What did I do wrong? The plate does not belong in the car. He answers his question again. Police officers are supposed to ask questions at a traffic stop. They're supposed to get your ID. That's what a traffic stop is. And that's what he's doing here. And if you want to see how Officer Schurr responds when somebody actually complies in the smallest amount of a way, watch this interaction. Look at his body language. Listen to the tone of his voice. When Patrick Lyoya says, "It's in the car," get it for me. Does he scream at him? No. He steps back, literally steps back, get it for me. So what follows after this is a series of decisions by both of them. Patrick Lyoya is making decisions. Officer Schurr is responding to those decisions and making decisions of his own based on his training as a police officer. He's doing his job. Patrick Lyoya decides to walk away from police. Why? We don't know. Officer Schurr is trained, though, that failure to comply, ask yourself why. There's not a lot of good reasons for doing what he did. So he's alarmed again. So he went from, "Get it for me, please," to, "Oh, here we go." He's walking away, so I have to go back up. He decides he's walked away, I'm going to have to arrest him. Why? Because as a police officer, he's committed a crime. And it's not his job to decide who gets set free and who gets arrested. His job is to arrest. He is on the street to detect crimes and arrest people for them. And it's committed right in his presence. He doesn't think, well, I'm not really going to arrest this guy today. That's not his job. So then you saw that Mr. Lyoya, after Officer Schurr lawfully went to arrest him, resisted arrest. And we can argue about all day whether he affirmatively punched him, but balling up your fist and throwing arms like this, I agree he didn't face up to him that many times, just a couple times. He shoves him, and then he decides to run. Why is he running? Officer Schurr doesn't know. He doesn't even know his name at this point. Officer Schurr does his job. He calls it in immediately. Gets on his walkie-talkie. All right, somebody's running, and he catches him. He's arresting him. Feet from the car. Why? Because he's a police officer, and that's his job. He's doing exactly what we expect him to do. He doesn't get to decide, well, I'm just going to let this person go. That's an option under his training, but he made the choice to pursue him. And Professor Stoughton agreed that the initial pursuit was fine. He's just mad that he disagrees with the fact that he didn't peel off once he got near on the other side of the car. And you saw that Patrick Lyoya continued to resist arrest. He lifts him off the ground. Why? Yeah, he's getting away. But Officer Schurr is not trained to figure out what the motive was for the fact that he's resisting arrest. He's just resisting arrest. He doesn't have time to ask him questions. Why? Please just stop. He's not answering anything that he's saying. He's telling him to stop. So Officer Schurr decides to use greater force because he's a police officer and that's how he's trained to handle it. Knee strikes, commands, open hand blows. You heard that they were open hand. So he's not trying to hurt him permanently. He's using his open hand. That's how he's trained. And obviously they're not effective. He didn't take out a stick and hit him on the head or anything like that. He's trying to arrest him. That's why he's using intermediate force. He's trying to get him to command, to comply within the bounds of his training. And you see Patrick Lyoya, he decides to get up and walk across the lawn with the officer in tow. Officer Schurr doesn't know why, but it's not his idea to go that way. Who's in control of this situation? He gets up. He walks him across the yard. Intermediate force didn't work. You hear Mr. Lyoya yell, "Get the keys." Well, sure looks like he's developing a plan to get out of there. So Officer Schurr has decided, oh, he just wants to get in his car and go away, so I'll just let him go. No. It's his job to arrest people that are committing crimes. He can't just decide, well, I have to let him go now, because he's saying he just wants to get his keys and get out of here. The suspect doesn't get to decide when you get arrested. So he pulls out his taser. That's the next step up. It's perfect. Everybody agrees it's perfectly appropriate to use intermediate force here. Fires the taser. As everybody agrees, Mr. Lyoya grabs it and moves it to the side. That was Mr. Lyoya's decision. That wasn't the officer's. He didn't say grab the taser because he put it in front of him. This is not an affirmative act of aggression, reaching out. He grabbed it and he never let go. And he tries to get it from Chris. And look what the officer's decision here was. Did he pull out his gun? No. Did he go to deadly force here? No. He decides to physically try to get it back. He's got the taser in his possession. He won't let it go. And Patrick Lyoya decides he's not giving it back. The officer's yelling at him to drop the taser. Let go of the taser. And then the fight is on. They both want the taser. That's what they're fighting over. And Officer Schurr has a right to it, and Patrick Lyoya does not. And Officer Schurr did not use deadly force to get back the taser. That is not why we're here. They go to the ground, and the film goes in and out because Mr. Tuyashime I'm sorry, Your Honor, is there something wrong with the camera?
The screen went out for a moment. It's back on now.
Thank you. So you see this part of what's going on. They're both still trying to get it back. And you notice that there's a part where it starts in Mr. Lyoya's left hand. And then it's in his right hand. And 11 seconds go by. And you can't really see what happens. So we don't really know how Mr. Lyoya got it in his right hand, but we know it was in his right hand. And then you see Mr. Lyoya roll over onto his stomach. Just like previously by Mr. Butler's house. He started on his stomach, pulls his knees in, and gets up. And that's exactly what's going on here. The taser is now in his right hand. Officer Schurr's trying to get the taser back still, and he can't. It's been switched. He's got exclusive control of it. He's on his back, yes, but why is he on his back? Because he's trying to get the taser back. And then you see Officer Schurr still trying to get the taser back. He's over the top trying to get this thing back. And you can see on the exhibit that it is in Mr. Lyoya's right hand. Right there. These slides, half a second apart. Half a second. This is how quick this is happening. It's a little split second. Patrick Lyoya has got it, holding it in his right hand. It appears from the video, it's consistent with the officer's testimony that he's holding it like a gun. It's clear in the video that it appears that Officer Schurr is being lifted up. Is he jumping up? No, he's being lifted up by Mr. Lyoya. And the angle is turning, consistent with the officer's testimony. And here, this is no longer about arrest. This is the decision you have to judge. Whether in the moment of the threat, he was afraid of that taser, incapacitation, or great bodily harm. Whether it was reasonable for him to make the decision he never wanted to make that morning. Christopher Schurr was at work, and he was faced with the toughest decision of his life in half a second. That's what you're judging. Whether it was reasonable in that split second for him to think that an officer could be in fear of the taser. Not whether, what did Patrick Lyoya intend to do with it? He's holding it like a gun, and he's getting up. He has no idea why Patrick Lyoya is fighting this hard. And he doesn't have time to figure it out. 3 years later, when you hear about his family and his friends, yes, maybe you can draw some conclusions about what he was actually thinking. But he doesn't have the luxury. He's got half a second to make up his mind. And at this point, Mr. Lyoya has given him absolutely no reason whatsoever for him to believe he's not going to use it to get away. It doesn't matter why he's got it held like a trigger. I mean, if he's just trying to get away, he's still going to disable the officer to get away. So here we are in a criminal trial. And so now you're asked to judge not what the best practice was, but whether or not in the moment of the threat, whether the prosecutor, with his burden, proved to you beyond reasonable doubt, all reasonable doubt, that he wasn't in fear. And to help you decide this issue, the prosecutor brought in some experts. You heard from Mr. Childs, Professor Stoughton, Mr. Bloomfield, because he is trying to prove to you beyond a reasonable doubt that it was unreasonable for Christopher Schurr to be in fear. Beyond a reasonable doubt. And you heard from Mr. Childs. He works at Axon. It's the company that makes the taser. So he is an expert in tasers. A taser is a weapon. That's how they refer to it. And it's something to fear. The taser can cause incapacitation, even if the probes are discharged. If used improperly, a taser can blind or possibly even kill you. Probes can be reactivated once fired if they're lying on the ground. All you do is hit the button again. The wires can cause, even with wires, they can cause NMI, this incapacitation. They're insulated, but it's not a big insulation. It can get scraped off, especially if they're being dragged across the ground. The very next witness is Professor Stoughton. And followed him as Mr. Bloomfield. They wrote a joint report. And they've never heard of Brian Childs. Not really sure who he is. Didn't consider his opinions about the taser. How is that possible? They just flew in, gave their opinion, and flew out. It was their opinion It's reasonable to use deadly force if going to be incapacitated. So they agree. If you're going to be incapacitated and you're a police officer, you can use deadly force. It's reasonable to use deadly force if you're going to suffer great bodily harm. You don't have to lose an eye before using deadly force. That's what that means. But then here's where it differs. No objectively reasonable officer could be in fear of incapacitation from the taser because no reasonable officer could have feared incapacitation or great bodily harm in this particular situation. In other words, the taser is not dangerous in this situation. So you heard from Brian Childs, and then you heard from Professor Stoughton and Mr. Bloomfield. And they completely disagree with the prosecutor's own expert on tasers. They say a taser is not a weapon or something to fear in this situation. The taser cannot cause incapacitation if both probes are discharged. It's unreasonable to think the probes can be reactivated after being fired. Wires cannot cause incapacitation if insulated, because it's so unlikely. The taser is about as dangerous as a thumb in your eye. And even Mr. Bloomfield, unless you're holding it like a gun. So you have the prosecution's own experts disagree with each other. You know what this picture is right here? That's reasonable doubt. You don't have to go any further. They're disagreeing with each other on the basis for why he should or should not be in fear. How can you convict someone for acting unreasonably and not being in fear when their own experts disagree? And certainly not beyond a reasonable doubt. Now, Mr. Stoughton and Bloomfield offer some more opinions. They admit they don't know how he's trained. And they essentially admit that there's no bearing on the ultimate issue of whether he reasonably could have used deadly force. But it has no bearing. These other opinions about the chase and the stand too close. Why are we discussing this? You're asked to determine whether or not the prosecution has proved beyond a reasonable doubt that he was in fear at the moment of the threat, and then whether it was reasonable. Why are we talking about GRPD chase policy? Because they're trying to distract you from the actual issue. And even if you consider it, it doesn't matter if he chased him improperly. It doesn't matter if he's within 4 feet or 7 feet. And it doesn't matter if he used a compound sentence in his warning or is just a directive. The issue is reasonable fear. And that's why you saw this evidence about tasers and this training. They just don't agree with each other. You don't have to go any further. The prosecutor is also suggesting that you should just let him get away. Let him go. He hadn't punched him. That's the standard for when you get to use deadly force? Well, up to now, I know he just took my taser, he's holding it in his right hand, but he hadn't punched me yet. So therefore, no reasonable officer would think that he was going to use the taser on him. None. That's what they're saying. That's what Professor Stoughton said. It's absurd. Not one officer, no reasonable officer. That's what he's saying. No one could think they were in fear. No one could think that he might use it on them. He's got to figure out that he's got some innocent motive for taking the taser from him after getting up 3 times before. Watch the video. If this issue, does he run away once the taser comes out, or does he turn around and grab it? Does he deflect it, or does he hold on? If this was reflex, oh, I don't want to get tased, you just deflect it. Does he ever say, hey, don't tase me? Does he throw it away once he has it? Does he listen to anything Officer Schurr is begging him to do? Is it transferred from his left to right hand? Why would any reasonable officer think he was going to walk away politely? In the split second that Chris had to decide whether or not he poses an imminent threat, all he knows is he's fighting to retain control. He knows he's lost the taser. He knows that he's turning and rising. His fear is unreasonable? No reasonable officer could think that. You should find him not guilty after the government's case. And even though we're under no obligation to put on evidence, because his entire life is on the line, we put on substantial evidence that the prosecutor cannot show that his fear was unreasonable. And we're constantly hitting these shifting arguments. You heard from the training officers. Captains, Sidebar and McCursey. You saw a lot of training materials. Why is this relevant? Because you're considering the knowledge of the officer, not generally accepted police practices. They may coincide from time to time, but you're looking at what, he's a street cop. He's trained. Hours and hours of training. You saw a lot about taser training. Why are you seeing this? Because this is what's in his head of what happens when you get hit with a taser. I mean, is there any doubt that the training puts the fear of God in these guys about these tasers? They're weapons. You heard about firearms training, deadly force scenarios. One of you asked if they have implicit bias training. They do. This is a heavily trained department. And what is the point of all this training? Let me tell you about training. Officers are put in situations like this all the time, and you train because when you don't have time to make a reasoned decision with all the facts about everybody, you rely on your training. So when the time comes, you have to make a decision, you can act quickly. The same thing, military drills, sports, if you ever played sports, what do? You practice. So it comes almost automatic. When you don't have time to think in stressful situations, you rely on your training. All right, Captain Sidebar, he's a training officer, expert on GRPD policy and training. He testified that Officer Schurr trained on GRPD policies and trainings, not generally accepted police practices. Followed GRPD policy and training in the situation. Once a decision was made to use deadly force, he's not required to try other options. It's the decision to use deadly force. A reasonable officer in this situation could have used deadly force. Mr. Becker, question that Captain Sidebar didn't do an expert report. This does not matter at all. It's irrelevant whether or not he did an expert report. He was paid exactly $0. I know you heard a lot of paid experts. Captain Sidebar isn't one of them. Captain McCursey. He's an expert in GRPD training and tasers. What did he tell you? Officer Schurr was given warnings that taser is a dangerous weapon. If someone gets your weapon, assume they're going to use it against you. A taser can incapacitate you and probe or drive stun. An officer does not have to wait before being harmed or killed before resorting to deadly force. And a reasonable GRPD officer in this situation could have used deadly force. He followed his training. The captains in the GRPD believe that he was reasonable in this situation. Now, let's talk about the prosecutors' experts on GRPD training. Here they are. None. So everything that involves his knowledge, you heard from the defense, and nothing from the prosecution. How did they show you he didn't follow his training? They didn't call a single GRPD officer. Do you know why he didn't call one? It's his burden to put on proof. Ask that question yourself. How else has the prosecution failed to meet its burden? We heard about exhaustion. Heard from Lon Bartel. It's reasonable for an officer in Schurr's position to lose ability to continue fighting. In a fight, you lose ability to contract muscles within 30 seconds. He was in a position of tactical disadvantage, not advantage. He fought with him for 2.5 minutes with a man that was larger than him. He's got nothing less, and he lost control of his taser. Heard from Dr. Kroll, he wins the award for the smartest witness. He's a biomedical scientist. Why are we calling him? Because we're trying to refute this testimony by Professor Stoughton, who is not a taser expert, that you can't be incapacitated by this thing. So if you think that Professor Stoughton actually knows more than Mr. Childs, we called another expert. Drive stun can temporarily incapacitate you through disorientation. You have the probes, and then you have the drive stun. A scientist came and told you, yes, you can be temporarily incapacitated. And Professor Stoughton agrees, if you can be incapacitated and you're in fear of incapacitation, you can use deadly force. The drive stun can and has caused great bodily harm to sensitive areas. You heard this whole thing from Professor Stoughton. There's no reported deaths of police officers who lost their tasers as officers trained after they lost their tasers, where someone took their gun and killed them. And you know why? You also heard that answer from Dr. Kroll. Because officers are trained to use deadly force if someone gets your taser. That's why. He told you how many deaths there were. You heard from Dave Blake. Well, you first heard from Mr. Bloomfield that this is not the type of situation where auditory exclusion and tunnel vision or this sort of closing in, it's not stressful enough. And then he was asked, are you an expert in human factors? Well, no. Well, this is Dave Blake. He is. He said this is exactly the type of case where this could occur. And that Chris did not have time to give a warning. That's it. That's how much time he's got to make up his mind. That's what you're judging him on. And that decision, not whether he chased him a minute and a half before, that's how much time he's got to decide, and whether that was reasonable under those circumstances. The prosecution suggests that you shouldn't credit Dr. Blake's testimony because he went to an online school. But yet, he wants you to credit Mr. Bloomfield's testimony, even though he didn't go to school for this. I'll let you decide who's more credible. So you heard from the use of force experts. They pretty much agree on a lot of stuff. We agree on the standard as trained. When you're in fear of great bodily harm or death, that means you're not worried about a paper cut. It's got to be like stabbing, breaking a bone, or losing an eye. And of course, death. Then, if the prosecutor can show beyond a reasonable doubt that he wasn't in fear at that moment, that's the standard. You heard about the totality of circumstances. And you can go through these. These are the things you're supposed to consider when reviewing whether or not the decision to use deadly force was appropriate. And we agree that a lot of these things applied. But that doesn't mean he shouldn't have tried to arrest him in the first place. This just means, under the totality of circumstances, the decision to use deadly force was reasonable. You know what's not on there? Foot chases. Because it doesn't matter. It's the decision to use deadly force that you have to consider. And so he was bigger than him. There were multiple people. He was stronger than him. He got his taser. He's in a bad tactical position, or, if you believe Professor Stoughton, he's in a better tactical position. The fitness level, the exhaustion, it's raining. He's getting up with the taser in his hand, and he's right next to him. All these factors point to a positive decision to use deadly force. You heard from Officer Gady. He's a firearms instructor. It's deadly force is deadly force. All the experts agree on this. It's the decision to use deadly force that you're judging, not the location of the shot. Not one expert said, oh, you have to try to wing him or hit him in the hand or hit him in the side. That is not what these experts are saying. It's the decision. Am I in fear of imminent threat? Is there an imminent threat? Then I can use deadly force. The manner of deadly force doesn't matter, and everybody agrees to that. Where do they disagree? Well, you heard that the prosecutor's taser expert and the prosecutor's use of force experts disagree. And you also heard that their use of force experts didn't really rely on GRPD policies and Michigan law. Instead, they have this generally accepted police practices. And that's because Professor Stoughton and Mr. Bloomfield, they're viewing this in hindsight, and everybody agrees you shouldn't do that. It's a sort of a woulda, coulda, shoulda thing. If you go back in the jury room and say, you know, if he just had let him go, that is not the proper analysis. I wish he just, I guarantee Christopher Schurr wishes, in hindsight, that he had let him go. He didn't want to make this decision. But that's exactly what the prosecution is doing here. Monday morning quarterback, based on all kinds of issues that don't matter, it's the moment of the threat. Look at his training, his knowledge, what he knew. And you take that into that situation, and you decide that based on what was in his head, the decision to use deadly force was reasonable. In this case, they have to prove beyond a reasonable doubt that it was unreasonable. Now, you heard Chris testify. He had no obligation to testify. It's a criminal case. What did he tell you? He testified about his knowledge, his training and experience. He was exhausted, running on fumes. He was alone. He called it in right away, but there's nobody there. You can listen to the video. Do you hear any sirens at the moment of the threat? Listen to it. Crickets. Where is everybody? He testified he did everything he could to avoid using deadly force. He didn't pull out his gun as soon as he grabbed the taser. Probably could have under this training. What did he try to get it back? And he's screaming at the guy, let go of the taser. It's the moment of the threat. He testified that he saw the firearm. Let's get that. In his hand. He was trying to he testified he tried to put the safety on, even. Couldn't do it. He's in a bad position. He does not feel like he's safe. He's pulling himself up again, and look at what Mr. Lyoya had done 3 times prior. Literally lifted him off the ground, and now this time he's got the taser. It's reasonable for an officer to think in that situation that he's going to use it on him. It would be unreasonable for him to think he wasn't. But when he's given a chance, he comes into the stand to cross-examine him as vigorously as he did Captain Sidebar. He barely even asks him about the moment of the threat. What is he asking about? You didn't have to chase him, right? That's the questions they got. You stand too close to him. You're in really good shape, aren't you? That's just designed to mislead you from the issue that is why you're here. He suggests that he's lying about the second pop because he said, look at the statement. And did he ask him about hearing it? Nope. He just wants you to look at a statement that was done. As Christopher Schurr testified, I kind of wrote it like a police report after seeing the video. I mean, this video was out there right away. That wasn't his fault. And then you have the state police asking for a statement, and he's got counsel already. And he signed it, so it's attributable to him. But keep that in mind. View the actual evidence, the testimony. The prosecutor has a chance to ask him all these questions. Now he asks you to answer based solely on a statement that was written with the help of lawyers a few weeks after the incident. That's not fair. He didn't have to testify, he did, and then he didn't ask him any questions. How can you assess his credibility on these issues when he wouldn't even ask the questions? All you're left with was what he said originally, but it wasn't the focus of cross-examination. No, it's something he wrote kind of like a police report because he's a police officer. I mean, look at this exhibit right here. If you're wondering whether he's exhausted, I know he's in good shape, but 2.5 minutes trying to wrangle a grown man, desperately trying to get a taser back, is not the same thing as running on a treadmill. So you're going to hear about the law, and I think I have already stated over and over again what the issue is. Nowhere in here will it say, please consider whether or not Officer Schurr's complied with policy. Nowhere in it will say, hey, maybe we should change GRPD's foot policy. Please give us your thoughts on that. No. That's a distraction. Go to the next one. The relevant consideration is not what defendants should have known or done, but rather what a reasonable officer with the knowledge and the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. That's why we're here. Professor Stoughton and Mr. Bloomfield say there was no reasonable officer could have thought he was in fear. We don't think the prosecutors come close to meeting that burden. If you start discussing whether or not GRPD should have a foot pursuit policy, stop, because that's not relevant. Look at the moment of the decision. It's the decision. Please, just look at this decision and whether or not there is enough there for any reasonable officer to think he might be in fear of harm. You're going to hear also that police officers do not have a duty to retreat. And this is important because private citizens do. Like if he wasn't a police officer and you saw this, then yeah, he put himself in a position he shouldn't be in. But Officer Schurr, he's not supposed to be retreating. He doesn't have a duty to retreat because he's a police officer. He put himself in danger, yes, because that's his job. You heard from one of the officers about the cowardice policy, just letting people go. You have to be sure that he wasn't in fear of great bodily harm or death before you can convict him of murder. Now, we go to the next one, please. Honestly, or go back, I'm sorry. One more. It has to be an honest and reasonable belief. But you heard from Officer Schurr. Judge him on his testimony. And judge him, his testimony in comparison to what you saw in evidence from the video. You heard him say that Mr. Lyoya had exclusive control of the taser, and he did. You heard him say that he was completely exhausted after a minute, and you saw how he was 4 minutes after. And if there's any question whether he feared that taser, whether he had an honest belief, if he doesn't fear it, ask yourself, why is he trying to get it back? What is he, even after the second discharge? Does he stop for a second and slow down after that second probe goes? No, he's still going gangbusters trying to get it back. Why would you turn the safety on if it's as dangerous as a thumb? It doesn't matter what Professor Stoughton thinks about thumbs and tasers. It matters what he thinks. And look at the video. Does he slow down for a second? He's fighting as hard as he can to get that thing back. He's going over the top of him. He's putting himself at harm. Yes, because he's trying to get it back. Reasonable? This is what the prosecutor thinks is reasonable. No reasonable officer could have thought that that taser, with the probes discharged, could harm him, could incapacitate him. None, not one. These guys who didn't even talk to the taser expert for the prosecution, who disagrees with that completely. If no reasonable officer could have been in harm or thought he could be incapacitated, then why does everybody else that's called to the stand think you could, including taser experts? Especially when handled by an untrained person. Now you're going to hear a separate jury instruction on manslaughter. It's the first time you're hearing this. This is the prosecution recognizing this case is weak. It's a lesser included. It's for cases where someone didn't intend to shoot the gun. Officer, he got up there and he told you, yeah, I intended to use deadly force. I intended to shoot him. But it was justified because he had the taser and I was in fear. This is not a situation where someone gets in a fight and they don't really intend to kill him, but they lose their cool in the heat of passion before they have time to cool off. They kill someone and didn't really intend it. That's a lesser included. That's not this case. And justification of self-defense is a defense to both of them. So if you find that the prosecutor hasn't met his burden to show that he was unreasonably in fear, then you must acquit to both of them. You absolutely cannot convict him of murder or manslaughter if you acquit him of murder. Now, you heard a lot about the burden of proof. And it's important. This is a criminal case. It's not a civil case. I think a lot of you were asked during the voir dire whether, it's got to be one of the it's one of the most important decisions in your life, like buying a house. I agree. It's got to be, this decision is as important as those. And this is the highest burden under the law. I like to equate it to, you have a friend, family member who's on life support and you have to decide whether or not to take them off life support. That's how important this decision is. It's any reasonable doubt. Now the wiggle room in there is if it's not reasonable. If it's an unreasonable doubt, then that's not something you should consider. It has to be a reasonable doubt. If you have any sliver of reasonable doubt, then you must acquit. They have to prove beyond a reasonable doubt that he wasn't in fear, and that his use of deadly force was unreasonable. If you're back to saying, well, he might have been justified, you must acquit. He could have been justified. Not sure whether he acted reasonably or not. That's an acquittal. That's the burden the prosecutor has to show before this is murder. And we just ask that you judge him on the decision and not all this noise around it. It's the split second. Any reasonable officer? This isn't murder. What an impossible decision. Make up your mind. It's not murder. It's not manslaughter. This man did not commit a crime. No one is saying Patrick Lyoya deserved to die. That is not what this is about. It's about, in the decision that we've asked Christopher Schurr to make, in that moment where he's supposed to be, whether the prosecutor shown beyond a reasonable doubt that it was unreasonable. No reasonable officer could have used deadly force in that situation. That's the standard. And their experts don't even agree on what's dangerous. You must acquit him of both charges. Thank you.
Do you have rebuttal?
I do, Your Honor.
Okay. You may go ahead.
Street. So you have attack prosecution's experts. That's one of the things you got to take a look at. You got to take a look at the credibility of witnesses. This is one of the instructions you're getting. Does a witness have any bias, prejudice, or personal interest on how a case is decided? And that includes the experts. That includes everybody here. So you want to compare experts here. Let's compare force science. Force science is not an expert entity. Force science is an advocacy group for police officers. That's what they're there for. Bond cleaning, and that's their network. That's their whole thing. So you're not compare about why not to believe somebody. Why would you believe an entity that starts out with giving the benefit of the doubt to the officer? That was Von Kleem's testimony. He starts out. So how can you be impartial? How can you be coming from a position of neutrality when you start out? You're going to give the benefit of the doubt to the police officer, which goes into them finding 98% of the time officers acted appropriately. What other profession is that infallible? What other profession? Name one that they're correct 98% of the time. So that goes into how do you believe they're experts? Yeah, they parade a bunch of experts out here, and it gives you just an insight of what happened. If you guys remember my question to Mr. Bartel, he said, well, geez, MMA goes 5 minutes, right? MMA goes 5 minutes. Well, that was the dumbest question ever made in the history of cross-examinations, because the disdain from the stand just oozed out of his pores. How could you can't compare an officer to an MMA fighter? MMA fighters train for 3 hours a day, so whole years, and blah blah blah. Yet the next day, when Von Kleem, his partner, his friend, who he presents with all the time, what does Von Kleem do in his report? Compares Patrick to an MMA fighter. Because that's what they got to do. They've got to say the opportunity, he has an opportunity because he can spring up like an MMA fighter. That gives you a window in terms of the prism. They translate what happens based on an officer. They like officers, which is perfectly fine. I'm not saying that they shouldn't have advocacy group for officers, but you judge an officer by one standard, then you judge the victim by another one. That's the opportunity. That was a tactical advantage because why? Because Von Kleem and Lon Bartels do jiu-jitsu and they do grappling. And so ergo, that Patrick has the same opportunity because he can suddenly spring up from a face down or a face on his back position and maybe use the taser. That's what gives him the opportunity. Von Clean talks about, disproportionate resistance. That's their intent. That's his interpretation. That's what he said. Well, you can determine the intent. Disproportionate resistance by Patrick is why you can think he's going to use deadly force. Von Clean doesn't want to use that against police officers because they have no idea how can they come up with disproportion. They can't comprehend that. So when you want to talk about bias and prejudice against the experts, you want to criticize ours, take a look at theirs. And they're comparing apples and oranges. Because our experts are use of force, they say, in terms of taser, what a taser does, what a taser can do. And it's possible for these things to happen, but it's not reasonable to think it is going to happen. That's the reasonableness test. You can't look at every sort of possibility in the universe of what might happen and then say, oh, it's reasonable that you can do it. I mean, why does it take Wegovy? When you listen to all the bad things that can happen on any of the drugs that are on TV because they may cause, hair loss, liver problems, and so on and so forth, but they want to use that as justification because all this may happen. It could, the wires could. There is no, talk about distractions, there is no evidence the wires were broken, there is no evidence that anybody was feeling MNI, there's no evidence that wires had any impact, but they've got to throw out all these things. You want to talk about another thing? Why isn't GRPD? Why do we ask for GRPD? Does a bank, when somebody embezzles money, investigate their own? No, they call it an independent. They call it an outside organization. How hard is it? And this is not just GRPD, this is for anybody. How do you judge something that you train? I mean, Captain Sidebar said, hey, I was his commander at one point in time. You think they're coming from a position of not bias because you're asking them to judge their policies, their procedures, and what this person does? They like him. He's a good guy. How do you come in and say they're impartial? And once again, to give a window on that, what did Captain Sidebar say? Because Captain Sidebar, when we asked, we said, okay, you've been listed as a defense witness. Okay, what's the policy? If somebody's disarmed of a taser, do you have a policy on that? Nope. No policy. Never heard of it. Yet then he takes a stand in front of you and says, oh yeah, that's deadly force. Well, wait a second. 2 weeks ago when the detective asked you about it, you said, no, there's nothing. But now that, as soon as somebody disarms you of a weapon, that was a weapon. You never said taser specifically, but he was asked specifically about a taser and disarmament. Nope, there's no policy on that. We don't train nothing about that. But yet all of a sudden it changes. That gives you a window of why there's bias. There's a conflict of interest. That's why we have the state police in here talking about it. There's a conflict of interest to try and bring GRPD officers to judge on another GRPD shooting incident. They have every reason, just like anybody else. Just like a bank, you don't ask the people who were responsible for training what went wrong. But even that, and this is what I'm talking about, you can believe all, some, or none. They say Grand Rapids policies are generally accepted police practices. They're one and the same. There's no difference. Both of them say that. So to create this, he doesn't know what generally police practices are because he wasn't trained on them, it's just a fallacy because it's one and the same according to GRPD. But the other example is Officer Beatty. Why couldn't he talk to the officer? I got better things to do. He doesn't want to talk to an officer to give him, I'm not disputing. That's not a dispute. Yeah, when you use deadly force, that's what's trained. You use deadly force, you're going to shoot to kill. They're not going to try and shoot an arm off. They're not going to try and shoot a foot. That is. Why do you want to talk to the detective about that? And so he trains. He was part of his recruit class. It's somebody in-house. You can't ask somebody in-house to be completely impartial and unbiased when you ask them to do stuff like that. But when you look at it, when you think about it, when you try and compare in terms of what's going on between these experts, compare the experts, what about Sergeant, I think it was Johnston, the first sergeant on the scene? Let's remember his testimony. Remember what he said? Did he or did he not sound like Seth Stoughton? Because he was worried. He said, yeah, we pulled up. I couldn't see inside that car. I didn't know what was going on in that car. I didn't know what the individual that was standing outside the car had. He could have a gun. That's what we teach. We don't know what's going on. I mean, that's the thing. He's got 3 officers at the time all with handguns drawn, and watch the body cams, how carefully they approach that car, because they don't know. That's what they're trained. So it's kind of a contradiction in terms to say, yep, it's okay for a single officer all by himself to run after and chase and tackle somebody, which flies in the face of their policies that says don't do that you saw. That's a big difference there. How can you change, if they're treating everybody, 3 officers on scene being that careful, why is 1 officer all by himself, that's okay, that's fine. And so it's not distraction. So what is the purpose of the reasonableness of the officer's actions when you're looking at the totality of the circumstances? If it's just as many times as you snap your hands, there's no totality of circumstances. It's just looking at that moment, period. And what's the purpose of the totality of circumstances? Looking at how the officer got into that situation. There is no purpose. There is no totality of circumstances. Well, he was, somebody had a taser, he can shoot him. And the interesting thing was, because who did they say? Who did he say? Well, Professor Kroll. Professor Kroll is the one who said, oh yeah, they're able to use deadly force because he did that study. Professor Kroll isn't a taser expert. He has no idea of police policies. He said, that was his testimony, it was his impression of police policies. Because they can't bond claim, the GRPD officers, nobody can say anything about what the taser policy. There is no, take a look at all the policies, take a look at the policy where it says, if you're just starting the taser, you can use it. You can shoot them. Because it's not there. There is no policy. It's based on the totality of the circumstances, based on everything the officer knew at the time. And what the officer knew at the time goes back to when the incident started. The whole thing, not just looking at that one brief second. And why would a reasonable officer, when there's been no aggression, there's been nothing, no punching, no kicking, no hitting, no anything, think he was going to die because somebody had his taser? That's what's not reasonable about all this. And you're right. You're right, manslaughter is going to be brought up. And it was a complete misstatement of the law to say, well, the manslaughter is not an intent to kill. That is not the law. Listen to the instruction. It is an intent to kill. The traditional manslaughter thing is when a spouse shows up and sees their spouse in bed and loses it. That's your typical manslaughter. You lose it and they want to kill them. It's not, well, they got no fight. A manslaughter instruction is because of emotional excitement. Because of emotional excitement, somebody who's driven to kill somebody. That's what we're talking about here. It is not just, well, there was a fight they didn't need to. That's a completely different thing. Manslaughter, listen to it. And because of emotional excitement to the point a reasonable person may have acted in impulse. And if anything, that's what their experts are talking about. That's what their experts bring up. Yeah, Professor Blake. Yeah. Heuristics. Heuristics. And I said, heuristics. It's kind of, putting in layman's terms, that means jumping to conclusions. And that's it right there. He doesn't know why he's running, so he jumps to a conclusion. The defendant jumps to a conclusion. Well, there must be something worse here. There must be something worse here. I'm going to jump to the conclusion and think it's a bad thing. That reduces it, so it's justified, excused, it reduces it to a lesser crime. Manslaughter is a lesser crime, so if you think this fight, if you think this battle, you need to characterize it as a battle, because what it is a wrestling match. And that's in the totality of the facts and circumstances. How does somebody want to kill you when they don't do anything else before that? How do they want to kill you? What evidence do they want to kill you? He grabbed my taser, and I'm tired. That's not enough. That is not enough to justify taking another person's life. And watch the video. Yeah, take a look at the video. Yeah, he stands up 3 times, but at the moment he goes to push himself up, the defendant shoves him back down. He shoves him back down. He's got total control over this incident. So to think that he has to kill him at that moment is just wrong. It's not reasonable. Yeah, no reasonable officer would come up with that. Yeah, why? No idea why it's so far. Where's the fight? It's not a fight. It's a wrestling match. I thought the other thing that was, interesting about, GRPD puts the fear of God. Puts the fear of God about tasers. Yes. Watch that video. Watch the graduation video. This is the graduation video. So the fear of God, you put that's a serious weapon, but the fear of God in an instrument that you put the soundtrack to Top Gun to in a graduation video, and take a look. Get a closer look. Look at the smiles. Look at the smiles on all their faces. Yeah, they're kind of, somebody's going through it again. It's taking the ride. We're talking about taking the ride. Yeah, it's a serious weapon. but it's not a weapon that's going to cause death or great bodily injury. That's not putting the fear of God into him when you put it to the soundtrack of Top Gun. It's not putting the fear of God into him when you're sitting there smiling at him, smiling at somebody getting tased. It's something you're concerned about, sure. But this whole thing in terms of distractions, it once again is amazing now, because now we're saying don't ignore the defendant's prior statement, ignore it, because it was just a police report. What we heard on the stand, and we couldn't trust his testimony on the stand either. Why? Because, Mr. Dodge asked him, well, it's been 3 years. There's a lot going on in those 3 years. You've been through a lot of trauma. So you can't really believe his testimony by his own, attorneys asking him questions, but then you're also not supposed to pay attention to his written statement, so how do you determine what it is? I think you gotta take it. That's what the statement's there for. Compare. Compare what the differences are. Take a look what it is. Take a look. Where did the bladed stance come from? Because that's what it says in his written statement. Where's the bladed stance? Because we heard what the bladed stance was by Captain Sidebar. The bladed, somebody may have a gun. That was a bladed statement. No testimony to that. It was in his written statement. And then I didn't ask him questions. Well, show us the bladed stance. Well, it's a different perspective. You really can't see. So, what we're trying to do is trying to build up the danger of Patrick. Trying to build him up. He had a bladed stance. It was dangerous from the get-go. Well, then if it's dangerous from the get-go, why are you chasing him? And that's part of the totality of the circumstances. You think you may have a weapon, you shouldn't be chasing him. That's what GRPD policy says. It's a bad idea to do that. And you got to take a look at everything that led up to the decision to fire that shot. And simply getting up is not enough with the taser. He has gotten up 3 prior times and has done nothing. Has done nothing other than try and get away. But you're supposed to jump to the conclusion, using heuristics, jumping to a conclusion that he's going to kill you. That is not reasonable. It may reduce it. Maybe it's manslaughter, but it doesn't excuse it. It doesn't say, yep, go on away. You did nothing wrong here. So when you're looking at everything, yeah, it's a big decision. But a reasonable doubt, you'll hear, I've talked about it before, a reasonable doubt is a fair, honest doubt. But it leaves you firmly convinced. Firmly convinced based on the evidence. Based on the evidence that's presented here. And when you look at this, when you look at the facts, when you look at the evidence, you should be firmly convinced that there was a homicide here, there was a murder. It was second-degree murder. It was a death caused by the defendant. He intended to kill, and there is no justification for it. Simply having a taser with nothing more does not think, well, I'm going to die. We've had all kinds of people up here saying, yeah, we survived, we got tased numerous times, Line King got tased in the head, he's still talking about it, lasts about 30 seconds. And even in terms of you want to talk about reasonable, yeah, use their expert, use Professor Kroll. It's never happened, it happened in the history of policing, where an officer's been tased, disarmed his weapon, and killed. And it's his impression that because they kill. But the one thing where he said is it's happened 9 times where a person's actually been tased, an officer's actually been tased, but in the other case, the majority of the time, nothing happens. But they want to, every possibility considered, you have to consider what's reasonable. If you have a reasonable doubt, then he committed the crime of homicide. At best, he committed the crime of manslaughter, but he is not justified. He is not excused. Patrick is not a threat. Patrick meant no harm. Patrick wanted to get away because he was drunk or whatever. But the only logical conclusion you have is you find him guilty. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements, arguments, and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of any evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or Did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You have heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard from several expert witnesses. Zachary Batchelor has given you his opinion as an expert in the field of video technician and audiovisual analysis. Dr. Stephen Cole has given you his opinion as an expert in the field of forensic pathology. Brian Childs, who has given you his opinion as an expert in the field of Taser and bodycam by Axon. Seth Stoughton, who has given you his opinion as an expert in the field of use of force and police practices. Nicholas Bloomfield, who has given you his opinion as an expert in the field of police practices and use of force. Captain David Siver, who has given you his opinion as an expert in the field of GRPD training policies and procedures. Captain Chad McCursey, who has given you his opinion as an expert in the field of GRPD training policies and practices regarding Taser use of force and duties and functions. Lon Bartel, who has given you his opinion in the field of exercise, sports science, and exertion and exhaustion factors. Dr. Mark Kroll, who has given you his opinion in the field of operations and effects of electrical weapons. Bob McFarland, who has given you his opinion in the field of video analysis. Jason Getty, who has given you his opinion in the field of GRPD firearm training policies and practices. David Blake, who has given you his opinion in the field of human factor psychology and police practices. And Von Kleem, who has given you his opinion in the field of police practices, tactics, policy, and use of force. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they gave for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial a witness made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. The defendant, Christopher Schurr, is charged with the crime of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya. That is, that Mr. Lyoya died as a result of a gunshot wound from a gun fired by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The prosecutor must also prove beyond a reasonable doubt the crime occurred on or about April 4th, 2022 in Kent County. You may also consider whether the defendant is guilty of the less serious crime of voluntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya, that is, that Mr. Lyoya died as a result of a gunshot wound fired from a gun by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the defendant caused the death without lawful excuse or justification. The crime of murder may be reduced to voluntary manslaughter if the defendant acted out of passion or anger brought about by adequate cause and before the defendant had reasonable time to calm down. For manslaughter, the following two things must be present. First, when the defendant acted, his thinking must be disturbed by emotional excitement to the point that a reasonable person might have acted on impulse without thinking twice from passion instead of judgment. This emotional excitement must have been the result of something that would cause a reasonable person to act rashly or on impulse. The law does not say what things are enough to do this. That is for you to decide. Second, the killing itself must result from this emotional excitement. The defendant must have acted before a reasonable time had passed to calm down and to return to reason. The law does not say how much time is needed. That is for you to decide. The test is whether a reasonable time passed under the circumstances of this case. The defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. You may return a verdict of guilty of the alleged crime, guilty of a serious crime, or not guilty. The defendant claims he acted in lawful self-defense. A person has the right to use force or even take a life to defend himself under certain circumstances. If a person acts in lawful self-defense, that person's actions are justified and he is not guilty. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. At the time he acted, the defendant must have honestly and reasonably believed that he was in danger of being killed or seriously injured. If the defendant's belief was honest and reasonable, he could act immediately to defend himself, even if it turned out later he was wrong about how much danger he was in. In deciding if the defendant's belief was honest and reasonable, you should consider all the circumstances as they appeared to the defendant at the time. The relevant consideration is not what the defendant should have known or done, but rather what a reasonable officer with the knowledge and in the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. Reasonable is that which an ordinary, prudent, and intelligent person with the knowledge and in the situation of the officer would have deemed necessary under the circumstances. A person may not kill or seriously injure another person just to protect himself against what seems like a threat of only minor injury. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all the circumstances, the condition of the people involved, including their relative strength, whether the other person was armed with a dangerous weapon or had some other means of injuring the defendant, and the nature of the other person's threat. At the time he acted, the defendant must have honestly and reasonably believed that what he did was immediately necessary to prevent death or great bodily harm to himself or others. A police officer in defense of himself or others may use that force which is reasonable under the circumstances. Unlike the private citizen, a police officer, by the necessity of his duties, is not required to retreat before a display of force by his adversary. If an officer is authorized to arrest or detain someone and the person resists, the officer is entitled to use a reasonable amount of force to overcome that resistance. Like the private citizen, a police officer must reasonably believe himself to be in great danger and that his response was necessary to save himself from that danger. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt the defendant did not act in self-defense. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room to deliberate, you may now take your notes and these full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you will be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing to my clerk. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. That concludes my final instructions. We'll now pick 2 individuals that will be alternate jurors. So what that means is for today, you are excused. However, you still have the same restrictions as before. I'm going to ask those 2 individuals to leave your notes in here on the chair, and we'll make sure they're destroyed in the event that you're not needed as an alternate juror. But it's still for you, again, to maintain the restrictions as before, not access any news reports or discuss the case with anyone, because if we need to call you back as a juror, obviously if you've been out posting on Facebook about how you were a juror and all that, then you wouldn't be much use as a juror in the case. So those 2 individuals will still be, again, under the same restrictions, and then we will follow up and let you know when a verdict has been reached so that you know that you are discharged, whoever those two people are. And I'd also like to take this time to thank those two individuals for your time and attention for this case.
Seat number two, 120.
Just because we're don't say the person's name, just say that the seat number.
Seat number two.
Yes. Seat number 2?
Correct.
Okay. And
Seat number 1.
okay. So 1 and 2 would be you in the first 2 seats from the corner. And again, thank you very much for your time and attention, and we will let you know when a verdict has been reached so that you know that you're discharged. But if you just hang out for
Good afternoon. You have just seen closing arguments in the case.
All right, hold on. Let me see if I can get another feed. Let's see here. Hold on. All right, hold on, guys. Hold on. All right, hold on.
Seat number 2, 120.
Just because we're don't say the person's name, just say that the seat number.
Seat number 2.
Yes. Seat number 2?
Correct.
Okay. And
Seat number 1.
okay. So 1 and 2 would be you in the first 2 seats from the corner. And again, thank you very much for your time and attention, and we will let you know when a verdict has been reached so that you know that you're discharged. But if you just hang out for just another moment, then we'll send everyone back. Okay, so please raise your right hand. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they've agreed upon, so help you God.
Yes, I do.
Thank you. All right, so at this time, I'm going to have someone come out and let you all out to go and begin deliberations. Any breaks will be on your own. If you do decide to leave for an extended period, I do ask that you have your foreperson just write a note that, hey, we're taking an hour break or however long, but that's all entirely up to you as a group. Okay.
Thank you. You may be seated.
Okay, and then I'll ask if the final instructions were satisfactory for the people
No objection, Chair.
and defense.
Other than those objections already stated, Your Honor, they were met correctly.
Okay. And so I would just ask that you make sure that we have your contact information so that we can alert you once a verdict has been reached. I also, because I know that you didn't want to do oral argument on these motions that I received this morning after I arrived at court, but I do want to rule on them. So as far as the directed verdict, I've already ruled on that motion. It's a renewed motion. There's really not any new information contained within it, so I'm maintaining my previous ruling of denying a motion for a directed verdict. Also, there was a renewed motion for a mistrial, and part of, it's pretty much a run-of-the-mill except for the claim of judicial bias. There's an allegation contained within the motion that I was rolling my eyes during some testimony. I can't help but believe if one of my benchmates were presiding over this trial, that exact same allegation would not have arisen. However, I obviously don't, well, maybe it's not obvious, but I'll state for the record that I don't know the defendant. I don't know the victim. This is at least my 10th, 11th, maybe 12th murder trial. I do oftentimes work on other matters while I'm up here. I have hundreds of open cases. So I don't know where that implication of bias comes from. I do note that one of the cases that were cited as support for that portion of the motion involves a case where the judge in that case inappropriately questioned the defendant, questioned the defense's witnesses. I didn't obviously question anyone except for maybe asking for some type of clarification. And so it would have to, again, in order for there to be judicial bias, it'd have to be reasonably likely that my conduct is improperly influencing the jury, and I don't believe that to be the case. Also, there was a claim that the instructions have changed over the course of the trial. I've only given instructions to the jury at the outset of the trial and at the end of the trial, and the implication is that I gave some different instructions or changed them midstream so that no one knew kind of what to expect, but I don't believe that to be the case either. I never changed instruction. It implies that different instructions were given. I was reluctant to state what the final instructions would be without any evidence being put on or presented. There weren't any interim instructions requested, so I don't believe that to be a appropriate or an argument that has any merit either. So for those reasons and the reasons I cited previously, that a mistrial, most mistrial would not be appropriate to grant, I'm going to stand by that and deny that motion as well. And if there's nothing else, for the people while we go into verdict watch.
Nothing much, Your Honor.
For defense.
Nothing, Your Honor.
All right. So again, if you do decide to leave the general area, please let us know so that we are able to get everyone back here in a decent amount of time once a verdict has been reached. Great. We'll recess until then.
All right, we are officially in verdict watch. I have it set, I'm going with 12:45, so we are officially in verdict watch. If you haven't had a chance yet, take our poll. How do you think the jury will vote? And then I'm going to close that poll, and I'm going to say how long do you think they'll take. So I'll give you a minute or two to go through and answer that question. If you're new, if you haven't had a chance to answer that, boy, there was a lot. There was a lot that happened. Holy smokes. All right, we did take a couple votes. Did the state meet their burden of proof and is Schurr guilty or not guilty? So not guilty, did not meet the burden, 78% felt that. Guilty, met the burden, 21%. Now that was based just on the evidence alone. Then we had 43 votes, should law enforcement policy change regarding tactics, meaning chasing, foot pursuit, shooting, all that. 72% of you thought yes, 27% of you thought no. So then the prosecution asked the judge to include a lesser charge, which was voluntary manslaughter for the jury to vote on. That's what happened when they were at break, and we didn't see that. Schurr will likely still face jail time with a maximum of 10 years. So that's what he's up against now, if they go that route. Voluntary manslaughter means a person deleted another person unlawfully but without premeditation. So that's that passion of crime, crime of passion, when you get all heated up and you delete somebody you didn't mean to do it. The defense argues to deny this charge. The judge rules that this charge can be allowed. All right, so I'm going to go ahead, since they're in verdict watch, I'm going to end this poll that we currently have going right now. So out of 51 votes, let's do this one. All right, so 51 votes. How do you think the jury will vote? Not guilty, which would be second degree. 56% of you thought not guilty. 31% of you thought guilty, but with the lesser included, so that's voluntary manslaughter, 31%, and then 11% straight out thought that Officer Schurr is guilty. All right, now I'm going to do a new poll. How long will they take? How long will they take? Oh, come on. Oh, why isn't this working? Okay, hold on. Let me do this again. All right. How long will the jury take to deliberate? All right, we're going to go 0 to 2 hours. 0 to 2 hours. We're going to go 2 to 4 hours. We're going to go 4 to 6 hours. And then I only have those 4 options, so I'm going to go hung. Well, should we do hung already? Because she's going to send them back. All right, let's go 6 to 8 hours. Because that basically is going to take us to the end of today. All right, so 0 to 2, 2 to 4, 4 to 6, 6 to 8. Those are the only options I have. And then tomorrow, if they're still deliberating, we'll get into the hung aspect. All right, so new poll. New poll for you guys. How long will the jury take to deliberate? 0 to 2, 2 to 4, 4 to 6, 6 to 8. All right, so let me go through. Okay, so we heard the state's closing. Not really much that we really heard. Didn't really hear anything spectacular. Patrick wasn't a saint. He was drunk driving without a license. He was exhausted. So Schurr was exhausted and alone. He felt outnumbered. Schurr knew about the plates and not the ID. That's why he chased after Patrick. If you're getting tired within 1 minute, maybe GRPD should rethink chases. Definitely throwing some shade there on him. Generally accepted police practices. He talked a little bit. Patrick just wanted to get away. He wasn't a threat. Then the defense closing. You're not going to decide on whether Schurr was justified. You're not here to judge GRPD. I'm sorry, you are here to decide on whether Schurr was justified. That's all they're here to do. Was Officer Schurr, Mr. Schurr, justified? You're not here to judge GRPD policies. Or whether he should or shouldn't have given chase. That's not what they're here for. They're just here to, was he justified? Did you have reasonable fear of deletion or great bodily harm at the moment of the threat? That's the crux of it. Did he have reasonable fear? The state has failed miserably and look at just the case he put on. So he's definitely throwing shade back at Mr. Becker there. They didn't even meet the burden. How can you convict somebody when their own experts disagree regarding fear and reasonable? Stoughton said Patrick hadn't punched him yet, so no reasonable law enforcement would expect Patrick wouldn't use it, that Patrick would use the taser. He followed his training. I think that's for me. I would just keep going back to them. Like, he followed his training. This isn't about, I mean, it is obviously in in the immediacy, yes, Patrick lost his life. Schurr caused that. That's terrible. We have to address that. But to me, it's a larger, wider problem going on here, in the sense of, and is it a problem? I don't know. That's not for me. But that's the debate I think should happen at the legislation point of or the training part. I mean, he was literally trained to do this. He's trained to do this. No, he didn't wake up and say, oh, today I'm going to go, shoot somebody. But this is what he's trained to do. He's trained to use a firearm that will end your life. So to me, that to me right now seems to be the greater debate we have to have here. Let's see. He followed his training. Law enforcement don't have a duty to retreat. So then there's that. Again, they're supposed to run towards danger. They're not supposed to run away. The general public is, we are not supposed to run towards danger. I mean, people still do, but Schurr put himself in jeopardy because that's his job, right? That is his job. You have to be sure that Schurr was not in fear of great bodily harm or deletion to convict. So you have to be sure that Mr. Schurr was not in fear of great bodily harm or deletion to convict. So that's what they have to do. They have to get inside Officer Schurr, Mr. Schurr's head, and was he not in fear for his life? Then she talks about, then the defense, this is still defense closing. Separate jury instruction on manslaughter, lesser included. You know the state has a weak case. He literally said that. You know the state has a weak case if they wanted that included. That's a heat of passion, and that's not this case. If you find the state hasn't met their burden, then you must reject both. If you can find any sliver of reasonable doubt, then you must acquit. And right now, I definitely have reasonable doubt. So I guess I would lean towards acquitting. As much as that pains me for Patrick's family, but he was just doing his job, right? I mean, that's to me is the bigger question here. We ask you to judge on the decisions to shoot and not all the noise around it. So this isn't the M word. Then the state rebuttal closing came in. He talked about being impartial and being unbiased. 98% of the time, law enforcement is okay in their actions. 98% of the time, he's like, what other industry sector is able to say that? One of the dumbest questions oozes out of his pores regarding MMA. That was Bartel. Again, he's throwing some serious shade. How do you judge someone you know and train? So he's talking about why, I think we kind of brought it up in chat. Why did the state not have anybody from GRPD? Why? The only person that they had on law enforcement was the Michigan State officer. That was the only person. All right, hold on. Did they, are they still live? I guess they are still live. All right, I'm going to go over to this other channel. Sorry, I'm just going to come over here. I'm going to go back to the talking heads. All right. We'll go back here. All right, so let's continue on. So the state's rebuttal, how can you judge someone you know and train? So that he's going back to, that's why they didn't have any of these GRPD officers. It was the only person that testified for the state was Michigan State Police. And we found out from him that anytime there's an officer involved shooting, they bring in Michigan State. Let's see. How can you come in and say you're impartial? Law enforcement, they aren't trained to shoot an arm or a leg, so you can't ask someone in-house to come in and be impartial and biased. You just can't. And he likened it to a bank. If a bank has been, if there's fraud in a bank, you can't bring in people to testify. You have to bring in outside people. Let's see. So then we get to jury instruction. So Judge Mims talks about second degree. So it's to make this, to find him guilty, to find the defendant guilty, caused the deletion as a result of the gunshot, and it was intended, great bodily harm, and then knowing it caused it by his actions. So that it was intended, that he caused great bodily harm, and that he knew that by doing that, his actions, he knew that he would cause that. It's not justified for it to go to a lesser crime. It's not justified. So voluntary manslaughter then caused the deletion as a result of the gunshot. It was intended, great bodily harm was caused, and then knowing caused it by his actions without lawful excuse or justification. So without lawful excuse or without justification. If Schurr acted out of passion and before he could calm down, that's the voluntary, I should say, emotion. So then she talks about emotion was disturbed or excited. The deletion must result from this action. All right, so that's pretty basic. You get in the heated argument, road rage, or something like that. The defendant acted in self-defense. She talks about that. She says it's not up to the jury to decide the penalty. That's up to her. That's up to her up to the judge to hand out the penalty. They are to choose a foreperson. Then she picked the alternates, and she says, she told her law clerk, don't say their names, don't say their names. But it was seat 2. Sorry, it was seat 2 and, well, seat 1 and seat 2, but it was seat 2 first and then seat 1. And then I have verdict watch officially starting at, oh, here, you know what? I should do this. Oh, wait. Yep, let me get rid of that. All right, so verdict watch started. Verdict watch starts at, I'm going with 12:45 Eastern. Verdict watch starts at 12:45 because it probably took them a minute or two to get back. Now remember, we're 30 minutes behind, so I'm just basing that on my, so it probably truly is 12:15, but I'm basing that on my clock. Then the judge came out with, she denied the directed verdict and the mistrial. So these were motions that were filed. So she talked about judicial bias, and I thought it was going to be the state or something, but no, she says that she was, well, this motion claims that she was rolling her eyes. Yikes. Some of you picked up on it that she should be paying attention, but she explains why she wasn't paying attention, because she was working on other matters. She's like, well, I don't know the defendant and I don't know the victim. She's working on 12, or she has done 12 murder trials, and she works on other matters while she's up here. So she's got hundreds of cases. So that's what, she wasn't necessarily paying attention to their closing. She was, hold on a second, she was working on other matters. Ooh, that's a good one. Let me grab that one. Let's see. Charges. She says, not sure what the implication of bias comes from. So she was a little tweaked over that. I can understand that. Her conduct was not influencing the jury. Instructions have changed, and I only gave them at the beginning and at the end. Implication is I did that, but she doesn't believe that that was done. All right, so let's pull up the charges. This is his second degree. Let's kind of go through some, let's see. Where did I put it? Charges. All right. All right, so it's charged with second degree. It's defined as a passing caused by an act of the defendant with malice. Act causing the passing is without justification or excuse. Schurr's defense is arguing he was justified through self-defense, punishable up to life in prison if found guilty. Shirley Roth, no officer wants to delete anyone, but when it's the last choice, he has to do what he must do, even though it's never a good outcome. Most of these cases are done internally. They never go to trial. That is true. Drunky the Bear, you were on a federal jury, and after the verdict, we jurors had to come back to testify against the U.S. prosecutor, and we even had the FBI at our houses. Wow. Wow. Let me see. Yeah, Ken, that's wild. Widespread. What? All right, let's get to it. Yeah, deets. Let's see. The prosecutor planted evidence in the jury room, and some of us jurors told the judge after we realized it. Wow. Widespread panic. I don't think the prosecution proved malice in the least. Well, there's your reasonable doubt, Widespread. There's your reasonable doubt. Drunky says, but after we all testified, the prosecutor was found not guilty because no one saw him do it. Interesting. Lily Wayne, but shouldn't she pay attention to closing in case of appeal or just to appear interested in the whole case? One would think, especially if there's an objection. I would agree with you there, Lily Wayne. I would want to pay attention, but that's just me. Yeah, that is a good story, Ken. Good on you guys. Yeah, what a story. That is crazy. Oh, Drunky, it was insanity. We were given the diary of the victim. Interesting. Wow. I've never served on a federal trial, just local. So I've told you guys about that civil and criminal. But that was in New York City. I've been called twice in Florida, at least twice that I can remember. Did not have to serve. Got kicked out both times, meaning one time I just sat there. The other time they chose people before me, so I did not have to serve. All right, so that's what he's charged with. All right, and I have decided that I'm going to, Aaron put together Slim Pickens, and I'm going to pull him out at the end of the day. So we'll do that at the end of the stream. All right. I should probably get some food. Right? This is probably a good time to get some food. Let me see what they're saying in the court. Let's see. All right, so they have 12:41 jury deliberations begin. I have 12:45, so close enough. All right, so 15-year max. The lesser manslaughter would be 15 years. So 15 years is the max. So voluntary, involuntary. Oh, it's involuntary. So they changed that. It was voluntary. Now it's involuntary. So it's involuntary. Now earlier they said it was voluntary, so that's my bad. Okay, so they wanted to put voluntary manslaughter on, but now it's involuntary? So she's changed it. Or else somebody's typing in wrong on this site. All right, I'm going to go with what they say, involuntary manslaughter. Let's see, 15-year max. So earlier they said they posted voluntary, now they're saying it's involuntary. I don't know. I heard voluntary. I think maybe that's a typo. So, all right. Yes, Trial Junkies United. Good. I'm glad Ken stopped in. I tried to do rewatch, but if you guys don't know, Trial Junkies United has shows on Thursday, right? Thursdays and Sundays. So definitely go check them out. Her and Doc put on some really great content, so definitely go check them out. And also check out Joe Schmo. We had a good conversation with him yesterday. He's going to the Brandon Boudreaux, Lori Daybell trial in June. So we had a good jam session with him. Looking forward to covering that as well. All right, Ken, the idea here is that justification or excuse can't exist at the same time as malice. Gotcha. From a footnote in some document in this case, the malice element requires also on the negative side of the absence of any circumstances of justification, excuse, or recognized mitigation. Julie, your husband sat on a jury in a federal case in New York City for 4 months. It was a mob case. Wow. Yeah, Aaron's dad did one in Buffalo. He sat on a mob case. A grand jury though. He was a grand jury. Julie, I didn't know what it was about and freaked out after I found out it was a mob case. Right? Gulp. Processing is taking forever? I don't understand that. Processing what? Objection! Trial Junkies United. I don't understand that. What is taking forever? Julie, of course I had no idea while it was going on, but after I was so mad at him for not figuring out a way to get out of it. Right? Your cousin Vinny. All right, I am going to go grab some food. Oh, can't wait for the next case. I gotcha. Okay. Gotcha. Yeah, definitely go give Trial Junkies United some love. Got some great stuff happening over there. All right, I'm gonna play some music for you guys. Do I have? Why don't I have music? Oh, there it is. Okay. All right, I'm gonna go grab some food. I definitely will have an eye out for everything, so we will be, we're on verdict watch for now, and I guess they're still gonna be 30 minutes behind, so that's gonna be weird. No spoilers, but we'll keep an eye out.
Zimbabwe, Nagala to show 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 Zimbabwe. Did
Hey guys, thought I'd just pop back in real quick, see how everyone is doing. Missy Russell, your allergies are kicking your butt. That stinks. What kind of allergies do you have? Seasonal, I hope. JWDMG, how are you today? And yes, this was one emotional case where I think I really took it to heart, as well as many others. Absolutely. But through it all, we stuck together as a group, no matter what, and that really matters. I agree. Only fan, you think a verdict by the end of today? If you haven't taken the poll yet for how long you think they'll take, 0 to 2, 2 to 4, 4 to 6, and 6 to 8. And they started at 12:45 Eastern. So they've already been at it in 1 hour. So they've already been at it for 1 hour. Oh, not good, not feeling well. I have a micromanager that's been abusing me at work with his power trip. That stinks. And didn't something happen to you last week with your foot or something? Your leg? Please refresh my memory about that. Allergies are hitting hard. Oh, pine trees. Wow. Yeah, in Washington State, you're allergic to pine? Oof. Is it the sap or is it the pollen? I guess it's the pollen, probably. Missy. Is it the pollen? Ken says, if I had to guess, you'd say tomorrow afternoon. I have had enough of it. Now I'm taking him to court. Wow. While being at the job, I'm in the process for looking for another one. Wow. Well, good luck for you. Good luck on that. Good luck to you, I should say. Wow. Sorry to hear that. You spend so much time at work, you know, you have to be happy, right? If you're not happy, oof. And then you get abused on top of it. That stinks. So we think we found a new trial for you guys. I forget who said it in the chat. Somebody, oh, I remember, Katya. So we'll thank Katya for this one. Aaron's putting it together right now. So it just started today. So we'll do what we did for Monica and Lori. We'll do verdict watch on one computer and we'll start streaming another trial on another computer. So we'll pick up on that tomorrow. It started. It's going on right now. It just started. So we'll pick up on it tomorrow. Hey, yeah, Shirley. There's always new trials. You just have to wait long enough. We were ready. We have a good one for a rewatch. I worked on it yesterday. It's all ready to go. So if we ever need a rewatch, we'll do that one. But it seems like every Monday there's always a new trial. Yes, Golden Girl. It is the California case. So right now, Julie, it's let's see. I can read you some preliminary stuff about it. Let's see here. Hold on. Hold on a sec. Just give me a second. All right, so it's Carlos Dominguez. He's a former UC Davis student. He's stabbed David Bro and Karim Abu Naj. I'm sorry, I'm going to really butcher that name. He was academically dismissed from UC Davis shortly before the stabbings began. So, okay, here, cool. All right, Aaron sent me the link. All right, so let's see. California versus Carlos Dominguez. He was born in El Salvador. He came to the U.S. as an unaccompanied minor in 2009. He grew up in Oakland, California. He graduated high school in 2020 with a 3.8 GPA. Yes. Oh, tinnitus in your shoulders to the elbow. That's what it was? Okay, I gotcha. Yes, Selena, we are in verdict watch. They went out at 12:45. 1:15. I got 12:45, Ken, but that's what I have. Oh, they're an hour and 15 minutes. Okay. Thank you, Ken. Yep. Selena, I have it pinned to the top. Verdict watch starts at 12:45 Eastern, so it's pinned to the top. All right, so this new case that we're going to pick up tomorrow, He was a biological science major at UC Davis. He did report, his mental health reportedly deteriorated. His friends and his ex-girlfriend observed behavioral changes, including social withdrawal, neglect of hygiene, and claims of hearing voices and communicating with the devil in his dreams. Yikes. So he was arrested near the scene of one of the attacks after multiple residents reported seeing someone matching the suspect's description. So he stabbed 2 people, and he attempted to stab another person, but she survived. So he's got 2 counts of first degree and 1 count of attempted. I think this is going to be like, they're not seeking the DP. So this is going to be like Chloe Driver. The new name is Carlos Dominguez. I think it's going to be like Chloe Driver, where she admits it, but then she's trying to get by reason of insanity. That seems to be what he's entered. Plea of not guilty by reason of insanity. So to me, this is going to be like Chloe Driver, where he admitted it, and this is, and then he's just going to try and get, instead of just being thrown in jail like Chloe, I hope that they get this guy some help. All right, so the one guy that he stabbed, his name's David Breaux. It's Breaux, David Breaux, or I would say Breaux. He was 50 years old. He was known as the Compassion Guy. So April 27th, 2023, he was a Stanford University graduate who became a well-known and beloved figure in Davis for his mission to spread compassion. For over a decade, he sat at the corner of 3rd and C Streets asking people, "What is your definition of compassion?" He recorded over 10,000 responses in a notebook and published a book titled Compassion, a compilation of concepts on compassion. The city recognized his work by dedicating a compassion bench to him in 2013. Now here's where it gets sad. It was at this bench where he was tragically found fatally stabbed in 2023. In the wake of his passing, the area was renamed Compassion Corner. His sister Maria has continued his legacy, promoting compassion and healing through public events and media. So that's sad, right? Lori got to him. So then the other kid, he was 20, the other gentleman person, Kareem Abu Najm, Najm, Najm. Wow, that's tough for my tongue to wrap around. I'll just go with Kareem. He was brilliant and accomplished senior at UC Davis, majoring in computer science, just weeks away from graduation. Originally from Lebanon, Kareem moved to Davis with his family and quickly became an integral part of the community. He was working on innovative research to help the hearing impaired and was known for his passion for learning and building community through education. He co-founded Cornish, a platform that supported undergraduate researchers and had won multiple awards for his work, including a People's Choice Award from Blackstone Launchpad. Wow. Kareem was biking home from a university event when he was fatally stabbed. To honor his legacy, the city dedicated a bench in Sycamore Park and renamed a nearby bike path. UC Davis also established a scholarship in his name. Now, a survivor, Kimberly Gillory. She was living in a tent at a local encampment. She was 64. This was May 1st of 2023. So she was living in a tent at a local encampment where she was brutally attacked and stabbed multiple times in the chest and abdomen. Despite life-threatening injuries, including a lacerated liver and kidney, she survived and underwent multiple surgeries. She later helped police identify her attacker. Before the attack, Kimberly had lost her daughter to cancer and was facing housing instability. After surviving, she became a symbol of resilience. A GoFundMe organized in her name raised over $60,000, helping her secure stable housing and support. She has since spoken out about homelessness and healing and expressed a desire to advocate for others in similar situations. Wow. This case really sounds interesting. So that's next on the docket. They're saying it's expected to last 12 weeks. Gulp. Well, because there's 3 people involved, I guess. Did you miss a question? No. Mona, I don't think so. Let me just double check, see if anything's going on. Nope. Did not miss anything. Does it start tomorrow? 12 weeks. We may need to zoom once it gets going and other trials overlap. It started today. And it's supposed to last 10 weeks. But they also said they thought Lori was going to last 6 weeks, 6 to 8 weeks, and that only lasted 2 weeks. Yeah, another legally insanity case. Exactly. Yeah, Adelson, Stern, they're postponed. The only thing that would get in our way would be Lori. That one we will definitely stop to cover that one because Joe's going to be there. We're going to have Joe Schmo in our what do you call it? He's going to be at the trial, so that would be the only thing that would kind of derail this one because she's scheduled to start June 3rd. So let's see. 1, 2, 3, 4. Yeah, we'd be in the week number 5 when Lori starts. So that would be the only thing that I think would derail it. Let's see, Ken. However, I don't think California differs all that much from the majority of states, following McNaughton's rule only. Yeah, I want to hear therapist and Dr. Rachel's take on this new trial. See what they have to say. To me, it sounds like it's like a Chloe Driver where they're admitting that they did it, but they did it because of insanity. All right, Baca. Depends on how long you're going to be running errands for, but I think you'll be okay. Ken says, California is an interesting state legally just because of how it developed way faster than the rest of the far west coast. So it's always been a tad different than neighboring states in a lot of ways. Shirley, so much for your hip injections to help pain. Yikes, it has helped me to walk more, but pain is at 30 plus. 30 out of what? What's that? 30 plus? It sounds painful, but what's the context? Is that a 30 out of 10? Or a 30 out of 100? I certainly don't mean to make light of it, but just trying to get a context there. Usually pain level is out of 10, so you're a 30 plus. I gotcha. Ouch. Sorry. And rainy weather won't help. Yeah, do you find that true? Like when it's rainy, does that hurt? Does it help? It probably doesn't help. I can't imagine rainy weather ever helping, but does it hurt? Does it hurt more? Isn't that like arthritis though? Is that considered arthritis when your joints hurt when it rains? Your hip replacement is definitely going to happen at the end of the summer. That's cool. Therapist, you know, it's rainy here too, but it's my most favorite weather ever. I know we talked about this, but moving out west, therapist. Shirley, I have osteoarthritis in the hip. That is why I need it replaced. Gotcha. I worked on a clinical trial for osteoarthritis of the knee. When I was working at a marketing firm with Aaron. I actually won an award for that, for my design work on that. So I can understand. Paul says she means 30 out of 10, it looks like. That's the way I took it as well. Yeah, so that's a little bit over, you're like blasting through the pain level on that one. Yes, I know. No, not Chicago this time. I'd say out west. Go to where it rains all the time. Thank you, Shirley. Yeah, that was fun. I won 2 awards with that firm. That Got Knee Pain was a lot of fun because it was, that's what it was called, Got Knee Pain. And it was with GlaxoSmithKline. Posen was the company, but they eventually they got FDA approval. So they did, it was a clinical trial. That's what this marketing company did. And we had to, they wanted like 1,000 patients for this clinical trial. So I specifically worked on all the print, because that's what I did. I did the print, and then Erin, she was head of the digital media department, so they did like the websites and emails. So I did a poster. I have all this stuff too. I should pull it out at some point. I did a poster. I did postcards. What do you call it? Like direct mail. Follow-up, like letters for the doctors. It ended up being like 20 units or 20 assets, if you will, various assets. I did a sticker. I did the logo, and that won a prize, won an award, I should say, not a prize, an award. So that was fun. That's one that I hang my hat on proudly. If Chris was to go to prison, wonder where they will send him. I can't imagine a police officer ever surviving in a prison environment. The Hubs and I talked about this weekend. He really doesn't stand a chance in prison. Yeah. I would think that the corrections officers would look out for him. And then I would think, I don't know. I would think the officers would look out for him. Right? Lily Wayne, I was thinking about that too. Prison for a policeman is definitely not a safe place. Yeah. Yeah. Yeah, they can't really look out for someone 24/7. I know. Yeah, it's just not doable. I get it. You gotta join a group. You gotta join a group that looks out for you. So they're an hour and a half. They started at 12:45. Now we're at almost 2:30. We just passed the 2:15 mark here on the East Coast. Hey, CE, thank you. Liking and lurking. Appreciate that. Thank you for popping in and saying hello. I always appreciate that. Lily Wayne, there will be time when officers are not with him, and it only takes a few seconds to unalive him. I'm sure he's thinking of that too. Yeah, absolutely. 100%. I'm sure he's got people that want to do him harm even, right now. He's probably got people that are after him. So I wonder if he's going to move or what's he going to do, Therapist says, probably ate some lunch, have to go through all the paperwork, good 1 to 2 hours of admin work, I think. It's interesting, as all the trials we watch, sometimes jury instructions just take forever, and it's like, they've got like 50 pages that they have to go through. It didn't seem like there was that many pages, right? She got through it. Judge Mims got through it fairly quickly. So, right? It doesn't seem like maybe they don't have that much paperwork. I'm just totally speculating, and I'm only basing that on how long it took her to read the jury instructions. It didn't seem like it took her that long. Maybe a half an hour, maybe. Lily, I would expect a jury question or two, not a verdict right away. They have some serious hashing to do, that is for sure. some serious hashing to go through. What's going on there, therapist? Oh, did you hear that? Is that what you... I'm not even paying attention. I was reading through Twitter to see if... trying to find people that are posting. Big truck. Probably big truck, yeah. We have... well, they've been doing road work on our road here. It's not a street, it's a road. The last like 2 or 3 weeks they've been doing repaving it, chewing it up, repaving it. They're not doing it now. They usually do it at night or like 8, 9 o'clock. But we have trucks, yeah, cruising down this road all the time. You hear wind? No, it's probably just a big truck. Lily Wayne, it may just be difficult to get 12 of them on the same page. JWDDMG, he needs to be put on watch if he goes in because suspects in general do not like cops, and so especially when there is one with them. Oh no, that's not going to be pretty. Yeah. You hear a blinker? No, it's probably just a... Yes, you heard it. All right. I'm like, it doesn't even faze me anymore. The street noise. It's funny, like on 3 sides of our property, it's nothing but woods, but then the street street's fairly close. It's closer than I would like it to be, but it is what it is. So that's probably what you guys hear, especially when those big trucks go by and they're downshifting. We also have the people that drive those modified cars and trucks that just make noise for no purpose other than just to make noise. Erin always shakes her fist at one of them. All right, that was just tire noise. People, music, crowd. Well, I do have the music up. Shore Life, I do have the music up, so that I'm hoping you're hearing that. Right? I just have straight up music. I have the music on, and then you're probably hearing maybe some street noise. Judge Mims didn't say how long she was going to give them to come back. I like her, but there's definitely some things that she could improve upon, and that's one of them. I thought the blinker was the beat of the music we heard at lunch. Oh. I don't know. Like, I wish, this is one thing I wish Judge Mims would have said. There's going to be no 30-minute delay, and we'll give you a half hour to get back. I just wish she would have been more attentive. She is very nonchalant. Yeah, I will agree with that. Therapist, she does come across as very nonchalant. So those that missed the unboxing of Slim Pickens this morning, Aaron put Slim together, and we're going to We're going to show show him in his entirety. Do I have So we'll do that after the stream ends. I have no idea how late they're staying either. I want to know when the eye roll was. I know Shore Life, right? She said, let's see. I was eye rolling. I guess it was throughout testimony. She just said, I was rolling my eyes, but I don't know Shore or the victim. Or maybe she said the defendant and the victim. Yeah, I don't know. We did kind of pick up when they were doing their closing that she was doing something else. It seemed like she wasn't paying attention, but she did say that she's done 12 murder trials, and she works on other matters during court. She says she has hundreds of cases that she has on her plate right now. So she clearly is, what do you call it, multitasking. Shirley said, most judges are doing other stuff, like Judge Klein said, but he was more attentive. Shirley, well, got to run to the post office, drop off orders, back in a flash. All right. Have fun with that. Good luck with that. Julie says, in the beginning I had hopes that she would be a good judge, but in the end I did not care for her at all. I thought so as well. I won't go as far as saying I don't care for her, but I've seen other judges that I certainly like more. I did like her, like she was definitely calm, and she was definitely calm and respectful. But I thought she could have been, like Kranick to me he set the bar, right? He definitely set the bar as far as judges. Like, I like Kranick because he asked Sarah Boone, like, every moment he could, are you happy with your counsel? Are you okay with the way this is proceeding? Do you have any changes? Like, he was he explained every step of the way. He just kept explaining. I really like that. Yeah, Ken, I think so too. He was spectacular, in my humble opinion. Oh, you like Lori's judge too, Bereski? Yeah, Judge Bereski. Or the first judge, the first one or the second one? It was Judge Bereski in the Charles Vallow one, but I forget the judge with Chad and Lori. Is that the one you're talking about, or are you talking about the second one? Golden Girl. Lily Wayne, I agree with you. If there had been an objection during closing, would she even know what they were talking about? Yeah, maybe she would just sustain everything. Therapist, I love Judge Kranick. Oh, yeah, he's fantastic. Drunky the Bear, Kranick is my favorite, followed by Panjalangan, Murdoch judge in South Carolina. Yep, he was good too. Bereski, yeah. Yeah, Bereski was good. I didn't Was there anything that, I'm trying to think, anything negative that, I think Joe was saying that he let, well, I guess he didn't let anybody, he let prosecution lead the witnesses a little bit more, but that's not his, I mean, that's not his fault. Yeah. Oh, Daryl Brooks, yeah. Yeah, Judge Newman, yep. Don't do other work if you can't control your facial expressions. It's so unfair to the defendant when it could influence the jury, yeah, and someone's life is on the line. That is true. That's a good point. Yeah, what was Daryl Brooks? What was her name? Let's see. She went on to, let's see. Oh, Jennifer Duro, right? Yep, Jennifer Duro, yep. Judge Duro, yep. Jennifer Duro. So she was up for, she's your girlfriend. Nice. She was up for like Supreme Court in Milwaukee or in Wisconsin, right? Didn't they want her to be a higher, they wanted to bump her up, and I know she ran, and I don't think she, well, I know she didn't win. Let's see. Runs for judge, no, whatever, what was it? It was for the Supreme Court, yes. Did you guys catch that? Yeah, so November 30th, 2022, following the Waukesha Christmas Parade attack trial, Judge Duro announced her candidacy for the Wisconsin Supreme Court. The election was for the replacement of Chief Justice Patience Rogensack, who announced her retirement earlier in the year. I'm pretty sure she did not win. Right? Pretty sure she did not win. She lost in the primary, yeah. Yeah, she was good. I liked her. So she was a Waukesha assistant DA, and then a private practice attorney. Oh, she had her own. It was Huppert's and Duro. So she was part of her own law firm. Yes, she lost. Crumbly Judge. I didn't really watch that case, so I'm not sure. You would love to watch the Book's trials, yeah. That could be a rewatch. Capri, unpopular opinion, not a fan of hers. Can you tell us why? Like, what didn't you like about her, Capri? Was there anything in particular? Her style? Like, what didn't you like about her? Tammy, Brooke so far has been the most unhinged trial I've watched. Yeah, same. She's probably not a fan of yours either. Ouch. Let's see, Lady Crush. Judge Matthews was crumbly. Touche. Capri, can you articulate what it was that you did not like about her? You don't have to if you don't want to, but... Let's see. Yeah, I didn't really watch... let's see. Cheryl Matthews, is that her name? Judge Cheryl Matthews? Is that who we're talking about here? Oh, I remember her. If that's who I'm thinking about. Judge Cheryl Matthews. So you love her in person, but you think she let Daryl get away with too much? Yeah. Didn't like the crumbly judge. We didn't really watch that trial, so I don't have an opinion on that. Nicholas's Cruz judge had to put up with a lot of bad behavior from the defense, and then she stepped down after trial. I did see that. Yeah, I saw that. She was definitely sparring a lot with the defense from what I saw. I did not see a lot of that case, but from what I saw, like in the what do you call it? News reports, because that happened like 45 minutes from where we were. That was down kind of Fort Lauderdale area. We were up in West Palm at the time. Actually, I was driving home. I was working down there, and I was driving home, and I was wondering, like, what is all the traffic? What is with all the traffic? And then I got home, and I turned on the news. I'm like, holy crap. And then I had a coworker who lived right over there. Yeah, pretty intense. Judge Schurr, I'm assuming that's the Cruz. So am I getting vibes for Daryl Brooks as a rewatch? We might do that at some point. Yeah, and Jill, yep. We had friends, really good friends. We're still friends with them, but we've moved away. Their kids went to Marjorie Stonemason. Yeah, to Marjorie Stoneman High or whatever. Is that what it was called? I don't remember now. But yeah, they went to that impacted them really heavily. That impacted them very heavily. Yeah, Julie Parkland shooter trial had you in tears. I have never seen such a disrespectful defense team. And then she hugged the state and family after the verdict in court. They were kind of disrespectful to each other. I didn't watch it, so I can't really opine, but from what I saw, brief clips, they were not respectful to each other. So it kind of went both ways. Did not seem to like there was no love lost between the judge and that team. That is for sure. All right, we're coming up on 2 hours, you guys. It was 12:45. Here it is, almost 2:45. So those that guessed 0 to 2 hours, you have another 4 minutes. %, of you guessed 0 to 2 hours. So 89 votes, 11% guessed 0 to 2 hours. So you're about to be told, sorry. Oh yeah, Judge Segala. Yeah. Lisa, that was a great one. Mathewson, Freak Show husband, did a solid job from what I saw and what he had to deal with. Yeah, he was fantastic. I did like him. And I saw that when it was happening, and then we rewatched that with her. She came on. Ken, I don't know if you were with us at that point. We had Elisa on. She came on the show twice. She came on with Florida PI Sam because Sam was the private eye for that trial, so we had her on then, and then we had her on again. So we've had Elisa on twice. Yeah, that was a good one. Meaning that she came on. It was terrible what he put her through. Lily Wayne, I'd love to see Daryl Brooks' trial. Something else must have been at the same time. All right, yeah, we'll keep that. We'll keep that in in the coffers. I'm sure we could find that. Ken, you should probably be a little more impartial. Their therapist is saying, we watched that and had Elisa on the show. Capri, I should rephrase, I actually was like her biggest fan, but after a while I got frustrated with her over-talking and not just reprimanding him. Fair enough. Lily Wayne, when they brought the Parkland judge's kids into it, she really flipped out. I don't blame her. Oh, I didn't know that. That's pretty dirty. I cannot sit through Brooks again. Subject matter jurisdiction. Grounds. Yeah, I missed all that, unfortunately. It was a good trial. She is such a strong woman. I read her book. She's trying to get her book published. I'm not sure where she stands with it, but she had me read the manuscript. And then she came on and we talked about it. Oh, and then that's what it was. We compared her, Sarah Boone, Ashley Benefield, and Amber Heard. So we played clips from all four, and she came on and she talked about that. Yeah, she's beyond impressive. Absolutely. Yeah, she's like, she had pretty strong opinions about all three of them. And she's like, Ashley Benefield didn't have enough time to build up the resentment that she said she had, right? Because I think they only were married, they only knew each other for like weeks or 5 weeks before they got married. And Amber Heard, she was just like, yeah, that's just complete BS. And Sarah Boone, pretty much what everybody felt, that she was just psychotic. Tammy and KS, how long have they been deliberating? They started at 12:45, Tammy. I have it pinned. I don't know if you're able to go, but if you go to the pinned comment at the very, very top of chat, we started at 12:45. So we, according to my watch, are officially at 2 hours. Now, according to other sources, they say 12:41 they began, but I always like to give the jury a few minutes to go into the back room. So I'm starting it, plus it's easier to remember 12:45. So 2 hours. So those, unfortunately, that guessed between 0 and 2 hours, you are officially out of the running. And only 11% of you said that, so sorry to say you are officially out of the running. They did bring her kids into it, in your opinion. He asked a rhetorical question, what if it was your kids? And she blew her top. She was very emotional, clearly. I see it now. The poll was in the way. Thank you. Yeah, no problem. Yeah, always check the pinned comment. You guys know the deal by now. We try to be as on top of things as we can, so you know. You know the deal. Only fan, I bet they had lunch first. Always, right? Julie Schwartz, Brooks and Boone are two defendants that made me cray-cray. One was enough, right? And we were saying that, Julie, through Sarah's trial. Like, can you imagine if those two got in the same room, or if Brooks was her lawyer? Grounds. Subject matter jurisdiction. Widespread panic. I felt Brooks was crazier than Boone. Yeah, I'll agree with that. Boone was just narcissistic, abusive, and lazy. Brooks was bad guano, cray-cray. Yeah. Ugh, yeah. Therapist, uncontrolled emotions isn't a good trait in a judge, I wouldn't think. Yeah, no, they should be very, very neutral, for sure. Julie, usually when there is more than one count, it takes a while to just get through the charges. Yeah, therapist. Brooks' trial was bananas. 84 charges and took forever with jury instructions. I remember that because she kept repeating the same thing over and over and over. And all she did was change the name, but of course you have to. You can't just say all these people are lumped into this one charge. You have to say their name. Hey Mel, good to see you. Greetings. How is it going out there in BC? Hope you are doing well. We are officially in verdict watch. As I just sit here refreshing Twitter feed and website feed. Let me try over here. Oh, cool. Halley's Comet will illuminate the night sky this week. Oh, that's fun. If you guys are looking for something to do, Halley's Comet is going to be... you don't want to miss the Aquarids? Aquaria. I guess it's coming out of Aquarius, but it's... All right, let's see. Peaks on early morning Tuesday, May 6th, and will be visible across the globe. Very cool. They've been active since late April and will be visible through May 21st. You can expect to see 10 to 20 meteors per hour. So it comes on the heels of the Leonids, which peaked in mid-April. All right, so they're going to peak Monday. Oh, wow, that's now. So they're going to peak tonight, May 5th. All right, so pre-dawn hours. So if you're getting up at 4:30, 5 o'clock, definitely go check them out. Let's see, where do you look? Trying to find out where to look. Pre-dawn hours, I'm guessing just look up. Let me just see. Okay, I guess you just look up. They're best viewed for pre-dawn hours. So the moon will set around 3. So if you guys are up, go check it out. Tammy, I won't see the comment here. Cloudy, rainy. Well, it's a meteor shower, but yeah, so it's. Okay, and we had split instructions. Yeah, so the instructions we heard might not technically be all of it. All right. Well, Mel, I'm glad that it's going forward, right? Your spine is talking back to you. Yeah. Good, yeah, good weather, good. So yeah, go check out the meteor shower from Halley's Comet. That's tonight. All right, that's not telling me anything. Jenny, I've never been lucky enough to see meteor showers in West Virginia. Is that because of light pollution or... Drunky the Bear, nothing in any trial ever was more shocking than Sarah Boone forgiving, I like to say Jorge, but George's parents and everyone else. Yeah, that was pretty... Yeah, Brenda, this might take a while. I agree. Mel, hello, dear friends. You're very happy to be with us. Thank you. Very happy to be here. I hope everyone had a pleasant weekend. Yeah, it was pretty good. We got together with Joe Schmo again, talked to him, and solidifying him going to Lori Daybell next month. Well, I appreciate you guys being with us. I don't want to play something else because I'm afraid as soon as I start to play something, they're gonna kick in. That's always the fear with going and doing something else. Okay, so for those that came in new, I think Mel, you might be. I don't know if you heard. We're going to start a new trial. It starts today. Yes, Lori Daybell and Charles Vallow 2.0. Jenny, not sure why I can have a clear sky, people 20 minutes down the road see them, but I can't sit outside for hours and not see them. Oh, you can sit outside for hours and not see them. So, yeah, okay, so Katya, I'm going to give this one to Katya. She asked if we were covering this trial coming out of California, and we looked it up, and it does looks sad and interesting at the same time, as most trials do. It's Carlos Dominguez. So he went to UC Davis, and he stabbed two people, actually stabbed three people. Two of them passed away. But he's basically saying he did it. It's kind of like a Chloe Driver, where he said he did it, but he wants reason of insanity. Smart kid, 3.8 GPA in high school. He went to UC Davis. He was studying biological science. He was football and track. He was aspiring to be a doctor to help people like his grandmother who had type 2 diabetes. Right? Seemed like a really good kid. But then his girlfriend at the time started to notice behavioral changes, including social withdrawal, neglect of hygiene, claims of hearing voices, and communicating with the devil in his dreams. So he was dismissed academically from UC Davis April 25th, and then he went on to stab three people, and he deleted two of them. All right, Tammy, go, run. We'll be here. And don't forget, we're going to have Slim Pickens. We're going to unveil Slim Pickens. Aaron put him together. So I'll pull him out after the stream tonight. Mel Stoller, please note that I really appreciate you and everyone here. This is a place where I feel at home. Oh, well, thank you, Mel. I'm glad that you feel like that, and I'm glad that we can provide that. Appreciate that. And I always say, it's you. You guys are what makes this chat what it is. So pat yourselves on the back, and you guys make the chat what it is. So thank you. Well, Capri, we just did the unboxing. We did the unboxing today. We're going to reveal it put together. him. I'll do that at the end of the day. Because there's people that are watching that other trial, and I want them to be a part of it because they helped make this possible. So I want to let them come on over. So Brenda says, agreed. I liked her in the beginning. I think she should be concentrating on this trial, not doing other things. Yeah. We all appreciate you, Mel. So glad that you're with us. Julie, do we know how old he was? Possible onset of schizophrenia? He's young. He's like 20. How old is he? He was born in El Salvador. He entered the U.S. as an unaccompanied minor in 2009. Grew up in Oakland, California. He graduated from Castlemount High School in 2020. So if you're 18 when you graduate, he's probably born in 2022. So he's 23-ish. Oh, 21. Aaron has him as 21. Two counts of first degree and one count of attempted. You're welcome, Mel. And thank you for being a part of our community. And again, it's people like you, Mel, that make our community what it is. So we appreciate you. Thank you. All right, we're into we've passed hour 2 full hours. Capri, isn't onset commonly around 21? We watched, what was that Ollie one we watched out of Colorado, right? What was his name? You guys remember that one? Well, I don't know if you do remember that one or not. Alyssa, right? I think that was him. Yeah. He was young too, and he saw things. And Chloe Driver, how old was she? She was like early 20s. That fits the exact age bracket for males. Yeah. Crumbly Judge was also McMumbles. All right, I'm going to get up and stretch my legs for a bit. I'll be back in a few.
Zimbabwe, Nangala kushore Zimbabwe, Nangala kushore Zimbabwe, Nangala kushore Zimbabwe.
All right, I'm back, just checking in. Come on, chair's fighting back. So we are 2.5 hours in now. They started at 12:45. Here we are at 3:15. All timings are approximate. Only kidding. All times are East Coast. And we're waiting. So we had a poll up. How long will the jury take to deliberate? 0 to 2 hours. 12% of you said 0 to 2 hours. So we're past 2 hours. So don't vote on 0 to 2 anymore. We're now into the 2 to 4 hour range. 30% of you thought 2 to 4. I think that's where I landed too. And Angela, how are you? Thank you for coming on in and saying hello. Hope you're doing well today. Yeah, nothing involving a jury is an exact science, Ken. Yeah. No. Hey Mel, where is it? Where in your back is it? Upper, lower, middle, all of the above? And if you've said that already, I apologize, I missed that. But what part of your back? Ooh, ouch, Ruby, you have a slipped disc? You need back surgery? Ouch. Angela, doing well? Hope you are well as... Yep, we are. We're doing good. Doing pretty good. We found a new trial to watch. It started today, so we're going to pick up on that tomorrow while we're in verdict watch here. And then also we did a... unboxing of Slim Pickens this morning, and Aaron put Slim together, so I'm going to pull that over after towards the end of this towards the end of today. I'll do the unveiling of Slim put together. Sorry, that was me. I have no... What's in here? Okay, yeah. So this, these are the charges. Second degree. Then he also has voluntary manslaughter as well. They included that. The state wanted to include that. So Schurr is charged with second degree, defined as a deletion caused by an act of the defendant with malice. Act causing the death is without justification or excuse. Schurr's defense is arguing he was justified through self-defense, punishable by up to life in prison if found guilty. Let's see what else we can pull up here. Oh, you have 2 cracked vertebrae? Ouch. Sorry to hear that, Mel. Ooh, that sounds painful. Short life, yeah. Actually, Katya, when she was in this morning, she asked if we were going to cover. It's the it's out of California. Carlos Dominguez. He stabbed 3 people, and 2 of them passed away. It happened near Davis, UC Davis, which I believe is up by what do you call it? San Francisco, right? Is that, where is it? Let's see. Yeah, it's way, it's up near San Francisco. So that started today, so we're gonna pick up on that as we're in verdict watch here. So hey, Trial Junkies, welcome back. Thank you for coming back. Yeah, it's really it's an interesting case. He's pleading guilty by reason of insanity. So it's kind of like a. Do you remember Chloe Driver? It's kind of like that, where they're admitting it, but they're he's insane, and he truly sounds like it from the backstory that I read. So we'll pick up on that one tomorrow. All right, let's see. Let's look at some things here while the jury deliberates. So this is what we're dealing with the jury. Now they let two people go, right? So you've got a Hispanic male in his 20s, a pharmacy technician. You've got a Hispanic female in her 20s. She's a stay-at-home mom. You've got a biracial black female in her 30s. She's a nurse. You've got a white female in her 30s who's also a nurse. So those two are probably kibitzing. Then you've got a white female in her 20s. She's a warehouse worker. You've got a white male in his 20s. He's a janitor. Then you have a white female in her 20s. She's also a nurse. Right there, you've got three nurses. Oh, you know what they said? They said when they let juror number 1 and 2 go, and they said it would be you two, and I think it might be this white male and white female. I think those are the two that they let go, you guys. So that's a physician's assistant. He's a white male in his 30s, and a white female bank teller. She's in her 60s to 70s. You have a Hispanic female in her 40s. She's a municipal employee. Then you have a white male salesperson in his 30s to 40s. You have another white female in her 40s. She's an IT director. You have a white female in her 30s. She's a business owner. And then you have a white female in her 50s and 60s. She's a graphic designer. So when I remember the judge said, "We'll let you go," I remember she said, she was pointing to her left in the front row, so number 1 and 2. So I think it's that male and female, 30s and 60s. That's what I'm thinking. I think it was those two. Trial junkies, you've been lurking? Fair? Fair enough. Let's see, what else can we pull up? So here's what this is what they're deliberating. So Schurr definitely has the taser, but Patrick is absolutely grabbing onto it. Yeah, I mean, he just doesn't want to get tased. I get that. Nobody wants to get tased. So here he's just falling to the ground. So here's where it gets murky for me. So that's his left hand, and then he switches over to his right hand? I didn't quite get that. So this is what they're not arguing about, but this is what they're trying to deliberate about. Deadly force applications. Officer may discharge a firearm in connection with the performance of their official police duties. Defend against a reasonable threat, seriously bodily injury to himself or herself. Defend against a reasonable threat of serious bodily injury to another officer or citizen. Prevent the escape of a subject who is fleeing from inherently violent felony crime. So that's not this case. When the officer has probable cause to believe that the subject poses a reasonable threat of deletion or seriously bodily injury to the officers or others. So it seems like it would be number one, right? A1. He felt that it would be a reasonable threat or serious bodily injury. So. Mel, you have a problem with the element of malice. So, second degree, deletion caused by an act of the defendant with malice. My problem is he was trained to do this. That's my problem. Probably will be. Ken, how large of a period do you want to look at? In most cases, in most self-defense cases, one side wants to look at a greater length of time and the other wants to narrow it down. Yeah, you said that. I remember you said that at the beginning. The state wanted, right? I think you were saying the state wants to. Which way would that go? The state wants to narrow this down, or the defense wants to? I'm sorry, slow it down. Let's see. The state wants to slow it down. The defense wants to speed it up because they kept saying split second decisions, right? Oh, here we go. The defense, like we expected, really tried to narrow it down to the exact moment. Right. And they wanted to speed it up also, that this all happened in 2.5 minutes. He had split-second decisions to make. Here, the prosecution wants to expand the picture to include as much as possible. Mel asks, can we judge someone for doing what they're trained to do? That's the tough one, Mel. That is the tough one. That is the... That's why I was saying earlier, I think we need changes at a legislative level, policy level. I mean, we're training officers to do this, and then people get upset when they do it, and it's like rightfully or wrongfully, it's what they're trained to do. They're trained to shoot at center mass. They're trained to, if somebody's a threat, they're trained to take them out. So I don't know. That's at the heart of this issue. Well, the heart of it is really, was he in fear for his life? But then to me, it's, yeah, he's trained to do this. Ken, yeah, it's sort of backwards, giving it's the state prosecuting a police officer. Totally. Green-eyed cat, and with power comes great responsibility. Absolutely. I still struggle with the choices Schurr made that led to this outcome. Traffic stops shouldn't lead to anyone's end. 100% agree. 100% agree. Yep. That's part of the struggle as well. You know. Meaning, you know, we played that game this entire trial. You know, woulda, shoulda, coulda, if then, if only. You know, if only Patrick hadn't done this, if only Schurr hadn't done that. You know, it stinks. It absolutely stinks. But. Here we are. Ken says, and Becker kind of came back to that in his rebuttal, saying it's not reasonable at that moment for an officer to think a taser could cause serious bodily injury or deletion. So do you think he was conceding a little bit there? Ken, it sounds like Becker is saying it's not unreasonable then. Let me read through that again. I don't have that in my notes, but I trust you. I have more like, you know, he didn't call law enforcement because they weren't going to be impartial. And they talked about, it was his bias. I thought his rebuttal was more about bias, but I don't recall that specifically. See, they're coming up on 3 hours here. Let's see, Ken. Oh, you're talking about the self-defense claim specifically. Not about bringing in officers to testify on what they think. Gotcha. Talking about self-defense claim. Okay, yeah. So that, yeah. No, that I understand. That I got. Green-eyed cat, for sure. If they had been struggling over a gun, I would probably have a different view. Yeah, I mean, then for sure, it is what it is, right? Mel, in my opinion, this case is similar to the armed forces training people to defeat the enemy, then penalizing a soldier for taking 5 enemy lives. Ken, because self-defense still has to be reasonable. Schurr says it was reasonable to fear imminent serious bodily harm. Becker says it's not, and therefore unjustified deadly force in self-defense. See, now that's where I have, right? I guess that's where I have an issue of like, so Schurr is saying that he thought one thing, he felt one thing, but then here's this other person saying, no, what you felt or what you were thinking was not true or in reality, right? I'd be like, well, how can you tell me what I was thinking? Like, how can you tell me what I was thinking at a particular moment? We're coming up on the 3-hour mark here, guys. Right? So then isn't that just right there, reasonable doubt? You can't tell me what I was thinking, so how am I supposed to be a judge on that? Or a jury, How can I judge you for what you were thinking? So that's called the reasonable person standard generally. It's subjective and objective. So it's both subjective and objective at the same time. All right, thinking or feeling. Ken, so the person has to actually be in fear and imminent serious bodily harm, and it has to be the fear that is reasonable. It's an adoption from a civil standard for negligence. So the person actually has to actually be in fear of, well, I think he was. I think he was in imminent serious, excuse me, oh, sorry. I think he was in fear of imminently serious bodily harm. I think that. And it has to be a fear that is reasonable. All right, we're almost at well, they're saying at 12:41, that's when they start deliberate. I have 12:45. Here we are at 3:42. How can one thing be two opposite things at once? Subjective and objective. I'll let Ken handle that one. So a person has to actually be in fear, and that fear has to be reasonable. Right? You can't just be unreasonably in fear of, like, I'm afraid of. So is that irrational fear as well? That's true. All's fair in love and war. That definitely is different. Ken says, let's say trial TV bot attacks me with a pool noodle and I shoot it because it terrifies me and it deletes. That's subjective, actual belief. Silly example, but go with it. It's not a reasonable fear. Okay. But what if you grew up and you have this irrational fear of pool noodles? What if you were tied down as a young child and pummeled with pool noodles? Would that then you have a irrational fear? Or is that irrational? Or is that rational? Because I guess it would be irrational, but it comes from a place of getting pummeled by pool noodles when you were, 5 years old. Hey, Mona, I always think I understand reasonable doubt until I listen to closing arguments and jury instructions. I know, right? Ken, think of it like a tool for the jury to filter out the fake or manufactured self-defense claims. I can understand that. But what if we heard your irrational fear, and is it really truly is it irrational? Like, what if as a child X happened to you and now you have that fear as an adult? That leads into a doctrine called imperfect self-defense. Green-eyed, so he couldn't be afraid of spiders in the ground or something? All right, we're officially going into hour 3. Mel says, phobias may be irrational to some, but for those who suffer from them, they're not irrational. Yeah, totally agree. Specifically, just anything. People have fear of snakes, spiders. Hey Mona says, Ken, good facts and bad facts also throw me into confusion because facts. Well, here's the next question is, how long are they going to go for, I wonder? How long they're going to go for. Ken says, typically an imperfect self-defense claim means I had an honest but unreasonable fear that typically mitigates down to a lesser offense like manslaughter. So typically an imperfect self-defense claim means I had an honest but unreasonable fear. All right. That typically mitigates down to a lesser offense. But not all states do that. Phobias are feared that cannot be controlled. So like debilitating, like you can't control a phobia to the point of like it just debilitates you. Right? Because that changes the defendant's mental state or mens rea. Ken says, you didn't know we were going to law school today, did ya? And we appreciate it, Ken. Just wait till Ken gives you his bill. Just wait till you get a bill from Ken. Professor Rosenberg's bill. Mel says, I estimated incorrectly. Deliberations have already gone longer than your guess. Therapist says, I would argue with the can't be controlled verbiage. It can be controlled if one decides to. Baka, gather round, listen up. Gather round, y'all. Always happy to learn. Yes, completely debilitating. I'm going to agree with therapist on that one because I have a fear of snakes, but I deal with them when I see them. like when I've had to. I certainly don't want one as a pet, and I don't want to snuggle up to one. And if I see one, I'm like, yeah, no. But if one's, in the yard and I have to relocate it, I do. So I overcome my fear of snakes. So I will agree with therapists in that regard that I will control them. But when I see them, my initial reaction is like, hey, Ken says the law sort of recognizes that if you have irrational fears or things like that, that you're supposed to kind of deal with that yourself. If apples make you homicidal, the law isn't going to bend over backwards for you. Go to therapy or something. Is it a fear or a phobia? I guess a fear. I don't know. What's a phobia? What specifically then is a phobia? Let me see. What's the difference between a fear and a phobia? Difference between a fear and phobia. Fear is a natural, rational response to perceived danger, while a phobia is an intense, irrational, often debilitating fear of a specific object or situation that is out of proportion to the actual threat. So that's the difference between a fear and a phobia. Fear is a natural human emotion that helps individuals react to perceived or real threats, while a phobia is an excessive and irrational fear that significantly impacts daily life. Phobias can lead to avoidance behaviors and intense anxiety, even in the absence of perceived threat. All right, then I'd certainly have a fear of them. I think I also have a phobia because it's irrational, because I know snakes are very beneficial to the environment. Or it's like the water, right? You don't want to go swimming in the water because you're afraid you're going to get eaten by sharks, right? I mean, is that a fear? Is that a phobia? Therapist, fear, nervous when you see a wasp near you. Phobia, refusing to go outside in spring because there might be a wasp. Fear, a natural adaptive emotional response to a real or perceived threat. Can be rational or proportional, that is, fear of a growling dog, fear before a big exam, usually temporary and manageable. May prompt protective behavior, that is, moving away from danger, preparing for a challenge. Yes, thank you, Professor Rosenberg. We appreciate it. Phobia is a type of anxiety disorder involving intense, irrational, and persistent fear of a specific object, situation, or activity. The fear is out of proportion to the actual danger. Yep, green-eyed cat. Run away! Leads to avoidance behavior that interferes with daily functioning, not going to work because there's a dog on the route, causes significant distress even when the person knows the fear is irrational. All right. Mel, you also have a fear of snakes, but I don't have a phobia of snakes. All right, I guess I don't have a phobia. Fear is up front, phobia is back of mind. Well, it debilitates you, it seems like, right? It seems like a phobia will debilitate you. Causes distress even when the person knows the fear is irrational. Yeah, I don't like I don't go out into nature because I know there's snakes out there. Like, I don't like, I'm not going to go into the woods, or I'm not going to go get the mail because I know I saw a snake, yesterday, or it's going to come flying out of the sky at me, or the trees. All right, so I'll just say I have a fear then. I guess I do not have a phobia. Agoraphobia is the intense and uncontrollable fear of open spaces. And yes, we always appreciate your insights, therapist, definitely. Ken says, I don't think I've spent a day in chat where I haven't learned something new. I would agree to that. We aim to expand our horizons here, Ken. It's always fun. It's always fun to drop some knowledge, expand our our knowledge here. Always appreciate that amongst our chat. Mel says, people are prisoners of their phobias but are aware of their fears. Therapist, I have a total irrational fear, almost phobia. Y'all will totally make fun of me. No, he won't, and can totally use it against me later. Only fan Ken Rosenberg. So I'm going to trust you a lot here. Lizards. All kinds of lizards or just certain kinds of lizards? Baka, my legs won't let me walk across anything I can see through. My legs buckle even though I say go. Hey, Care Bear, good to see you. Only have one thought to toss in about juries. Okay, please do. Brad, I get panic attacks from dentists, but I can medicate it. So fear or phobia? Huh. Well, if you're getting a panic attack, doesn't that mean that's a phobia? Elizabeth G, I always try to remember that the snake is more afraid of me than I am of him. Yep. Yeah, that helps. Absolutely. That absolutely helps. Hey, you guys. Fala. Yay. Fala. Yes. You heard your name. So it's all lizards, huh? All right. Brad, 8-Ball, is a fear of pie irrational? Are you joking? What was it? May the 4th be with you. I'm the 5th. Revenge of the 5th. I'm more of a fan of Revenge of the 5th. So all lizards give you shivers, huh? Yeah, I'm okay with lizards. I'm okay with anything, to be quite honest. How was the doctor? Oh, Dr. Fala. I remember, of course, I was a kid. My dad took me to go see Jaws, right? And it was of course, it was a summer movie, summer blockbuster. I think it was 75 it came out. And we went to Myrtle Beach that year. And my dad did not go into the water, and my mom was so mad at him because he's like, I'm not going to become fish food. And so I've always been freaked out by sharks, right? Traumatized at an early age. So there was this one time I was in my 20s, and we went on a family vacation, and I was really petrified of getting eaten by a shark, right? Because we were going to South Carolina Beach. And I was going through this whole meditation moment in my life, and I was just like, what's the worst thing that could happen? And so I just went through the process of, well, you get bitten, right? That's going to be painful for sure. Then you either survive or you don't, and if you don't survive, you die, right? So that's literally the worst thing that could happen to you. And I just kind of let myself sink into that and go into that, and sure enough, I felt really good going into the water, because I'm like, you know what? The worst thing that can happen to me is I get eaten by a shark. Is that really the end of the world? Yeah, it's the end of my world, but I don't know, for some reason that exercise just helped me get through that fear of going swimming, because I'm like, I didn't want to not go swimming, but I just allowed myself to go that route and see what happens. And I addressed it, and I think I got over it. All right, Care Bear, I could never be a juror in a case like this, but if I were a foreperson, I would start out, we are not deciding this on color. Imagine both are see-through, deciding on actions only. Yeah, I mean, they're not supposed to. I mean, that's those are instructions. I don't know if they judge didn't say that implicitly, but I think that's pretty much the tone of this. Child Junkies United. Objection is not okay if a shark eats you. It would make Aaron cry. And what about Super Ball? Yes. Well, admittedly, this was before I knew them. This was before I knew them. But yes, I certainly do not want to get eaten by a shark now. Fala, long story short, brakes aren't healed but are healed as much as expected. Can start walking on flat surfaces without boot. Everywhere else boot. Swelling will happen for about 6 months. Ooh. Wow. 6 months? Jeez. Wow. Can, but then Super Ball would get the chair. That's true. OnlyFan, I think the trial has been stellar, not making color an issue at all. I would agree on that as well. Physical therapy, exercise, very slow healing process, Fala says. Insert blowing raspberry gif here. Aw. Wow, you had to turn on the AC, Baca, in Minnesota? That went from like 0 to winter to summer in 2 days. So the jury started to deliberate at 12:45, and right now it is 4 o'clock. So we're going into the 3-hour mark. 3-hour mark. All right, so it was voluntary manslaughter. All right, so I heard it right, and then she said involuntary. Oh no, they wrote that wrong. So my source wrote that wrong. It's voluntary. I had that right to correct with. Follow black snake across the driveway when I left. Him, friend, not foe. Yep, they keep copperheads away. Wow, he was probably eating froggies. Yep. That's a good question, Missy. I wonder how long they're going to go today. We don't know. They usually go to like 4:45. That's what they usually go to. So we'll see. We'll see. Maybe they'll come back at 4:45. And say they want to go more. I don't know. But yeah, usually they have been going to 4:45-ish. Yeah, 13th juror, still no questions or anything. Yep, nothing. Nanar, I was Instacart grocery shopping and they should be here in 5 minutes. Okay, cool. Yep. We did find a new case that we're going to start for you guys tomorrow. It started today. We'll pick up on it tomorrow. It's a case out of California. So while we are on jury watch, we will watch a new trial. Mel says to Baca, "Ooh, wow, wrists and hands have so many bones." Oh, yeah, for sure. Ruby, it was beautiful and sunny here this morning. I came out of my first apartment and it was cloudy and lightning. Wow. Came out of my appointment. Wait a minute. Oh, came out of my second appointment in a downpour. Wow. Missy, nope, no snakes here. I only had to deal with little gardener. Yep. Gardener snakes, yes. Is it gardener? Garter snakes. Gardener snakes. Yes, that's what I grew up with too. What are they called? Are they garter or gardener? What are they called? They all call it, they're garter. Garter snakes. So they're garter snakes. Yep, I grew up with them too. My grandparents had rattlesnakes though. I never really saw them, but they did have rattlesnakes. Yes, garter snakes. Missy, I could be wrong with how you spelled them. Yeah, you had a rattlesnake in my area, but I never came across one. I was hiking once. I lived in Woodstock. Well, no, this was before I lived there. I would go hiking a lot because from New York City up to New Paltz was only like, it's like 70 miles, 70, 80 miles. So I would go hiking up there, and I went hiking in the springtime. And I was walking with my friend, and we heard like this, and I looked the path that we were on, and the path was only like, maybe like this width of your shoulders, maybe a little bit more. And there was, the size of my arm laying across the path was this rattlesnake, and we were like, whoa. And we backed up very, very quickly, quietly. And I swear to God, to this day, I swear to God, that thing started to come at us. And it was like maybe 15 feet away, 20 feet away. Yeah, it's probably like 20 feet away. And we started to back up, and I swear to God, that thing was coming towards us. I was like, yeah, no, let's get out of here. Green snake, I always called them garden snakes. Yeah, therapist, yeah, I'm sure you have a billion of them. Ken, garter snakes you can generally roll with. They're cool. We have a lot of like black snakes, rat snakes. There's this really cool looking one. It's pretty big. Like everything down here is big, but this thing's probably at least 3 feet. And maybe about as thick as, maybe as thick as 3 fingers, something like that. And they're kind of brownish, dark brown, light brown stripes. And I had to relocate him because he was by this nest. We have a propane tank, right? And there was a nest of birds up there, and this snake was going up there, so I had to relocate him. And I have this long pole. I just kind of picked him up and ushered him out of the yard. Hey, Selena, how are you? Selena-ka. Everybody's got the Mel, plenty of garter snakes where I live, but no other nasty types of these reptiles. Therapist, we were talking about scorpions, right? Don't you have scorpions by you? Supposedly they're in Florida, but I've never run. We had a friend, Aaron and I have a friend who said he's dealt with scorpions in Florida, but I've never seen a scorpion here. I never thought there were armadillos. And I found out there's armadillos. There were armadillos in our backyard. There still are. They come and go. I thought that was scorpions and armadillos. I thought are like Texas and New Mexico, Arizona. I don't think I've ever seen a live scorpion in the wild. I've never seen a tarantula either in the wild. I don't think so. No scorpions here either? Yeah, that's good. Selena, how long is the jury going to stay tonight? We don't know. They didn't say. We have no idea. They usually stay till like 4:45. That's when they've usually been being let go. So you're married to a scorpion? Nice. Hey, Mona. Ken, scorpions are a big absolute effing knot. Right? Therapist, I've lived in Texas my whole life, and I've never seen a real alive armadillo. When we moved here, there were holes in the ground, and we're like, what the heck is this? And we called our pest people, and they said, yep, got armadillos. So they trapped them. They trapped 3. They caught 3, literally mama, papa, and baby. It seemed like there were 3 different sizes. So I got up, I got pictures of them. Oh, you know what? Let me see. And then I saw one the other day, well, maybe a couple weeks ago I saw one. It was like sunrise, and it was kind of just, oh, and then we saw one last year too at night. So I've seen a couple. I've definitely seen them. Let me see if I can find, let's see. When did we move here? 2023. Let's see. Oh, wait, let's see. What's this? We moved in 2022. I gotta remember when we moved here. All right, hold on. And there's a meteor shower tonight too, guys. If you look up, I should probably be paying attention. Make sure there's a meteor shower tonight. If you're up around right before sunrise, look out the window. You got a meteor shower happening. It's from the Halley's Comet, so that'll be something fun to watch if you're up late. Let's see here. Trying to find the. Oh, here we go. All right, here's some. Is this a good one? All right. I think I can do this without causing all hell from breaking loose. All right. All right. All right, here, check this out. Therapist, you know, this was after, let's see. We moved here. All right. Sorry, guys. All right, so this is what they trapped. There's a little armadillo. So they got 3 of them. No, I'm not showing you a lizard. Hey, Dwayne, how are you? Good to see you. Thank you for joining us, Dwayne. Always good to see you. So no, that was one of 3 armadillos that they captured. So I think that was the baby. Well, there was 3 of them. There was literally like I think it was mom, dad, and little baby. So that's one of them. And I've seen them. Okay, so those were trapped. Then there was one time, it was at kind of nighttime, and we saw Super Ball was growling. So we saw that one. All we did was just open the curtain, and we saw that one kind of running around. And then maybe a month or 2 ago, I woke up and the sun was just coming up, and I saw a little guy, armadillo, running around. They chew up your yard. It's not too bad. Some nights sometimes it's better than others. Sometimes they just dig a hole or 2, and other times they'll dig like 10 holes. But yeah, they go for grubs. So that's our little armadillo. Well, it's not an emotional support animal anyway. Hey, Dwayne, good to see you. Hope you are doing well, my friend. We're in verdict watch, Dwayne. If you didn't know. Oh, and we also got the skeleton. Dwayne, were you part of that? The dog park murder trial? Were you part of that naming of skeleton? I forget if you were or not. So for all those that were a part of naming the skeleton from the dog park shooting, we did an unveiling earlier today, and Aaron put it together, and I can show you, let's see. This was Rafa helping. So that was Rafa helping put him together. Skunks dug up your tulips. Oh, I saw a little turtle the other day. Guy was like a little turtle cruising across the lawn. We don't have skunks, thank God. Oh, there was an alligator, of course. You know, we do live in Florida, so every body of water has alligators. Hola, no, he was called Slim Pickens. We, yeah, Bon Jovi. Aaron is truly Wonder Woman, Irish Amy. I agree with that. Yes, Rafa has been busy, Irish Amy. Yep. Little Rafa Bean. Hola, yes, he's a good looker, good helper. Again, shout out to producer extraordinaire. Yeah, we're on a fairly busy street, right? And somebody got out of the car and picked something up and put it into the ditch right across the street. So I had to go look, right? So I went over and I did take pictures. I don't know if I could find that, but there was an alligator. So somebody must have hit it, and then that person moved it out to the side. Father Squeegee accidentally puts Aaron on screen, and now we have two skeletons. No. Yeah, we came up with 16 names, and we had a round robin. We broke them down into 4, so we had 4 rounds of 4, and we took the best, and it ended up being well, here, let me see, what were the final, let's see. What was his name again? I was just there too. Shoot, what was his name? Gerald Radford, right? Gerald Radford. All right, so let's see. All right, so round 1 was Jack Skeleton, Jack, Herbert, and Simon. Then round 2, let's see, and Jack Skeleton won that one. Then round 2 was Jeeves, Mr. Bones, Jr., and Creepy. Jeeves won that one. Then round 3 was Bon Jovi, Skelly, Sarah Bone, and Gerald. And Bon Jovi won that one. And then round 4 was Slim Pickens, Frankenspine, Marilyn, like marrow, bone marrow, Marilyn Monroe, and Skeleton McSkeleton. that one just makes me laugh. And then Slim Pickens won that one. So the final was Slim Pickens, Bon Jovi, Jeeves, and Jack Skeleton, and Slim Pickens won 46%. So for those that remember that trial, that was the name the skeleton trial. Dwayne, no, I didn't see the dog park trial, but I got a notification last night that I haven't watched. Yes, yeah, we did that this morning, Dwayne. We did a unboxing of the skeleton, and then whenever this trial ends for today, I'll do Aaron put it together. Aaron put Mr. Pickens together, and I'll bring him in after we're finished here. No Bob. Hey, Mona. No Bob. I just read them. No Bob. Yep. No Bob, no Ralph. No. Yeah. Bon Jovi is pretty funny. Perfect shallow grave on your street. There was a ditch. We have like ditches. We have ditches. Yeah, they are. Yeah, this alligator was pretty big from what I remember. Let me see. I know I took a picture of it. Let me see if I can find it relatively quickly. Let's see. I felt bad for the dude. I mean, right? Oh, deer. Yeah, then there was the deer that was in our backyard that got trapped. I eventually got him out. Yeah, we've had interesting what do you call it? Interesting escapades since we've been here. We've had hawks. Yeah, we had these really cool red-tailed hawks, but they've kind of gone away a little bit, only because of the cats. But I did see them the other day. We have a lot of wildlife. Oh, here, I might as well send you this. I'll show you this. Yeah, here, okay. All right, I'm going to show you guys this. All right, so this was one of the snakes that we had this mango tree. All right, here, check this out. This thing was crawling up into our mango tree. All right, so there, it just kind of gives you an idea of, I had to relocate this guy. So that was probably, let's see. Yeah, he was probably that thick, maybe three fingers, at least 2 fingers, maybe 3 fingers. This is the one I was telling you about that we had a propane tank just kind of out of, well, maybe 20 feet out of camera there, and there was some birds there, a nest, and this snake was going there, so I had to relocate that snake. So, yep. And then there's another picture. He actually crawled up. That mango tree is probably up to my waist. He crawled up into that mango tree. So I was like, yep, nope, you need to go. You need to go. So, oh, sorry, Try Junkies. Sorry, look away. All right, so that's that. I had to relocate. I had to relocate that guy. To which I did. No harm, no foul. Everything was cool. Uh-oh. All right, you guys know how I love animals, right? All right, we're we're gonna get real silly now. All right, you guys know how I love animals. I'm a big proponent of animals. All right. This is really funny. All right, so check this out. Guess who this is? Guess who that is? I guess you can. Yes. I like my little hat. I love that hat. That's just so silly. But I've always loved animals, as you can see. So I'm trying to find this alligator. I'm not. Let's see what else. Oh, here he is. All right. You really can't tell from this perspective how big or small he is. But okay, so here's... And we're trying to figure out where this thing came from. Because yes, we do live next to a lake. Well, we're about a mile from a lake. But this thing was crossing... and it was... Yeah, it's didn't make sense. All right, so hold on. So this is, you can't really tell how big or small this is. But let's see. Wow, this picture is huge. Hang with me. Sorry guys to do this to you. All right, so there's the alligator. So again, you can't tell from that picture how big he is, but he was pretty big. I mean, he's not like, 10 feet, but he was probably, at least 3 feet. I'd say he was at least 3 feet. And unfortunately, a car hit him or a truck hit him or something. So yeah, so that's a little taste of some wildlife that we have out here. Poor little guy. We do not, Brenda. We used to, but we do not anymore. In Nanar, somewhere I've seen a picture of your husband when he was little in a hat just like that. I guess that was the thing back then. Capri Law. No, that's not Aaron. Well, it was dead, Lacey, so I had to go see what the person, because the person got out of the car and they picked this thing up and I didn't quite see what it was. So I had to go and see what the heck it was, yeah. Hey, Jamie, I don't think I'd let my cats outside with giant snakes and alligators in that area. Well, cats can beat snakes. We've seen those videos. Cats can destroy snakes in the blink of an eye. Alligators, well, yeah, we have fencing all around. I'm more concerned with like dogs. There's a bobcat, but there's only so much we can do, Trial Junkies United, Lake Placid, great movie with the gator. Yeah, I remember that movie. That was a good one. Anything south of like North Carolina, you're going to have, if there's a pond, lake, river, there's going to be an alligator in it. That's what I've found. That's what I've discovered in my travels. Anything South Carolina, Georgia, Alabama, you're going to have a gator. Baca, there are lots of those quick little ones. Oh, little lizards? Yeah. Yes. Oh, Capri, you just realized you were way behind? Okay. Yep, I'm good with deers and bears, Missy says. We have deer. We definitely have deer. Yep. Dwayne remembers Lake Placid. That was a good one. Fala, I had a girl on her back road get out to move a turtle out of the road. I got out and yelled, "Don't," just before said turtle about bit her fingers off. Oh, literally, it was a snapper. Yeah. I'd like a cat, but I'm scared of the gifts that they bring you. All right, I don't know how late they're going to go. We have no idea. This judge did not tell us anything. Ken, sometimes you see a rat. Yeah, well, when I lived in the city, when I lived in New York City, that's what we would see. I would see rats. I literally had a rat like come at me one time. I was coming home from practice or something, and it's like 11, 12 o'clock, and I'm walking on the sidewalk, and this rat looked at me, and I literally swear to God, this thing started to come at me, and it was like huge. That rat was huge, and I was like, yeah, no, I wasn't going to mess with that thing. So I scuttled to the other side of the street. Yes, Mel, Lake Placid is the name of a horror movie. It's about this gigantic alligator in Lake Placid, which is in New York. It's in this lake, and this thing is like ridiculous, like 40 feet big, 40 feet long or something like that. Jamie, my cat is content to stay inside. Urban predators here and sick alley cats. Yeah, got to keep them in, for sure. In Venice, beautiful Venice, there are rats everywhere. Well, because the water, right? I was in Venice and never saw a rat, but I was only there for like a day and a half, 2 days. Wasn't really looking. Ken, we started getting more crows back in recent years, and that's actually pretty cool. Ken, I like crows. I know they bother lots of people. They're noisy. They are definitely noisy. They will let you know that they are there. No verdict yet, Kathy. No verdict. Let's see. Jamie says she got deadly sick once in the vet street cat before I got home. I transferred germs to her. Oh, that's sad. Wait, I want to pull this one up. Trial Junkies United. Objection. I don't call it a horror movie. Oh, okay, they scare me. This one has Betty White. Oh my gosh, Betty White is in it? Oh, I forgot about that. What would you call it then? What is it? It's like Jaws then, I guess, or any of those Sharknado or whatever. What would you call it? If it's not a horror movie, what would you call it? It's like a Monsters Gone Wild. Crows are ridiculously smart. I have heard that as well. Oops, wait. Mel says your water rats are big enough to pay rent, though they don't, of course. They're gonna be a no from me, dog. Oh, Elizabeth, yeah, we know Pompano. Grandfather lived in Pompano Beach. A canal ran through his neighborhood next to his backyard. He had a gator climb out of the canal onto his yard. Scary. Oh, creature feature, yes. Irish Amy could be a creature feature. Yeah, Elizabeth, we know Pompano very well. We actually lived in Pompano Beach for a little bit, but inland probably 2 or 3 miles. But then we lived, we know Pompano Beach. Aaron knows Pompano Beach very well as well. Oh, crazy wildlife movie? Nice. Kathy, I used to live in a river town and the wharf rats were the size of possums. Wow. Yeah. Yeah, rats are definitely a no from me. But they live in trees too. I remember we would see rats in trees. Don't ask me how they got up there, but somehow they got up there. All right, Joror. So they started their deliberations at 12:45. Here we are coming up on 4:45. If you haven't already taken our poll, please do so. Just don't. Just be aware that it was 0 to 2, 2 to 4, 4 to 6, and 6 to 8. So don't answer 0 to 2 because we're past that already. And then tomorrow, if we don't have a verdict today, tomorrow I'll do a hung because they very well may be hung. Lacey, I'd be more scared of the crazy people that live in Florida than the animals. Are you calling us crazy, Lacey? Comedy horror genre? Yeah, I guess it could be. Well, like Piranha. You guys remember Piranha growing up? That was a good one. Anaconda. That was another one. That was in the 90s, I think. Mel says, Ken, I absolutely love crows. They are very intelligent creatures. On Vancouver Island, we have white ravens. Cool. Not albino, but white. Interesting. Capri says, my uncle is a white river rafter guide and is known as the Crow Man. They wait for him and talk to him even. It's crazy. That's pretty cool. Ken, your last apartment building, there was a dude who had trained a crow to meet him for a cigarette. Wow. That's funny. Not exactly sure it was the same crow every time, but the dude did something in academia with animals and knew a lot about crows. So I'll just go ahead and trust him. What was the one with the white gorillas? I don't know. Not a Planet of the Apes kind of thing, I'm thinking, right? Yes, Jamie, Florida man, yes. Yes, well, there's 25 million of us crazies down here. Or something like that. Last time I checked, we were about 25 million. All right. Keeping my eye on the Twitters and on the website. Nothing. Dwayne, you remember Piranha? Yeah, that was a good flick. Oh, the Blob, right? The Blob, that was a good one. Yeah, I know it's not Planet of the Apes. I don't know. I don't remember a white gorilla one. Oh, Shaun of the Dead. That's a good one. I like that one. Now that definitely would be comedy horror for sure, right? I'd put that in comedy horror because that is tongue firmly planted in cheek. Absolutely. Elizabeth says there were little geckos running all over the place when we would go out and about. Us grandkids never wanted to have to stop at stoplights in town. There's this one place, actually, we're speaking of Pompano, there's a place that one of the street corners where there's just a ton of iguanas, like a ton. I mean like 100 iguanas. It's just out of control. Oh my goodness. Really? You don't like iguanas? Do you like iguanas? No. Okay. She does not like... Tremors! Yes, Tremors was a good one. You thought a white gorilla was a Yeti? Interesting. Kevin Bacon was in Tremors, right? Wasn't he in Tremors? Therapist you know lives in Monsterland. That's true. Brenda, you come to Florida every July and August. Can I ask you why you come to Florida in July and August when it's like the most hottest, humidest time of the year? Just asking. Just wondering. Oh, and hurricanes. Just wondering. Jamie, yes, funny zombie flick. Shaun of the Dead was... I enjoyed Shaun of the Dead. That was a good one. Kathy, does jury know they can go home after verdict? Who knows what they know, what they don't know. Nan R, I had a cat visit me by hanging on window screen. He finally broke through and spent most of the time in my house. Brought me a bird. I screamed and he never came back. Oh, wow. Dwayne, yes, I loved the Blob. I remember a time before color TV. Me too. Dwayne, I had black and white up until I think I was like 13 or 14. All my friends had like cable, and I still had like a black and white TV. Reba McEntire was in Tremors, was she? Jeez, wow. Hellcat, you'll be here next week. Well, it's not. No, now is nice. It's July, August, September is when it's hot, humid, and hurricane season. So. Your son is stationed in Mary Esther. I don't know where Mary Esther is. Let me look that up. Where's Mary Esther? Never even heard of Mary Esther. Mary Esther, Florida. All right. Where is Mary Esther? Fort Walton Beach. Oh, so you're up in the Panhandle. You're Pensacola area, Destin. All right, I gotcha. We had a couple hurricanes slam up there recently. more by the Big Bend, I guess. We had Debbie, Adalia. Yeah. So, just saying, I understand you're coming to visit, and you know, your son knows if he lives here, he knows. He knows the dangers of hurricane season. My family was going to have a reunion in September 1st, on the coast of Georgia. I'm like, you guys do realize that's like the peak of hurricane season? And they're like, yeah, we'll be okay, we'll be okay. We're like, you guys don't know. Yeah, Air Force Base near Fort Walton. Nice. Werewolves in London? Yeah, that's a good one. I like that one. Lacey, they've been finishing around 4:45. That's usually, yeah, it's been 4:45. That's when they've been stopping. So, I would, and I think we're still a half hour delayed. I haven't seen anything where they've taken that off. So I think they may still be a half hour delayed. Brenda, you love the hot weather and the ocean, plus that's when hubby gets his vacation. Fair enough. Yeah, that's true. If you're on the ocean, then the humidity is not that big of a deal. That is true. I thoroughly 100% agree with that. If you're on the ocean and you have AC, then you're good. Misery scared you, Lacey? That was a good one. Any Stephen King. Stephen King's great. Kathy, those old scary shows were not blood and gore, but gave you nightmares? Absolutely. Yeah, Alfred Hitchcock is one of my favorite directors of all time. Angela, how long have they been deliberating? We have that pinned to the top of our comments, Angela, but I will tell you they started at 12:45. So we have that pinned to the top of our comments. So they have been deliberating for 4 hours now. Coming up on 4 hours. Yes, Irish Amy, we did see Lori's motion thingy for a new trial. I wonder how likely it is to work. We were talking with Joe over the weekend, and he covered it. Joe Schmo was talking about that. If you guys want to go check him out, Joe was covering it. Yeah, it has to do with Juror 15, of course, talking afterwards, saying what he said. So, Angela, bless you. You don't have to apologize. The poll is at the top of yours. Yeah, you have the poll and then you have it underneath. Well, wait. For me, I just have Verdict Watch. I don't have the poll anymore. I think once you take the poll, it should go away. It should go away. Trial Junkies United. Reba was awesome in Tremors. She played a survivalist along with her husband, played by Michael Gross. Oh, yeah, Family Ties. Yep. Michael J. Fox's dad. I got to watch that again. Gosh, I haven't watched Tremors in such a long time. Okay. You saw Joe's coverage too? All right. Yeah, cool. It wasn't scary to you? You're talking about Stephen King, right? It with well, they did two. He did two. They did two versions of it. You had to dismiss the poll after taking it. Interesting. Shirley Roth, listening to the chat while I'm watching a horror movie about a Dibbit box. A Dibbit box. That sounds familiar. Oh, wow. So they've gone offline there. They may have gone home or something. My feed just put up the live view, which means they've gone offline. Let's see here. Yeah, that feed has gone offline. Let's see if we can find another. All right, I gotta pay attention here for a moment. So the feed that I was following has gone offline. You guys can see it says live view. Yeah, we're going to see if they're going to go past. I want to show you Slim Pickens too. I want to do that once they officially go home for the night. I don't want to be showing Slim Pickens and then right in the middle of it they come back. Let's see, Double Indemnity from 1944. Barbara Stanwyck, yep. Fred McMurray, yeah, it was based on Ruth Schneider. I did a live stream on her. Yes, we were watching that. We watched that. Trial Junkies, we watched that. We watched your stream of that. Lacey, Katya found a trial. She asked if we were going to cover a trial. I said I never heard of it before, and then we just looked it up, and it started today out in California. It is... Carlos Dominguez. He stabbed 3 people and 2 of them passed away. So that's going to be our next trial that we're going to pick up tomorrow. We'll pick up on tomorrow. We'll do a dual stream like we did with Lori and Monica. We'll do this camera. I'll be doing the new trial, and then the computer over there will do verdict watch. So we will be dual streaming tomorrow, so be kind to our mods. They're going to be pulling double duty. All right, we are officially at 4 hours. They started at 12:45, and here we are at 4:46. All right, 22 seconds ago, I'm told that they've wrapped up for the day. Hold on. Where did that go? Why did that go? Why did that go away? Told the jury is wrapped up for the day per attorney on the case. Deliberations are set to resume at 8:30 Tuesday. All right, so it seems like they've wrapped up for the day, you guys. Seems like they have wrapped up for the day. That's coming from a local news station who's in the courtroom. So it seems like they have stopped for the day. Yep, court closes for the day at 4:45. All right, so they have officially ended for today. 4:45, they have ended. All right, so we have 4 hours. So they're coming back at 8:30. 8:30, they're coming back tomorrow, guys. I don't know if it's going to be a 30-minute delay or not. So they have officially ended. I'm going to end this poll. Hold on a sec. Let me end this poll. All right, so we have officially ended for the day. Now don't go anywhere because I'm going to show you Slim Pickens. So 113 votes. Good job on that. Appreciate that, guys. 113 votes. How long will the jury take to deliberate? And we ended up at 4 hours. We're at 4 hours right now. So 30% of you said 2 to 4 hours. 30% said 4 to 6 hours. 28% of you said 6 to 8 hours, and 10% of you said 0 to 2 hours. All right, I can get rid of this now. I don't need that anymore. All right, so are we ready for Slim Pickens? Let me show you Slim Pickens. Let's see. All right, hold on. Let me show you Slim Pickens. Aaron put together Slim Pickens. All right, are you guys ready? Here comes Slim Pickens. There he is. How do you do? All right, so he's heavy. Here we go. So while I'm out having lunch, anyway, trying to get him to cooperate. So there you go. There's Slim Pickens. Here's Super Ball. What do you think? What do you think about that? So there's Slim Pickens. There he is. So Aaron put him together. Let's see. It's pretty heavy. Something like that. We'll sort it out. All right, so there you go. Slim Pickens. Super Ball is not thrilled, yes. So there you go. Pretty funny. Let's see. That was the unboxing this morning. We did the unboxing. Super Ball. She doesn't seem too freaked out. I thought she'd be more freaked out about it. She's definitely checking him out. Oh, it's a good girl. Oh my goodness. Yeah, I know. Hi. I know. Do you like Slim Pickens? Do you like Slim Pickens? Are you a fan of Slim Pickens? Are you gonna go say hello to Slim Pickens? You wanna go say hi? Go say hi to Slim Pickens. Nope, she's not. I don't think she's a fan of Slim. All right, guys. On that note, you can say goodnight. Go say goodnight. Say goodnight. Say goodnight, Gracie. All right, guys. Thank you for joining us. All right. So the deal is we're going to pick up on that Dominguez what's his name? I gotta get this guy's name down. Dominguez. Okay, so tomorrow we're going to pick up on Carlos Dominguez. Started today. It's out in California, so we'll pick up on that tomorrow. Day one tomorrow, we'll do verdict watch. So this will be Dominguez here, and then over here we'll do verdict watch. And that starts at 8:30. I don't know if they're going to be a half-hour delayed, but we'll be ready at 8:30. Yeah, so thank you for joining us. Have a great one. Thank you guys for your support. Thank you to Aaron. Thank you to Aaron for putting together Slim there. I like the way he's sitting. I like this. How you doing? Oh, absolutely silliness here. Silliness. All right, guys. Have a great night. Thank you, Aaron. Thank you to our mods. Thank you to Therapist for shipping that. Thank you to Pammy and Sinbad for also helping in shipping of that. Thank you to Aaron for putting together Slim. And we'll see you guys tomorrow. Well, you have to admit we do have fun here, right? If one thing is, we definitely have fun here. I should do like my best Joey. How you doing? All right. See you guys tomorrow. Same bat time, same bat channel, all that good stuff. I got to take a screenshot of that and send it to, hold on. All right, hold on. That's really funny. All right, guys. Have a good night. We'll see you tomorrow. Oh, don't forget Halley's Comet. The debris from Halley's Comet is happening tonight. So don't forget to look up right before, sunrise. So tonight, if you're out, if you're doing something 4:30, 5 o'clock, just look up and you should see some good meteors. Slim looks judgmental. He's judging me. I can tell, right? He's judging me. Nanar. Slim's judging me. All right, guys. We'll see you tomorrow. Have a good night. Thanks, guys. Bye.